ಇಲ್ಲ ಇವತ್ತು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. My lords.
Number 19 to 23. Page 3, 24 to 37.
Two weeks. Senior conciliation. 2 weeks. 4 bundles.
Page number 38 to 46. Page 5, 47 to 58. Page 6, 59 to 60.
Number 62, madam.
My lords, serial number 61, my lords.
My lord, serial number 58.
ಒಬ್ರು ಹೇಳಿದ್ರೆ ಹೇಳ್ತೀನಿ ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲಿ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ 62 2 weeks
61, my lords.
2 weeks
58, my lord.
yes ಕರಿ ಬರ್ತೀನಿ ಸೊ ವೇಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ನೀವು
60, please. To produce the counter complaint. Week step.
ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಅಷ್ಟೇ ಹೇಳಿ ನೀವ್ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ ನಿಮ್ಗೆ ಕೇಳಲಿಲ್ಲ
Week step.
2 weeks
Can I request week step?
2 weeks 2 weeks ಈಗ ಹೇಳಿ
61, my lords.
My lord.
61 ಹೇಳಿ
At 61, kindly have done Tuesday, my lords. I will engage the senior counsel, my lords. The senior counsel is the
ಕುದುರೆ ಅಂತ ಹೇಳಿ ಕೊಡಕ್ ಆಗಲ್ಲ ಅವ್ರಿಗೆ
Tuesday next are 80 date, my lords.
21st
Please, my lords.
Serial number 58, my lord.
ಹೇಳಿ
2 weeks time may be granted to furnish the charge sheet, my lord.
2 weeks
Much obliged.
7, 69 to 77.
My lord, serial number 69, my lord. In this case, I am for the petitioner. Kindly have done 1 week time may be given.
2 weeks
Okay.
Page number 8, 78 to 83.
My lord, I am appear for petitioner. ಈ ಕೇಸಲ್ಲಿ ನಾನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಪೋಸ್ ಮಾಡ್ತೀನಿ ಮೈ ಲಾರ್ಡ್, ಯಾಕಂದ್ರೆ ಬಿ ವಿ ಆಚಾರ್ಯ ಅವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದೀವಿ ಮೈ ಲಾರ್ಡ್ ಈ ಕೇಸಲ್ಲಿ. ಸೊ ಹಾಗಾಗಿ ಇದನ್ನ ಇವತ್ತು my lord,
one is for not for impleading sir, I2 is for impleading ಮತ್ತೆ he cannot be impleaded. The most he can be permitted to assist the prosecution.
ನಾವು ಇದ್ರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ತೀವಿ ಮೈ ಲಾರ್ಡ್. ಪ್ಲೀಸ್ ಅದರಲ್ಲಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಿ ವಿ ಆಚಾರ್ಯ ಅವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದೀವಿ ಮೈ ಲಾರ್ಡ್.
ಬಂದಾಗ ಹೇಳಿ
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
70 ಹೋಯ್ತು ಹೋಗಿಲ್ರಿ ನೀವು ನಾ ಬರೇ ಮುಂದೆ ಹೋಗಿ ಆಮೇಲೆ ಮತ್ತೆ ರಿಜಿಸ್ಟರ್ ಬರ್ಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಬಂದಾಗ ಹೇಳಿ ಅಕಾಮಡೇಟ್ ಮಾಡ್ತೀವಿ. The office objections regarding the offenses and one name does not survive as it is mentioned in the prayer column in the petition itself. Hence, office objections are overruled. SPP is directed to take notice for respondent state which the matter or objections next Friday. Next Friday.
Serial number 4. Play for 1 week.
438 ಇದ್ದಿದ್ದು 2 weeks ಕೊಡಿ. 439 ಇದ್ದಿದ್ದು 1 week ಕೊಡಿ. ಏನ್ ಮಾಡ್ಬೇಕು? ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅರ್ಜೆನ್ಸಿ ತಗೊಂಡು ನಾನೇನ್ ಮಾಡ್ಲಿ? ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿ ಆಮ್ಯಾಗ ಅರ್ಜೆನ್ಸಿ ಬರುತ್ತೆ. ನೀವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡೋಲ್ಲ ಮತ್ತೆ ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ? Sir, certified copy of the bail, rejection of the bail order is to be furnished. That is not furnished. Xerox copy, it is there. Xerox copy to be attested. ನೋಡಿ, ಟ್ರಾನ್ಸಿಟ್ ಬಿಲ್ ಸಿಕ್ಕಂಡ್ರೆ ರಿಜೆಕ್ಷನ್ ಆಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ನೀವು ಅದಲ್ಲ, ಆಮೇಲೆ ಮುಂದಿನ ಬರುತ್ತೆ. You are moving a bail application, but you don't want to produce the certified copy of the bail order, and you don't want to comply, but you express urgency. Comply ಮಾಡಿ. ನಾನು ಹೇಳಿದ್ದೆ 439 ಇದ್ದಿದ್ದು ಎಲ್ಲ 1 week, 438 ಕೆಳಗೆ ಇದ್ದಿದ್ದು 2 weeks. ಅರ್ಜೆನ್ಸಿ, ನಿಮಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಕೋರ್ಟಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ. ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಕೋರ್ಟ್ನವ್ರ ಜವಾಬ್ದಾರಿ ಆಗ್ತಾರೆ. ಮಾಡಿ ಸರ್, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ ಮ್ಯಾಗ ಮೂವ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಂದಿಲ್ಲ, ಇನ್ನ ಬಂದಿಲ್ಲ ಸರ್. ಎಲ್ಲ 1 week.
ನಂಬರ್ 14 ಸರ್, 439 ಇದೆ. ಹೇಳಿದ್ದಾರೆ ಸರ್, 2 months ಟೈಪ್ ಕಾಪಿ ಆಗ್ಬೇಕು. ನಾಳೆನೇ ಫಿನಿಶ್ ಮಾಡ್ತೀನಿ ಸರ್.
ನಾನು ಟೈಮ್ ಕೊಡೋದು 1 week ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. ನೀವು ನಾಳೆ ಹಾಕಿರಿ ನಾಡ್ದು ಹಾಕ್ಲಿ, ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ಟೈಮ್. ಐ ಗ್ರಾಂಟಿಂಗ್ ಯು 1 week. ನಿಮಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾಗ ನೀವು ತಲೆ ಕೆಡಿಸ್ಕೋದಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಲ್ದ ಪೆಟಿಷನ್ ಹಾಕ್ತೀರಾ, ಆಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ಕೊಡಿ, ನಾಳೆ ಮಾಡ್ತೀನಿ ಇಮಿಡಿಯೇಟ್ ನಾಳೆ ಇಡ್ರಿ ಅಂತ. ಸೊ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
Serial number 18, 2 days. That my colleague was
1 week finally. All the 3.
Serial number 19, my lord. Serial number 19, my lord.
1
ಸರ್, ಒಂದ್ ಸ್ವಲ್ಪ ಆದ್ರೂ ವೇಟ್ ಮಾಡಕ್ಕೆ ಪೇಷನ್ಸ್ ಇಲ್ಲಲ್ಲ ನಿಮಗೆ.
Serial number 19, my lord.
19 ಹೇಳಿ.
19, my lord. There is urgency, my lord. Kindly.
ಅರ್ಜೆನ್ಸಿ ಇರುತ್ತೆ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದು ಬೇಡವಾ?
Yes, my lord.
ಇಲ್ಲಿವರೆಗೆ ಅಲ್ಲ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದು ಬೇಡವಾ ಅಂತೀರಾ? ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿ.
No, 2 times police entered my house.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಾಕ ಸಫಿಶಿಯಂಟ್ ಟೈಮ್ ತಗೋತೀರಿ, ಅವಾಗ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ. ಆದ್ರೆ ನೀವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆದ್ಮೇಲೆ ಅರ್ಜೆನ್ಸಿ ಬರುತ್ತೆ, ಅಲ್ಲಿವರೆಗೆ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ. ಸಾರಿ ಸರ್, ನೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಎಷ್ಟ್ ದಿನ ತಗೊಂಡಿದ್ರಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ? ಎಷ್ಟ್ ದಿನ ತಗೊಂಡಿದ್ರಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ? More than
My
1
lord,
month ಕೊಟ್ಟಿದ್ದೀರಿ. ಅವಾಗ ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
I have filed a memo, my lord, last time only. My
Makes
lord.
for
Only I have
objection.
medical.
SCGP
My lord.
is directed to take notice for respondent state. ನೀವು ಒಬ್ಬರೇ ಇದ್ದೀರಲ್ಲ?
Yes, my lord.
2 weeks. $439 ಇದ್ದಿದ್ದೆಲ್ಲ 1 week ಕೊಡಿ. 439 ಇದ್ದಿದ್ದು 1 week, 438 ಇದ್ದಿದ್ದು 2 weeks.
Next 21 next week.
Next week 1 week date ಕೊಡಲ್ಲ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ 1 week ಕೊಟ್ಟಿದ್ದೀನಿ. 1 week means next Thursday normally.
28
Next week means next Thursday ಬರುತ್ತೆ.
ಮತ್ತು find it serial number 24.
ಅವ್ರು ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತಾರೆ ನೋಡೋಣ.
ಒಂದು 24 ಒಂದು ಇಲ್ಲ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಿದೆ. ಅದು ಇಂಟ್ರಿಮ್ ಬೇಲ್ ಅಂತ
ನೋಡಿ ಏನ್ ಹೇಳ್ತೀನಿ ಮಧ್ಯ ಆಮೇಲೆ ಮಧ್ಯದಾಗ ಹೇಳಿ.
230 ಗ್ರೇಟ್.
For the petitions, my lord. Whatever you submit, next time it goes not on.
ಎಲ್ಲಿ
What is the page number? 21 to 27. Of allegations are made against 1 to 10 with no difference, exactly same set of allegations. Complainant is the not eyewitness. And Munindra and Venkatesh Reddy is said to be the eyewitnesses. Who stated overtax about 1 to 10. Those are same set of allegations, my lord, with no difference, exact my lord. Shall I proceed? Read the statement of Munindra, my lord.
CW
At page number, my lord. 153, my lord. Page number 153.
yes yes
ನಾನು ಮೆಕ್ಯಾನಿಕ್ ಕೆಲಸದಿಂದ ಚಿಕ್ಕರಾಗಡ್ಡ ಗ್ರಾಮದಲ್ಲಿ ನನ್ನ ಕುಟುಂಬದೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ದಿನಾಂಕ 25/11/2021 ಬೆಳಗ್ಗೆ ಸುಮಾರು 6:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ನಮ್ಮ ಮನೆಯ ಬಳಿ ಇದ್ದಾಗ ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಬಳಿ ಗಲಾಟೆಯಾಗುತ್ತಿರುವ ವಿಚಾರ ತಿಳಿಯಿತು. ಆಗ ನಾನು ಏನು ಗಲಾಟೆ ನೋಡೋಣವೆಂದು ಅಲ್ಲಿಗೆ ಬಂದು ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 6:45 ಗಂಟೆಗೆ ಬಂದು ನೋಡಲಾಗಿ ಹುಸೇನ್ಪುರ ಗ್ರಾಮದ ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಅವರ ತೋಟದ ಬಳಿ ಜಟ್ಟೋಜಿರಾವ್, ಶ್ರೀನಿವಾಸ್ ರಾವ್ ಮತ್ತು ಕೃಷ್ಣೋಜಿರಾವ್, ನವೀನ್ ಕುಮಾರ್, ಮಂಜುನಾಥ್, ಗಂಗೋಜಿರಾವ್, ಜಟ್ಟೋಜಿರಾವ್, ಬಿನ್ ಕೃಷ್ಣೋಜಿರಾವ್, ನಾಗರಾಜ, ಅಶೋಕ ಹಾಗೂ ಲೋಕೇಶ್ ಅವರುಗಳು ಹೊಡೆಯುತ್ತಿದ್ದರು. ಹಾಗೂ ಅಲ್ಲಿದ್ದ ಅಶ್ವಥ್ ರಾವ್ ಅವರ ಕಾರನ್ನು ಹೊಡೆದು ಜಖಂಗೊಳಿಸಿ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿದ್ದ ಹಳ್ಳದೊಳಕ್ಕೆ ತಳ್ಳಿದ್ದರು. ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ನೋಡಲಾಗಿ ಅವರ ಮುಖಕ್ಕೆ ಗಾಯಗಳಾಗಿದ್ದು, ಕಿವಿ, ಮೂಗು, ಬಾಯಿಯಲ್ಲಿ ಮತ್ತು ಕಣ್ಣುಗಳಿಂದ ರಕ್ತ ಬರುತ್ತಿತ್ತು. ಕೈಕಾಲುಗಳೆಲ್ಲ ತರಚಿದ ಗಾಯಗಳಾಗಿದ್ದವು. ಈ ಗಲಾಟೆ ಬಗ್ಗೆ ವಿಚಾರ ಮಾಡಲಾಗಿ ತಿಳಿದು ಬಂದಿದ್ದೇನೆಂದರೆ ಹುಸೇನ್ಪುರದ ಅಶ್ವಥ್ ರಾವ್ ಅವರ ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಬಳಿ ಇರುವ ಅವರ ತೋಟದಲ್ಲಿ ಟೊಮೊಟೊ ಬೆಳೆಯನ್ನು ಇಟ್ಟಿದ್ದು, ಆ ಬೆಳೆಯ ರಕ್ಷಣೆಯ ಸಲುವಾಗಿ ತೋಟದ ಸುತ್ತಲೂ ಕಂಬಿಯನ್ನು ಸುತ್ತಿ ಕಾನೂನಿನ ಅರಿವಿಲ್ಲದೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಲ್ಪಿಸಿದ್ದರು. ದಿನಾಂಕ 24/11/2021 ರಾತ್ರಿ ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ವಸಂತರಾವ್ ಎಂಬುವರು ಅವರ ತೋಟದೊಳಗೆ ಹೋಗಿದ್ದಾಗ ವಿದ್ಯುತ್ ಸಂಪರ್ಕದಿಂದ ಮೃತಪಟ್ಟಿದ್ದರ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಶ್ವಥ್ ರಾವ್ ಅವರ ತೋಟದ ಬಳಿಗೆ ಬಂದಾಗ ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಗಳಾದ ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ಗ್ರಾಮದೊಳಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿನ ಮೋಟಪ್ಪರವರ ಅಂಗಡಿಯ ಮುಂಭಾಗದಲ್ಲಿ ಗುಂಪು ಸೇರಿಕೊಂಡು ಹೊಡೆದಿದ್ದಲ್ಲದೆ ನಂತರ ಅಲ್ಲಿಂದ ಪುನಃ ಪಂಪ್ ಹೌಸ್ ಬಳಿಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ಅಲ್ಲಿ ಜೊನ್ನೆಗಳು ಮತ್ತು ಕಲ್ಲುಗಳಿಂದ ಹೊಡೆದರೆಂದು ತಿಳಿಯಿತು. This so-called eyewitness stated as if he is the hearsay witness ತಿಳಿಯಿತು. ಅದೇ ಸಮಯಕ್ಕೆ ವಿಷಯವನ್ನು ತಿಳಿದುಕೊಂಡು ಅಶ್ವಥ್ ರಾವ್ ಅವರ ಪತ್ನಿ ಮಂಜುಳಾಬಾಯಿ ಮತ್ತು ಅವರ ಮಗ ಮತ್ತು ರೋಗೇಶ್ ಮತ್ತಿತರರು ಒಂದು ಗಾಯಗೊಂಡಿದ್ದ ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ಯಾರಿಗೆ ಹೊಡೆದರೆಂಬ ವಿಚಾರ ಮಾಡಲಾಗಿ ಚರಕಮಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಗಳಾದ ಜಟ್ಟೋಜಿರಾವ್, ಅಪ್ಪಯ್ಯ ಆಲಿಯಾಸ್ ಅಪ್ಪಯ್ಯ, ಇವರ ತಮ್ಮನಾದ ಶ್ರೀನಿವಾಸ್ ರಾವ್ ಆಲಿಯಾಸ್ ಮೋಟು, ಗಂಗೋಜಿರಾವ್, ಮಂಜುನಾಥ ಎಂಬುವರು ಊರಿನೊಳಗೆ ಎಳೆದುಕೊಂಡು ಹೋಗಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ ಊರಿನಲ್ಲಿದ್ದ ಸುಬ್ರಹ್ಮಣ್ಯರಾವ್, ಕೃಷ್ಣೋಜಿರಾವ್, ನವೀನ, ಮಂಜುನಾಥ, ನಾಗ ಆಲಿಯಾಸ್ ನಾಗರಾಜ, ಅಶೋಕ ಮತ್ತು ಲೋಕೇಶ್ ಅವರು ಮೋಟಪ್ಪರವರ ಅಂಗಡಿಯ ಮುಂಭಾಗದಲ್ಲಿ ಕೈಗಳಿಂದ ಹೊಡೆದು ಕೆಳಗೆ ಬೀಳಿಸಿ ಕಾಲುಗಳನ್ನು ಹಿಡಿದುಕೊಂಡು ಎಳೆದಾಡಿ ನಂತರ ಅವರೆಲ್ಲರೂ ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ಪುನಃ ತೋಟದ ಬಳಿಗೆ ಎಳೆದುಕೊಂಡು ಬಂದು ಶೆಡ್ಡಿನ ಮುಂಭಾಗದ ರಸ್ತೆಯಲ್ಲಿ ಬೀಳಿಸಿ ಜಟ್ಟೋಜಿರಾವ್, ಶ್ರೀನಿವಾಸ್ ರಾವ್, ಕೃಷ್ಣೋಜಿರಾವ್, ನವೀನ್ ಕುಮಾರ್, ಮಂಜುನಾಥ್, ಗಂಗೋಜಿರಾವ್ ಅವರುಗಳು ಬಳಿ ಇದ್ದ ದೊಣ್ಣೆಗಳಿಂದ ಮತ್ತು ಕಲ್ಲಿನಿಂದ ಅಶ್ವಥ್ ರಾವ್ ಅವರನ್ನು ಹೊಡೆದು ನಂತರ ಎಲ್ಲಾ ಆರೋಪಿಗಳು ಶೆಡ್ಡುಗಳಿಗೆ ನಿಲ್ಲಿಸಿದ್ದ ಅಶ್ವಥ್ ರಾವ್ ಉಪಯೋಗಿಸಿದ್ದ ಮಾರುತಿ 800 ಕಾರ್ ನಂಬರ್ ಅನ್ನು ಸಹ ಹೊಡೆದು ಜಖಂಗೊಳಿಸಿ ಹಳ್ಳದೊಳಕ್ಕೆ ತಳ್ಳಿದರೆಂದು ತಿಳಿಯಿತು. The same version is deposed by the another eyewitness, my lord Venkatesh Reddy. There is no specific or specific overtrack made against this particular accused, my lord. All the 6 accused A5 to A10, my lord, who filed the different bail petitions are considered and allowed by the Honorable Court, my lord. Petitioners have been in judicial custody for almost last 10 months, man.
Yes. Are you seeking ground of parity?
That is one of the grounds, my lord.
Ground of parity, because the charge sheet allegations specifically disclose specific overtract against you. Accused number 1 assaulted by stone on the head, that is the vital part, and accused number 2 pierced through his eyes by a club. That was the major allegation, which has ultimately death is internal bleeding. PM report discloses very specific overtract is major overtracts are alleged against accused number 1 and 2. And these orders also disclose that other accused only vague allegations regarding assault made, damage to the vehicle and other things.
My lord.
But as regards both these accused, there is specific oath act.
My lordship, only 2 eyewitnesses. That is.
See, we cannot say that there are only 2 eyewitnesses. Their evidence is to be assessed during the course of the trial. At the juncture, this is too early to assess the evidence of eyewitnesses.
My lord, absolutely, it is not a mini trial. But
Yes.
that is acceptable.
Really?
My lord,
management-
kindly see, investigation is completed. The facts that to be considered at this stage, my lord, investigation is completed. Who are the permanent residents of the address given in the charge sheet, my lord? These petitioners have been in judicial custody for last 10 months, more than 10 months, my lordship. Apart from that, my lordship, when they come to the prima facie nature of the evidence, my lord, only 2 eyewitnesses, my lord. They have not stated, they have stated made allegations, overtax in respect of the 10 accused, same set of allegations, with no difference, my lordship. Exactly. They have assembled and bet the 10 accused, including one juvenile, my lord. Assembled and bet the deceased Ashwath Rao, my lord. So, basing on that, my lord, among these grounds, I am also seeking on parity ground, my lord.
Yes.
Investigation is completed, my lord. The question of tampering the prosecution witnesses doesn't arise, my lord.
Yes.
They are cooperate with the trial, my lord. They will ready to abide by any conditions that may be imposed by this honorable court in the event of petitioner enlarged on bail, my lord.
Yes. Two 209 page ಇಲ್ಲ ಇಲ್ಲಿ. Kishore Rao, son of late Keshav Rao, dated 22/1. That is page number 143. Yes. Yes.
In file submission with respect of the recovery, my lord. Recovery is only from the recovery of the stick is only from the accused petitioner number 1, my lordship, at page number 85, my lordship. But no recovery is made from the instance of the petition number 2 here in my lordship. And as alleged by the as stated by the eyewitnesses, my lord, all accused said to have bet the deceased, my lordship. So, when thus being the case on record, my lord, it can't be ruled out at this time that said injuries are said to have been caused only by the.
What is your explanation regarding blood stains found on your body?
remaining all was void, my lordship.
What
Even
is
five-
your explanation regarding blood stains found on your body?
Maybe for different reasons, my lord, petitioner might have been present at the scene of offence, my lord. Considering the same, my lordship, why you cannot or enlarge than bail, my lordship. Their blood stains class were also, my lordship, recovered, said to have been recovered, my lord, in the course of investigation. Despite of that, 5 to 6, 5 to 10 are enlarged than bail, my lordship. There is no recovery from the petition number 2, my lord.
This petition is filed under section 839 of CRPC, seeking regular bail to petitioners bar accused number 192 in crime number 231 of 21 of Manchinali Police Station, Chikballapur, registered for the offences punishment section 427 and 302, read with section 34 of the IPC. The brief factual matters leading to the case is that the wife of the deceased lodged a complaint wherein it is alleged that accused number, wherein it is evident that the allegations were made, were leveled against accused number 1 to 4, that there was a quarrel between them and deceased with regard to plucking up the tomato. It is further asserted that when the husband, on the date of the incident, when the husband of the complainant went near the land to protect the tomato in the early morning at 6:45 a.m., the accused number 1 to 4 said to have assaulted the husband of complainant, and when the same was brought to the notice of complainant, she went along with her son and found injured husband. He had sustained injuries on his face, and on inquiry, it is revealed that all the accused assaulted her husband and damaged to the car. In this regard, she lodged the complaint. On the basis of the complaint, the investigating officer has undertaken the investigation and apprehended the petitioners. The material objects were also recovered, including bloodstained shirts, cloths from the present petitioners and other accused. And the investigating officer found that there is sufficient material evidence as against the present petitioners and other accused, and hence he submitted the charge sheet. Next, the petitioners have approached the learned session judge seeking a regular bail, and the same came to be rejected. Hence, the petitioners are before this court. Third, the arguments advanced by the learned counsel for petitioner and learned HCGP. There is the records. The learned counsel for petitioner would contend that a omnibus allegations have been made against all the accused, and the other accused have been already granted bail by this court, by coordinate bench of this court in criminal petition number 4125, 4128, 4414, and hence the petitioners who are standing on the same footing are also entitled for bail. He would also contend that the investigation is concluded and charge sheet has been laid down, and there is no chance of, there is no chance of question of tampering the prosecution witnesses. We would also undertake to abide by the terms and conditions to be imposed by this court. Per contra, the learned SCGP seriously object the bail petition on the ground that CW 2 to 5 are the eyewitnesses and bloodstains clause of petitioners were recovered, and wooden club used for assault is also recovered at the instance of the present petitioner. Hence, he would contend that there is active participation of the petitioners in commission of the offense, and hence he would seek for rejection of the bail petition. Having heard the arguments and perusing the reports, the charge sheet has been submitted as against 10 accused. The present petitioners are accused number 1 and 2. All along, the learned counsel for petitioner would contend that the other accused have been released as a general or common allegations have been made regarding assault on the deceased by stone and clubs, and there is no specific individual act referred. However, on perusal of the charge sheet, it is evident that all the accused dragged the deceased, and the present petitioner number 1, accused number 1, assaulted by stone on the forehead of the deceased, causing fatal injuries, and then caused damage to the vehicle of the deceased. Further, it is also alleged that the petitioner number 2, that is present accused number 2, has assaulted by club on the chest of the deceased and also assaulted on his right eye, which has resulted in fatal injuries. The wound certificate, the postmortem report made available disclosed that the petitioner, the deceased, has suffered head injury as well as injury to his right eyebrow. The PM report disclosed that the death is due to internal bleeding. The main contention of the learned counsel for petitioner is that the other accused have been granted bail, and on the ground of parity also he is seeking the bail. But while considering the bail petition pertaining to other accused as referred above, the court has considered the individual acts as referred in the charge sheet, and it is asserted that there was no specific court act alleged against those accused involved in those criminal petitions. But in the present case, as against the present petitioners, there are specific allegations regarding active participation and specific court act. Hence, the ground of parity cannot be made out as against the present petitioners. Further, it is also important to note that the wooden club is recovered at the instance of the petitioner, and bloodstains cloths are also recovered. There is no explanation regarding bloodstains found on the body of on the cloths of the petitioners. Looking to these facts and circumstances, this is not a fit case wherein the discretion can be exercised in favor of the present petitioners merely because the petitioners are in custody for 10 months and the investigation is concluded is not a ground for admitting the petitioners on bail, as there is every possibility of their tampering the eyewitnesses during the course of the trial. Hence, petition being devoid of any merits does not survive for consideration, and accordingly it stands rejected.
Fine submission.
Yes.
Trial court may kindly be pleased to direct it to conduct the trial as expeditiously as possible. Petitioners have been
in the meanwhile, since the petitioners are in custody, the trial court is directed to proceed with the trial as expeditiously as possible.
Charge has been filed. We withdraw the petition. We withdraw the petition.
You withdraw the petition. The learned counsel for petitioner submit that since the final report has been submitted, he doesn't want to proceed with this petition and he may be permitted to move fresh petition. The submission is placed on record. The petition is dismissed as withdrawn. He is at liberty to move fresh petition before the appropriate court if he is so advised.
The name is not forthcoming either in the complaint or the FIR. However, notice has been issued to him, calling him as accused.
ನಿನ್ನಿದಲ್ವಾ? ಎದಕ್ಕೆ ಇಟ್ಟಿದೀಯ? Something I have directed.
One has power of attorney holder.
You are a power of attorney holder, no doubt. Your contention is that the executant are responsible. Executant of the power of attorney is your wife. She executed power of attorney in your favor. You in turn let out the premises to somebody else who has used it as a brothel home.
But regarding that sublease aspect, Lord, I have taken today's time. Kindly see, Lord, at page number 40.
ಅಲ್ಲ ಇದೇನ ಇಲ್ಲ ಕಂಡೀಷನ್ ಅಂತ ಇಷ್ಟೇ ಕೇಳಿದ್ ನಾನು.
ಅಲ್ಲಿ sublease ಆಗಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Subletting, how did you sublet it?
But it is not subletted.
Then what do you mean by leave and license?
But in the leave and license, Lord, permission was given. However, no tenancy rights were created.
Absolutely, tenancy rights cannot be created. You are a tenant. You are subletting it without creating tenancy on the ground of leave and license.
Therefore, my Lord, two clauses I'll just read for the time.
That is not, we are not, because I am not supposed to give any finding on proper subletting or not, because this is not the forum. But just I wanted to ascertain it in general.
It was specifically instructed that it should be used only for this purpose and not for any other purpose. Therefore, it was made clear, Lord. And the partnership concern, Lord, has given, Lord. Therefore, the
Partnership has concerned, has given you power of attorney. Partnership concern did not direct you to give it to a particular person who runs a brothel home.
The only grievance is the police are not going against the partnership concern, Lord. They are going after the power of attorney.
When you have executed power, when you are a power of attorney holder, when you are controlling the entire business of the partnership firm, you want that want to get the power of attorney. You want to enjoy the power of the partnership firm, but when it comes to the reverse, you say that it is responsibility of the partnership firm. You are no way concerned. How you cannot write two horses simultaneously, sir.
What are the instructions, Lord?
Whatever it is. No, no, sir. You are not entitled for anticipatory bail.
Cooperate in all the ways.
Cooperate ಮಾಡಿ surrender ಆಗಿ
Conditions you may be in.
condition surrender condition.
Because there are no
Anticipatory bail ಕೊಡ್ತಾ ಇಲ್ಲ.
allegations.
Sir, serious brothel home running. The premises is used for running a brothel. It cannot be looked in such a casual way. And now your argument is that they are not bothered about the partnership firm. When you are there as a power of attorney of the partnership firm, you want to save your skin by putting, then put forward your wife who has executed power of attorney. Your wife has executed power of attorney who is the partner of the firm. You are writing simultaneously, want to write two horses. ನಿಮ್ಮ ಜವಾಬ್ದಾರಿ ಬರಬಹುದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಏನಕ್ಕೆ ಹಾಳಾಗ್ಲಿ ಅಂತಾರೆ, ಆದ್ರೆ ನಿಮ್ ಹೆಂಡತಿ ನಿಮ್ಮ ಅದರ್ ಪಾರ್ಟ್ನರ್ಸ್ ಏನು ತೊಂದರೆ ಆಗ್ಬಾರ್ದು.
Allegations ಇದ್ದಿದ್ರೆ I would not have.
ಸರ್ ಏನೇ ಇರ್ಲಿ, ದಟ್ ಇಸ್ ದ ಡಿಫರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್. ಸರೆಂಡರ್ ಅವ್ರು ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾರೆ ಮಾಡ್ಲಿ, ಕನ್ಸಿಡರ್. Condition is to surrender. Rejection ಮಾಡ್ತಾನೆ.
Liberty may be given.
Withdraw ಮಾಡಿದ್ರೆ liberty. ನಾನು on merits may dismiss ಮಾಡಿದ್ರೆ no question of liberty. Why I should grant a liberty when I am dismissing it on merits? Why I should grant a liberty?
Kindly consider the situation.
ನಾನು ಹೇಳಾಗಿದ್ದೀನಿ.
ನಲ್ಲಿ ಅವ್ರು ಬರೀ ಇಷ್ಟೇ ಹೇಳ್ತಾ ಇದಾರೆ, ಬಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಕೇಳಿ ಹೋಗಿ ಕೊಡಿ. ಅಲ್ಲ ನಿಮ್ಮನ್ನ ನಿಮ್ಯಾಗ ಅಲಿಗೇಷನ್ ಮಾಡಿದಾರ ಅಂತಂದ್ರೆ merely because you have asked to produce relevant documents, produce relevant documents, cooperate. There is no, if you cooperate, there is no need to arrest you.
ಅವ್ರು ನಮ್ಮನ್ನ ಅದ್ರಲ್ಲಿ ಅಕ್ಯೂಸ್ ಅಂತ ಕರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ FIR ಅಲ್ಲಿ ನಮ್ದು ಹೆಸರೇ ಇಲ್ಲ.
FIR ದಲ್ಲಿ ಇರ್ಬೇಕು, ಇದ್ದವ್ರಷ್ಟೇ ಅಕ್ಯೂಸ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? Shall I dismiss it on merits? After arguing the matter for some time, the learned counsel for petitioner submit that he may be permitted to withdraw the petition with a liberty to file fresh petition. After arguing the matter for some time ಅಂತ ತಗೊಂಡಿದ್ದೀನಿ. ಹಂಗ ಗೊತ್ತಾಗತ್ತೆ ಸರ್. The submission is placed on record. The petition is dismissed as withdrawn with a liberty to the petitioner to move fresh bail petition if he is advised to do so. There is no representation on behalf of the petitioner. List of 2 weeks. Why I should not dismiss? ಅಲ್ರಿ ಕಾಪಿ ಕೊಡಲ್ಲ, R2 ನೋಟಿಸ್ ಕೊಡಕ. ಅಲ್ಲಲ್ಲ, ಆ ಲಿಸ್ಟ್ ಆದ್ರೆ ನಿಮ್ಗೆ ಆಫೀಸಲ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇತ್ತ? ಕೊಟ್ಟು ಎಸ್ಟರ್ಡೇ ಇಟ್ ಈಸ್ ಕಂಪ್ಲೈಡ್ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತಲ್ವಾ? The learned counsel for petitioner submit that the needful would be done during the course of the day. Submission is placed on record. Office to verify and then proceed to issue notice to R2 list after 2 weeks.
Under section 439, petition is the accused number 1. There are 4 accused persons. The offense under section 302, 120, heading 34 of IPC. Initially, the complaint is registered against unknown person. The other 3 accused persons have been granted bail by this court.
Yes.
And the accused number 2, madam, who is having similar set of allegation, and there are no eyewitness to the alleged incident. And the prosecution has relayed the circumstantial evidence that last theme along.
You are arguing the bail. You are not arguing on merits of the case. Restrict to bail petition filed by present petitioner accused number 1. You are arguing as if you are arguing the sessions after completion of the sessions. ಅದನ್ನ ನೀವು ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳಿ.
The accused number 2, who is having similar set of allegations granted by this court.
Yes,
he is also entitled bail on the ground of clarity also. Since the complaint itself again a unknown person.
Yes.
During the course of the investigation, this accused arrived, and the date of incident is 6/10/21. After 3 days of the incident, the present petitioner arrested.
Yes.
On the basis of the confessional statement made by the accused number 2, this petitioner has been implicated as an accused. And producing the order copy.
Yes.
The prosecution to link the statement of CW69 recorded. That too, after securing the all the equipments, the statement has been recorded.
Yes.
And considering this, and moreover, the recovery is concerned, the recoveries at the instance of accused number 2 as well as it is a joint recovery. Same things are there. And
Yes.
and everything has been considered and has been granted with the parity is also.
Yes.
All injuries in us were the right side of the right side. Exciting, exciting. How cannot see
Why? The bail order of accused number 3 and 4 may not be relevant for ground of parity. What about accused number 2? The entire case is based on last seen theory that the present petitioner was last seen in the company of accused number 3 and this petitioner. That is the only last seen theory and supported by recovery. But the chain of circumstances are required to be considered. The petitioner has filed this petition and petitioner accused number 1 filed this petition in section 439 of CRPC for granting regular bail in crime number 174 of 21 registered by Jaipura Police Station, Mysore, for the offence is punishable under section 302 120B read to section 34 of the IPC. The brief factual matrix leading to the case are that the complainant, being the brother of the deceased, lodged the complaint by setting the law in motion. However, it is evident that complaint is lodged against unknown persons for the offence under section 302 of the IPC. During course of the investigation, accused number 2 was arrested, and at his instance and on the basis of his confessional statement, the accused number 1, 3, and 4 were also implicated. Next, as per the case of the prosecution, the deceased is said to have deceased is husband of accused number 3, and accused number 4 is the sister of accused number 3. It is also alleged that the accused number 3 was having illicit relationship with accused number 1, the present petitioner, while the accused number 4, that is the sister of the accused number 3, is having illicit relationship with accused number 2. It is further the allegations of the prosecution that the deceased warned the accused to discontinue the alleged illicit relationship, and as such accused 1 to 4 have conspired with each other to eliminate the deceased Nagaraju. It is further alleged that on the intervening night of 6/10/21 and 7/10/21, accused number 4 by coercion secured the deceased at the place of occurrence on the motorbike, and there accused number 1 and 2 assaulted him with deadly weapons, and after having caused his death, thrown the dead body. In this regard, the investigating officer has submitted the charge sheet, heard both the sides and perused the reports. The learned counsel for petitioner would contend that the entire case is based on circumstantial evidence regarding last seen theory, and there are no eyewitnesses. He would further contend that the present petitioner is implicated only at the instance of accused number 2, who is already granted bail. He would further assert that the allegations made against accused number 1 and 2 are similar, and since accused number 2 is granted bail, the present petitioner is also entitled for bail on the ground of parity. Hence, he would seek for admitting the petitioner on regular bail. Next. Per contra, the learned LCGP would seriously object the bail petition, contending that there are material evidence in the form of recovery, and considering these facts and circumstances, he would request for rejection of the bail petition. Next. Having heard the arguments and on perusal of the records, it is evident that the entire case of the prosecution is based on circumstantial evidence. Though CW 6 to 9 are said to be witnesses, but they are not the eyewitnesses, and they are only circumstantial witnesses who have given their 164 statement before the magistrate. Their statement simply disclose that deceased was seen along with accused number 3 and present petitioner accused number 1. And further allegation is regarding recovery of the bloodstains clause and the weapons used for commission of the offense. But merely because there is some alleged to have been some recovery, it cannot be at this juncture. It cannot be come to a conclusion that the petitioners was directly involved in commission of the offense. Apart from that, the petitioner, the accused number 2, was granted bail by this court in criminal petition number 6075/22, and similar allegations were made against him also. Under these circumstances, on the ground of parity, also the petitioner is entitled for bail. The further investigation is concluded and charge sheet has been laid down. The petitioner is in custody for last more than 1 year. Under these circumstances, I do not find any impediment for admitting the petitioner on bail. The other apprehensions raised by the learned public prosecutor and the learned HCGP can be meted out by imposing certain conditions. Hence, petition needs to be allowed, and accordingly, so much.
Petitioners are the accused number 5 and 6. Offenses under section 306, 498 regular petition. Page 15 is the complaint. The mother of the deceased.
Yes.
Mother of the deceased lodged a complaint. The date of marriage not 12 years back.
Yes.
Here, my lord, ನಾನು ಮೈಸೂರು ಗ್ರಾಮ ನನ್ನ ಗಂಡ ಬಸವನಾಯಕ ಮತ್ತು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು 3 ಜನ ಮಕ್ಕಳಿಗೆ 1ನೇ ಜ್ಯೋತಿ 2ನೇ ಭಾಗ್ಯ 3ನೇ ಆನಂದ ಆಗಿರುತ್ತದೆ. 3 ಜನ ಮಕ್ಕಳಿಗೂ ಮದುವೆ ಮಾಡುತ್ತೇವೆ. ಜ್ಯೋತಿ ಮೈಸೂರು ಗಣೇಶ ರಾಘವೇಂದ್ರ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದು ನನ್ನ 2ನೇ ಮಗಳಾದ ಭಾಗ್ಯಗಳನ್ನು ಈಗ 12 ವರ್ಷಗಳಿಂದ ನಂಜನಗೂಡು ತಾಲೂಕು ಉಲ್ಲಹಳ್ಳಿ ಹೋಬಳಿ ಮಹಾದೇವನಗರ ಲೇಟ್ ರಂಗಸ್ವಾಮಿಯವರ ಮಗ ಸೋಮಣ್ಣ ಮದುವೆ ಮಾಡಿದ್ದು ನನ್ನ ಮಗಳಿಗೆ ಮಕ್ಕಳಾಗಿರುವುದಿಲ್ಲ. ನನ್ನ ಮಗಳು ಮದುವೆ ಸ್ವಲ್ಪ ದಿನ ಚೆನ್ನಾಗಿದ್ದಳು. ನಂತರ ನನ್ನ ಅಳಿಯ ನನ್ನ ಮಗಳು 5 ವರ್ಷ ನಮ್ಮ ಊರಿನಲ್ಲಿಯೇ ಹೊಸೂರಿನಲ್ಲಿಯೇ ವಾಸವಾಗಿದೆ. ಆ ನಂತರ 1 ವರ್ಷ ಮೈಸೂರಿನ ಜಯನಗರದಲ್ಲಿದ್ದರು. ನನ್ನ ಮಗಳು ಮತ್ತು ಅಳಿಯ ಮಹಾದೇವನಗರಕ್ಕೆ ಬಂದು ವಾಸವಿದ್ದರು. ನನ್ನ ಅಳಿಯ ಟೈಲರ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದರು. ನನ್ನ ಮಗಳಿಗೆ ನನ್ನ ಅಳಿಯ ಸೋಮಣ್ಣ ನಿನಗೆ ಮಕ್ಕಳಾಗಿವೆ ಎಂದು ಪ್ರತಿದಿನ ಗಲಾಟೆ ಮಾಡಿ ಹೊಡೆಯುತ್ತಿದ್ದನು. ಅವಳ ಗಂಡನ ಮನೆಯಿಂದ ಹಿರಿಯ ಅತ್ತೆ ಮಾದೇವಮ್ಮ, 2ನೇ ಅತ್ತೆ ಕೆಂಪಮ್ಮ, 3ನೇ ಅತ್ತೆ ತಾಯಮ್ಮ, ಸ್ವಾಮಿ, ತಂಗಿ ಮಲ್ಲಮ್ಮನ ಗಂಡ ಸ್ವಾಮಿ, ತಮ್ಮ ಶಿವ, ಮಲ್ಲಮ್ಮನ ಮಗ ಸಂಜು ಅವರುಗಳು ಹಾಗಾಗಿ ನನ್ನ ಮಗಳು ಭಾಗ್ಯ ಮಾಡೋ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡುತ್ತೆ. ಈ ವಿಚಾರದಲ್ಲಿ ಭಾಗ್ಯ ನನಗೆ ಹೇಳುತ್ತದೆ. ನನಗೆ ಸಮಾಧಾನ ಈ ಗಲಾಟೆ ವಿಚಾರದಲ್ಲಿ ಹುಲ್ಲಳ್ಳಿ ಪೊಲೀಸ್ ಠಾಣೆ ಮತ್ತು ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆ ದೂರನೇ ಇದೆ. ನನ್ನ ಮಗಳು ನಿನ್ನೆ ದಿವಸ ಅಂದ್ರೆ 15/3 ಮಧ್ಯಾಹ್ನ ನನಗೆ ಫೋನ್ ಮಾಡಿ ಮೇಲ್ಕಂಡ್ರಗಳು ನನ್ನ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿ ನಿನಗೆ ಮಕ್ಕಳು ಆಗಲಿಲ್ಲ, ನೀನು ಬಂದೇ ಬರುತ್ತಿರುವ ತಾಯಿ ಎಂದು ಹಿಂಸೆ ಮಾಡುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿದರು. ನಾನು ನನ್ನ ಮಗಳಿಗೆ ನನ್ನ ಫೋನ್ ಮಾಡಿ ಮಾತನಾಡಿದೆ. 5 ದಿವಸ ಸಂಜೆ ಮಹಾದೇವನವರಿಂದ ನನಗೆ ಫೋನ್ ಮಾಡಿ ನಿಮ್ಮ ಮಗಳು ಭಾಗ್ಯ ನೇಣು ಹಾಕಿಕೊಂಡು ಸತ್ತಿದ್ದಾಳೆ ಎಂದು ತಿಳಿಸಿದರು. ತಾವು ತಕ್ಷಣ ನಾನು ನನ್ನ ಗಂಡ ಬಸವನಾಯಕ ನಮ್ಮ ಗ್ರಾಮದ ಮಹಾದೇವನಗರಕ್ಕೆ ಬಂದು ನೋಡಿದಾಗ ಭಾಗ್ಯಳನ್ನು ಮನೆಯ ವರಾಂಡದಲ್ಲಿ ಮಂಚದ ಮೇಲೆ ಸತ್ತು ಹಾಲ್ ಅಡಿಯೇ ಮನೆ ಹತ್ತಿರ ತಿರುಗಿ ಸೀರೆ ಕಟ್ಟಿದ್ದು ಸೀರೆ ಮಾತ್ರ ನೇತಾಡ್ತಿತ್ತು. ನನ್ನ ಮಗಳು ಭಾಗ್ಯಳ ಮೇಲ್ಕಡೆ ಹಿಂಸೆ ನೀಡಿ ತಾಯಿಯನ್ನು ಪ್ರಚೋದನೆ ಮಾಡಿ ನನ್ನ ಮಗಳು ಸತ್ತಿರುವ ಬಗ್ಗೆ ಅನುಮಾನ ಮೇಲ್ಕಡೆ. The present petitioner is the sister of the accused number 1. The place of incident and occurrence at Mysore. She has given to marriage to the petition number 2. They are staying at Chamarajanagar. And the marriage happened 12 years back. And no occasion arose even for any alleged harassment by the present petitioners. So far as the accused number 2, 3 and 4 have been granted bail by this court, and accused number 7 is also granted bail by this court. That on 439. The accused number 1, who is in still custody. And the entire statement, my lord, of witness.
Where is the PM report? Why PM report is not produced? All along it is noticed that PM report is withheld. New produce model. You get it. New produce model. New job there alwa. Yes.
In favor of the statement, my lord, recorded, my lord, which discloses that, my lord, as on the date of the incident, even, my lord, the accused number 1 was also not in the house, my lord.
I'm not concerned about it. One sir.
Because the-
You just
yeah,
restrict to the present petitioner.
the presence of this petitioners is not mentioned in any way. Well, and question of harassing or instigating the deceased doesn't arise by the petition because they were separately staying in Chamrajpet. The incident happened at Mysore, and they are ready to obey any terms and conditions because merely the petition number 1 being a sister of the accused number 1, and the petition number 2 is merely husband of the petition number 1. Case has been registered against this.
Yes.
Considering this, they are ready to obey any conditions. Considering this, and also insofar as the other 3% already granted, the custodial interrogation of the present petition is not required. There may be charge sheet also.
So you decide custodial inquiry is not necessary. You are giving a liberty to yourself, not giving liberty to the IO. Huh?
They are staying.
Who has to take a call whether custodial inquiry is required or not? Huh? Yes.
That's why they want to come both of them.
Merely a person says that go and die. Does it mean that he has intended that the person against whom those such words are uttered should go and die? Mens rea is mandatory. 107 ingredients are required. Merely uttering the word go and die. So, the petitioners have filed this petition under section 438 of CRPC seeking anticipatory bail in the event of their arrest in crime number 40 of 22 of Pulahalli Police Station, registered for the offences punishment 498A and 306, read with section 34 of the IPC. The brief factual matrix leading to the case is that the deceased Bhagya was given in marriage to accused number 1 about 12 years earlier, and initially for 5 years they resided in Kelasur village, and later on for 1 year they resided in Jayanagar. Subsequently, they have also resided together in Mahadev Nagar. It is alleged that accused number 1 was doing a tailoring work, and though the marriage was solemnized about 12 years earlier, the deceased could not get any children, and as such, the present petitioners and others used to ill-treat her and humiliate her that she has not given birth to any child. This fact, it is further alleged that the deceased used to share these aspects with her, the complainant, and on 15/3/2022, it is alleged that deceased has called the complainant, and the petitioners have abused her, asserting that it is, since she is unable to get any child, it is better she could go and die, and ill-treated her. Then subsequently on 16/3/2022, they received a intimation that the deceased committed suicide by hanging in this in Mahadevpura in the residence. In this regard, the complainant has lodged a complaint and the case came to be registered. Third, the arguments advanced by the learned counsel for petitioner and learned HCGP. Where is the records? The learned counsel for petitioner would contend that the petitioner number one is the sister of the accused number one, while petitioner number two is the husband of petitioner number one, and they are residing in Chamraj Nagar while deceased, and accused number one were residing in Mysore. He would also contend that the present petitioners were not present when the alleged offence is said to have been committed, and only with vengeance they have been falsely implicated in this case. He would also assert that except accused number one, other accused have been granted bail, and as such she would seek for admitting the petitioners on anticipatory bail. Next. Per contra, the learned SCGP would seriously object the bail petition, contending that ground of parity cannot be made applicable to the present petitioners. He would further assert that there is material evidence as against the present petitioners and sought for dismissal of the claim petition, bail petition. Having heard the arguments and perusing the records, it is evident that the deceased Bhagya was residing with accused number one in Mahadevpura, Mysore. The offence is she committed suicide in her house in Mahadevpura. Admittedly, the petitioners are residing in Chamraj Nagar. Further, petitioner number one, being a sister of the accused number one, is married to petitioner number two. The only allegation is in the complaint is that on 15/3/2022, all the accused have humiliated her that she could not get any child, and it is better she could go and die. Mere uttering word that she should go and die does not amount to abatement, as the prosecution is required to prove the mens rea, for attracting the offence under section 306 of IPC, the ingredients of section 107 of IPC regarding instigation or abatement are required to be proved. Though there is some material evidence regarding 498A IPC, but at this juncture, no evidence is forthcoming regarding the petitioners abating the deceased in commission of the offence. The other accused have been, except accused number one, have been already granted bail. Under these circumstances, the investigation is also concluded and charge sheet is laid down. Under these circumstances, I don't have any impediment for admitting the petitioner on anticipatory bail. The other apprehensions raised by the prosecution can be meted out by imposing certain conditions. Hence, petition is to be allowed, and accordingly, I proceed to pass the following order. Petition is allowed, and petitioners are ordered to be enlarged. The petitioners are ordered to be enlarged on anticipatory bail in the event of their arrest in crime number so and so police station, on each of the executing a personal bond in a sum of rupees 1 lakh with the 2 sureties for like sum, subject to following conditions. Normal conditions, I think. Next time, the petitioners shall surrender before the concerned court within 15 days from the date of receipt of the certified copy, and on their surrender, the learned and the concerned court shall release them on bail as directed above. However, it is made clear that the investigating officer is at liberty to investigate further as against the present petitioners, and he is at liberty to submit charge sheet on additional charge, supplementary charge sheet under section 173(8) of CRPC.
Petition by accused number 1, 2, 3, based on an order of preference by the private complaint filed by the complainant. The present FIR, crime number 114 of 21 has been registered for the alleged offence punishable under section 192, 193, 196, 420. No, the allegation in the complaint is that the land measuring 3 acres, 13 guntas, originally belonged to one Anmantachar. And subsequently in the year 1966, Venkat Nayak has purchased said land through an unregistered sale agreement and was put in possession. Subsequently, in 2015, the complainant has...
How it is a sale deed? How it can be a sale deed?
Exactly, that is just a sale agreement. I am
See, you are arguing sale, and now you are saying that it is a sale agreement.
Well, it is a narration of the complainant that his vendor has purchased the said land through a sale agreement, and he was put in possession, the complainant's vendor. Subsequently, in the year 2015, the complainant has purchased the said land from his vendor again through an unregistered agreement, and in 2020 was put to possession through a settlement deed, again an unregistered. This is the narration of the complainant, and he says that till 2021, the land was in the name of Anmantachar, that is the petitioner. And in the year 2021, the petitioner and the first petitioner and the third other petitioners have executed that is accused number 1 along with 2 and 3 have executed a registered sale deed with respect to the 3 acres 13 guntas of land in favor of accused number 4. A registered sale deed. This is the fact of the case. Based on this, the complainant claims that he is the owner of the land, he is in the possession based on this unregistered deeds.
Whether the deed in favor of the complainant is whether agreement of sale or a sale deed.
It's an agreement of sale with the settlement deed, as per their narration in the complaint, page 20.
Yes.
And as on date, my lords, the RTC records everything. The name of the first petitioner is reflected. And there is a civil suit pending in OS 75 of 2021 filed by the complainant, and it is in the notice rate.
Yes.
And in the same offense, in the same FIR, another Ramchandra has been arrested. And he has been arraigned as accused for 1. He has been enlarged on bail.
What is the role of Ramchandra?
He is claimed that he is assisted the petitioners in executing this sale deed.
Yes.
This is purely a civil transaction, and yes. The civil suit is pending.
Yes, see, one thing I want to ascertain whether a sale deed, unregistered sale deed or agreement of sale, coupled with possession, confirm any right, title or interest. And when it is coupled with possession, even let us accept that it is a agreement of sale coupled with possession. What is the law? Sale agreement. I am asking sale agreement coupled with possession. What is the law? Sir, adike nan kelta idini. A sale agreement coupled with possession. What is the law after 1995? It is compulsory registrable. Stamp duty equal to sale deed is required to be paid. That is the law. If you don't pay stamp duty and if you approach civil court, 10 times penalty is required to be paid before accepting the deed, for accepting the deed, 10 times penalty becomes mandatory. ಏನ್ರಿ ಇದ್ರೊಳಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರೀ, ಡಿಸ್ಪ್ಯೂಟ್, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಎಲ್ಲ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ತೀರಾ ನೀವು? Have you investigated the genuineness of the agreement of sale, legality of the agreement sale? ಅದನ್ನು ಮಾಡಲ್ಲ ನೀವು, ಅದನ್ನು ಮಾಡಲ್ಲ ನೀವು, ದೇವರಾಣಿಗೂ ಮಾಡಲ್ಲ. Was the owner, original owner? Hanumanthachar. What is petitioner number 2?
The wife of the petitioner number 1.
What about petitioner number 3?
Son of petitioner number 1.
The petition is filed in section 438 of CRPC, seeking anticipatory bail in the event of arrest of the petitioner in crime number 114 of 21. Yen prayer Swami nimdu. On bail in the event of their arrest in crime number 114 of 21 for the offenses so and so, registered in respondent police station. Prati sala ನಾವು respondent police station ನೋಡ್ಕೋತ ಹೋಗ್ಬೇಕು.
ದೊಡ್ಡ ಬೆಲೆ ಮಂಗಲ.
ಅದನ್ನ ಹೇಳೋದ್ ಬಿಟ್ಟು ಏನ್ರಿ ನೀವು? ಇನ್ ದೊಡ್ಡ ಬೆಲವಂಗಲ police station for the offenses punishment section 193, 196, 419, 420, 192, 416, 417, 425 of IPC. The factual matrix leading to the case is that the petitioner number 1 is the owner of land, the disputed land measuring 3 acres 13 guntas, and petitioner number 2 is his wife, while petitioner number 3 is his son. It is alleged that one Venkat Naik in 1969 has said to have purchased this land under agreement of sale and was in possession of the said land, and on 27/5/2015 he has executed an agreement of sale in favor of the complainant. However, the land was continued to be in the name of the petitioner number 1, and subsequently he sold the land under registered sale deed in favor of number 4. Hence, the complainant has alleged that the petitioners have cheated him and lodged the complaint. The complaint was lodged under section 200 as a private complaint under section 200 of CRPC, and on the basis of the private complaint, matter was referred to the concerned police station, and this crime came to be registered. Third, the arguments advanced The petitioners apprehending their arrest have approached the learned session judge, who has rejected their bail petition. Hence, they claim that they are constrained to file this petition before this court. Heard the arguments advanced by the learned counsel for petitioner and learned counsel for learned HCGP. There is the records. The records disclose that the property is still standing in the name of petitioner number 1, who in turn executed a registered sale deed in favor of accused number 4. Further, it is also evident that the alleged transactions in favor of Venkat Naik and present complainant are unregistered deeds. There cannot be any sale deed without registration of the documents, as it is the such transaction is hit by section 17 of the Registration Act. Apart from that, even if the agreement of sale coupled with possession is taken into note of, that does not prevent the petitioners to alienate their property, and the remedy for complainant is to file a suit for specific performance of the contract so as to enforce the contract. But without taking any recourses, it is evident that a civil litigation is given a color of criminal litigation. Considering these facts and circumstances, further, the offences alleged are also not punishable with a death or life imprisonment. Under these circumstances, I do not find any impediment for admitting the petitioners on anticipatory bail. The other apprehensions raised by the learned prosecutor can be meted out by imposing certain conditions. Hence, petition used to be. The petition is allowed. Petitioners are directed to be enlarged on anticipatory bail in the event of their arrest in so and so crime number at so and so police station, and each of them executing a personal bond in a sum of ₹50,000 with one surety for like sum, subject to following conditions. Normal conditions. The petitioners shall surrender before the concerned police station and within 15 days from the receipt of the certified copy of this order, and in the event of their surrender, the IO or SHO shall release them on bail. Next, condition. The petitioner shall appear before the investigating officer during the course of investigation whenever so directed, and shall cooperate with the investigation. With no representation on behalf of petitioner, leaves the matter for compliance after 2 weeks finally.
ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಪ್ರದೇಶದಲ್ಲಿ
ಕೊಡ್ತಾನೆ ಇಲ್ಲಲ್ಲ. You are supposed to furnish copy to issue notice to R2.
Notice may be ordered.
Without furnishing, that is the issue. Notice has been already ordered. You are not paid PF. That is the complaint. Copy kodbeku, ella kodbeku. The learned counsel for petitioner submit that needful will be done during the course of the day. The office to verify and in the and then proceed to issue notice to R2. Please the matter on 27/10.
This is 307, 326B of this. How you get it compared to the page? Yes, page 18 please. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಮಕ್ಕಳಾದ ರಾಜ್ಯ ಇಕ್ಬಾಲ್ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದು ಫಾರೆಸ್ಟ್ ಗಾರ್ಡನ್ಸ್ ಅಗರಬತ್ತಿ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ಅಗರಬತ್ತಿಗಳನ್ನು ಪ್ಯಾಕಿಂಗ್ ಮಾಡುವ. ನನಗೆ ಹೀಗೆ ಸುಮಾರು 1.5 ವರ್ಷದಿಂದ ನನ್ನ ಗಂಡ ರಿಯಾಸ್ ಪಾಷಾ ಅವರ ವಿವಾಹ ವಿಚ್ಛೇದನವಾಗಿದ್ದು ಆಗಿನಿಂದಲೂ ನಾನು ನನ್ನ ಮಕ್ಕಳನ್ನು ಸಾಧಿಸಿದ್ದೇನೆ. ನಾನು ಹೀಗೆ ಸುಮಾರು 4 ವರ್ಷಗಳಲ್ಲಿ ರಿಯಾಸ್ ನಗರದ ಕರ್ನಾಟಕ ಅಗರಬತ್ತಿ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ಅಹಮದ್ ಉಲ್ಲಾ ಖಾನ್ ಈತ ಗೋರಿಪಾಳ್ಯದ ನಿವಾಸ. ಈತ ಯಾವಾಗಲೂ ತನ್ನನ್ನು ಮದುವೆಯಾಗಿ ಎಂದು ತಿಳಿಸುತ್ತೀನಿ. ನಾನು ಆತನಿಗೆ ನಾನು ನಿನ್ನ ಜೊತೆ ಮದುವೆಯಾಗಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ಹೀಗಿರುವಾಗಿ ಈತನ ಅವಳನ್ನು ತಾಳಲಾರದೆ ನಾನು ಸುಮಾರು 6 ತಿಂಗಳ ಹಿಂದೆ ನಾನು ಕೆಲಸಕ್ಕೆ ವಿವಾದನಗರದ ಫಾರೆಸ್ಟ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ. ಹೀಗಿರುವಾಗ ದಿನಾಂಕ 10/6/2021 ಬೆಳಗ್ಗೆ 9 ಗಂಟೆ ಸಮಯ ನಾನು ಎಂದಿನಂತೆ ಹೋಗಲು ಮನೆಯಲ್ಲಿ ಮಗಳೊಂದಿಗೆ ಹೊರಟಿದ್ದೆ. ನನ್ನ ಮಗಳು ರಿಯಾಜ್ ನಗರ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಹತ್ತಿರ ಬೇರೆ ಆಗಿ ಅವಳ ಕರ್ನಾಟಕ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ಕೆಲಸಕ್ಕೆ ಹೋದ. ನಾನು ಫ್ಯಾಕ್ಟರಿ ಹತ್ತಿರ ಹೋದಾಗ ಫ್ಯಾಕ್ಟರಿಯ ಮುಂದೆ ಅಹಮದುಲ್ಲಾ ಖಾನ್ ಕೆಲವೊಂದು ಸ್ವಲ್ಪ ಮಾತನಾಡುವುದು ಕರೆದಿದ್ದೆ. ಇದಕ್ಕೆ ಒಪ್ಪದಿದ್ದಾಗ ನನ್ನನ್ನು ಬಲವಂತವಾಗಿ ಕೇಳಿಸಿಕೊಂಡು ಸ್ವಲ್ಪ ಮಾತನಾಡುವುದಿದೆ ಬಲವಂತವಾಗಿ KP ನಗರ ಮೆಟ್ರೋ ನಿಲ್ದಾಣ ಮತ್ತು ಉಮಾಮಹೇಶ್ವರಿ ದೇವಸ್ಥಾನದ ಮಧ್ಯೆ ಇರುವ ಗುರಿಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡು ಮಾತನಾಡಿ ನನಗೆ ಮದುವೆಯಾಗುವಂತ ಒತ್ತಾಯ ಮಾಡುತ್ತಾರೆ. ನಾನು ನಿಮಗೆ ಈ ಹಿಂದೆ ತಿಳಿಸಿದ್ದು 15 ವರ್ಷದ ಮಗಳಿದ್ದಾಳೆ. ನಾನು ಈ ವಯಸ್ಸಿನಲ್ಲಿ ಏನು ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವುದು, ಅಲ್ಲದೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳಿದ್ದಾರೆ, ಅವರನ್ನು ಯಾರು ನೋಡಿಕೊಳ್ಳುವುದು ಎಂದು ನಾನು ಆತನಿಗೆ ತಿಳಿದಿದ್ದರಿಂದ ಆತ ನನಗೆ ಅದನ್ನೆಲ್ಲ ಹೇಳಬೇಡ, ನೀನು ನಿನ್ನ ಜೊತೆ ಮದುವೆಯಾಗಲೇಬೇಕು ಎಂದು ಕೋರಿದ ಮೇಲೆ ಮಾತನಾಡುತ್ತಾನೆ. ಅವರು ಆಗುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದಾಗ ಆಗಲೇ ಅವನ ಕೈಯಲ್ಲಿ ಅವರಲ್ಲಿ ಪಾತ್ರವನ್ನು ತೆಗೆದುಕೊಂಡು ಹಾಕಿದೆ. ಏನು ನನಗೆ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವುದೆಂದರೆ ನಿನ್ನ ಹಸಿಗಾಗಿ ಕೊಲೆ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೆದರಿದೆ. ಹೀಗೆಲ್ಲ ಮಾಡಬೇಡಿ ಅಂತ ಅವನನ್ನು ತಿಳಿದುಕೊಂಡು ಅವನಿಂದ ತಪ್ಪಿಸಿಕೊಳ್ಳುವುದು. ನನ್ನ ಮಗನ ಮೇಲೆ ನನ್ನ ಮಾತುಗಳನ್ನು ಕೇಳದೆ ಹೋದ ಮೇಲೆ ಈ ಸಮಯದಲ್ಲಿ ಇಬ್ಬರು ಆ ದಾರಿಯಲ್ಲಿ ಅಲ್ಲಿಂದ ಅಹಮದನ್ನು ಓಡಿ ಹೋದ. ಈಗ ಯಾಕೆಗಾಗಿ ಸಮಯ ಸುಮಾರು 20 ಗಂಟೆ ಆಗಿತ್ತು. ಆಗ ಅಲ್ಲಿಯೇ ಮುಂದೆ ಸಹ ವ್ಯಕ್ತಿಗಳನ್ನು ವಿತರಿಸಿದೆ. ನಾನು ಏನೂ ಆಗಿರುವುದಿಲ್ಲ ಎಂದು ಫ್ಯಾಕ್ಟರಿ ಕಡೆ ಹೋಗುತ್ತಿದ್ದು ಹುರಿ ಹೆಚ್ಚಾಗಿತ್ತು. ಫ್ಯಾಕ್ಟರಿಯನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದಿರ್ತಾನೆ. ಆಸ್ಪತ್ರೆ ತಪ್ಪಲಿ ಪುಟವು ಅಲ್ಲೇ ಬಿದ್ದಿರುತ್ತದೆ. ಅವನು ಅಹಮದನಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವ ಕಾರಣಕ್ಕೆ ಆತ ಉತ್ಪಾದನೆಯಲ್ಲಿ ನನ್ನನ್ನು ಕಾಡುತ್ತಿದೆ. ಮನೆ ಹತ್ತಿರವೂ ಕೂಡ ಬಂದು ನಿಮ್ಮ ತಾಯಿನೂ ಕೂಡ ಕೇಳಿದೆ. ನಮ್ಮ ತಾಯಿಯೇ ಸಹ ಆಗುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿ ತಿಳಿಸಿರುವುದರಿಂದ ಹಾಗೂ ಈ ಎಲ್ಲ ಕಾರಣಗಳಿಂದ ನಾನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಲ್ಲಿ ಆಚರಣೆ ಮೊದಲೇ ಕೈಯಲ್ಲಿ ಎರಚಿ ಹೋಗಿರುವ ಅಹಮದುಲ್ಲಾ ಖಾನ್ಗೆ ಕಾನೂನು ಇರ್ತದೆ ಕೇಳಿಕೊಂಡೆ. Ahmadullah Khan is the sole accused before your last. They had an acquaintance about 4 years. They are the colleagues in the same incense factory. And 1.5 years back, prior to this incident, she got a divorce from her husband. Of course, it is my defense, not even before the trial, saying that they were acquainted with each other. And there was a promise also saying that she would marry him. Since the petition as well as the complaint belongs to the The reason why we wanted after this, subsequently they developed differences. The case of the complaint is that what since he has refused saying that I have a children, one of children, he develops a grudge against her and he tries to go acid upon the complaint is as for the case of the prosecution, so that the charge sheet is filed, when at the time of stage of crime, I approached only the sessions. After that, the bail was rejected on the count that since it is an offenses committed. As for the case of the prosecution, there are 2 eyewitnesses. My lord may kindly take page 37. CW1 is the complaint. My lord gets it. 2 persons stated to be Syed Shabir and Syed Asghar. They are said to be on the spot in the incident stated to have been taken place. My lord may kindly take the statement of those 2 alleged eyewitnesses to the incident itself. Page 63. Coming page 63. ದಿನಾಂಕ 10/6/2022 ಬೆಳಗ್ಗೆ 8:30 ಗಂಟೆ ನನ್ನ ಸ್ನೇಹಿತ ತಿಲಕ್ ನಗರದ ವಾಸಿಯಾದ ಅಸ್ಗರ್ ಖಾನ್ ನಮ್ಮ ಭೇಟಿ ಮಾಡಲು ನಾವಿಬ್ಬರು ಮಾತನಾಡಿಕೊಂಡು ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿ ಜೆಪಿ ನಗರ ಮತ್ತು ನಿಲ್ದಾಣ ಹಾಗೂ ಉಮಾಮಹೇಶ್ವರ ದೇವಸ್ಥಾನ ಮಧ್ಯೆ ಇರುವ ರಸ್ತೆಯಲ್ಲಿ ಬೆಳಗ್ಗೆ 9:15 ಗಂಟೆ ಬೆಳಗ್ಗೆ 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಡೆದುಕೊಂಡು ಬರುತ್ತಿರುವ ಒಬ್ಬ ಅಸಾಮಿ ಬುಕ್ಕ ಧರಿಸಿದ ಮಹಿಳೆಯ ಮುಖದ ಮೇಲೆ ಏನೋ ಎರಚಿಕೊಂಡು ಆಕೆ ಜೋರಾಗಿ ಕಿರಿಚತೊಡಗಿದರು. ತಕ್ಷಣ ನಾವು ಅವಘಡಗಳು ಹೋಗುತ್ತಿದ್ದೆವು. ಆ ಆಸಾಮಿ ನಮ್ಮನ್ನು ನೋಡಿ ಮಹಿಳೆಯನ್ನು ಬಿಟ್ಟು ಅಲ್ಲಿಯೇ ಬಿಟ್ಟು ಓಡಿ ಹೋದರು. ನಂತರ ನಾವುಗಳು ಆಕೆ ಬಳಿ ಹೋದಾಗ ಆಕೆ ನಮ್ಮ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುವ ಶವನ ಆಗಿತ್ತು. ಈಗ ನಾವುಗಳು ಶವನನ್ನು ಸಮಾಧಾನಪಡಿಸಿ ಏನಾಯಿತು ಎಂದು ಕೇಳಿದಾಗ ಈ ಹಿಂದೆ ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಅಹಮದುಲ್ಲಾ ಖಾನ್ ನನ್ನನ್ನು ಪ್ರೀತಿಸಿ ಮದುವೆಯಾಗಿ ಎಂದು ಪ್ರೀತಿ ನನಗೆ ತೊಂದರೆ ಕೊಡುತ್ತಿತ್ತು. ನಾನು ಆತನಿಗೆ ನನ್ನ ಮಕ್ಕಳು ಬೆಳೆದು ದೊಡ್ಡವರಾಗಿದ್ದರೆ ಅವರನ್ನು ಬಿಟ್ಟು ನಾನು ಮದುವೆಯಾಗಲು ಇಲ್ಲ ಎಂದು ಹೆಚ್ಚು ಹೇಳಿದ್ರು. ಆತ ನನ್ನ ಮಾತನ್ನು ಕೇಳಿದೆ. ಈ ಕೆಲಸ ಬೆಳಗ್ಗೆ 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅಹಮದಿನ ಜೊತೆ ಮಾತನಾಡುವುದು ಇದೇ ಎಂದು ನನ್ನನ್ನು ಇಲ್ಲಿ ಕರೆದುಕೊಂಡು ಬಂದು ತನ್ನನ್ನು ಮದುವೆಯಾಗಿ ಎಂದು ಬಲವಂತಪಡಿಸಿತ್ತು. ಆಗ ನಾನು ಆತನಿಗೆ ಮದುವೆಯಾಗಲು ಸಾಧ್ಯ ಇಲ್ಲ ಎಂದಾಗ ಆತ ಏಕಾಏಕಿ ಆತನ ಜೊತೆಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡು ಬಂದ ಬಾತ್ರೂಮ್ ಕ್ಲೀನ್ ಮಾಡುವ ಆಸೆಯಿಂದ ನನ್ನ ಮುಖದ ಮೇಲೆ ಎರಚಿ ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿ ನಿಮ್ಮ ನೋಡಿ ಅಹಮದ್ ಓದಿ ಹೋಗಿತ್ತು. But is the replica of the same statement, so far as the statement of CW3 is concerned, they happen to be both are friends. But my respective submission is, as of now, as per my knowledge, but the FSL report, so far as the gravity of this liquid, whether it is truly acid or not, is not yet received and is subject to clarification. But when the bail application was considered before the trial court, there also it was not submitted. So kindly take the opinion, page 48. Last, the patient suffered acid burn injuries of about 3%, which is deep in partially. So this is what the nature of injuries are. But I'm not justifying it for a moment. If it is proved to be acid attack, ultimately, of course it is. What is attributed against me is an attempt to throw acid upon the victim, since he has refused to not marry me. So that the charge sheet is filed. The investigation is complete. Any stringent condition that could be.
So you mean to say that in case of acid attacks also, the court should be very liberal?
No.
A woman is targeted with acid. What is the mental state of mind of an accused who has prepared, he has brought the acid, prepared and brought the acid with an intention to damage the facial aspect of the victim, complainant, provided she refuses. Is it not a blackmailing thing? You may be in love, you may be interested in marrying her. Fine. You are not the sole person. It is her. If her consent is, if she is not willing, you cannot compel her. And in order to get a grudge, you throw acid. Whether the concentration of the acid is becomes secondary, but the impact will be the same. What is the mental trauma that lady undergone?
But so far as the factual aspects narrated in the complaint is, there is a chance of distorting the facts.
That is to be tested only during the course of the trial. This is too early to test it. The genuineness of the allegations of the complaint at this juncture, allegations made in the complaint will prevail.
Only because of one submission. My Lord has felt, but of course, my Lord, because crime against the society, if it is happened to be what generally it means very seriously.
No, sorry, sir.
One submission.
Really?
My humble request is, since it is not a, the FSL report is not a, which I do not know, subject to what another thing says. It is received.
Whether official report received or not, that is a secondary. The document medical report disclosed that she suffered acid burn injuries to the extent of 3%. The official report only disclose what is the percentage of the acid in the bottle. That's all. It may be a mild acid. If it is a sulfuric acid concentrated, it causes more. If it is a hydrochloric acid, it varies from person.
But my only humble suggestion is that since he did not have the intention to cause a death or attempt to cause
Whether his intention to cause a death is a secondary, his intention is to disfigure that lady so that she should not marry to anybody else. That is a serious lapse, serious thing.
Of course, I will not take much of your logic. Since what it is, what not a record is, bathroom clean ಮಾಡೋದಂದ್ರೆ ಹೆದರಿಸಬೇಕು ಅನ್ನುವಂತ ಉದ್ದೇಶ.
Sir, bathroom clean ಮಾಡೋದು immediately wash ಮಾಡಲಿಲ್ಲ ಅಂತಂದ್ರೆ what will be the consequences? No, sir. Dismiss. After arguing the matter for some time, the learned counsel for petitioner submit that he may be permitted to withdraw the petition. The submission is placed on record. The petition is dismissed as withdrawn. Sorry, you have done your duty. I cannot find fault with you. See, you have done it is you. See, you have been interested. You have taken, you have done your justification. It is the facts which will prevail. You can make your attempt, that's all. I cannot find fault with you. The learned counsel for petitioner filed a memo stating that he is not pressing the petition and he may be permitted to withdraw the petition. Memo is placed on record. The petition is dismissed as withdrawn. There is no representation on behalf of petitioner. List after 2 weeks, finally for compliance of office objections.
Under 448, 504, 323, 356. ಎಲ್ಲ ಸ್ವಾಮಿ ಎಲ್ಲ ಪಂಚಾಯತ್ ಅಫೆನ್ಸ್ಗಳು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಟ್ರೈಬಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್
ಏನೇನ್ರಿ ಏನೋ ನನಗೆ ಹೇಳ ಸರಿಯಾಗಿ ಅರ್ಥ ಆಗಲಿಲ್ಲ. ಆಲ್ ಆರ್ ಟ್ರೈಬಲ್ ಬೈ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. ಹರೀಶ್ ನೀವು ನೋಡಿದಿರಾ ರೆಕಾರ್ಡ್ಸ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಓದಿದಿರಾ FIR ಓದಿದಿರಾ ಏನೇನ್ ಅಫೆನ್ಸ್ ಇದೆ?
$448, 504, 324, 354, 394, 506.
394 ಹೇಳೇ ಇಲ್ಲಲ್ಲ. 394 is a serious offense, sir. ಹೇಳಿ. ಮೆರಿಟ್ ಮೇಲೆ you don't want to argue na ಏನು ಅನ್ನೋದು ಅರ್ಥ ಆಗ್ಬೇಕು.
ಸೀನಿಯರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಹಾಗೆ ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದು.
ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೇ ಮಾಡ್ತೀನಿ ನಾನು. ಅದನ್ನ ನೀವು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ನಾ? ಇಟ್ಸ್ ಮೈ ಡ್ಯೂಟಿ ಐದರ್ ಟು ಡಿಸ್ಮಿಸ್ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡೋದಿಲ್ಲ ಅಲಾ ಮಾಡ್ತೀನಿ. ಏನ್ ಮಾಡೋದ್ರಿ ನೀವು?
ಅರ್ಥ ಮಾಡೋದು.
The petitioner, petition number 1, has filed this petition under section 438 of CRPC, seeking anticipatory bail in the event of his arrest in crime number 58 of 22 on the file of Shanimar Sante Police Station, Somarpet, Kodagu district, registered for the offences punishable under section 448, 504, 323, 324, 354, 394, 506, read with section 34 of the IPC. The brief factual matrix leading to the case is that the complainant, along with her handicapped husband Manjunath, were residing in a tin shed constructed by them by the side of the main road of Nakalkot village. And on 18/7/22 morning, they had been outside to attend their work. In between, the present petitioner, along with other accused, broke open the lock of the tin shed and occupied the same. When morning at 7:40 a.m., when the complainant and her husband returned and found that the petitioner, along with other accused, occupying the said shed, she inquired, and at that time, the petitioner, along with other accused, assaulted the complainant by hands, kicked her on chest, and also threatened her to kill, and snatched 25,000 rupees from the pocket of her husband. In this regard, she lodged a complaint. On the basis of this complaint, the crime was registered. The petitioner apprehending his arrest was approached the first judge Kodagu, and the learned session judge rejected the anticipatory bail petition filed by the petitioner. Hence, petitioner is before this court. Heard the arguments advanced by the learned counsel for petitioner and learned SCGP. There is the records. The allegations of the prosecution disclose that the alleged offence is said to have taken place on 18/7/22, when the petitioner number 1, the petitioner along with other accused, broke open the lock of the seat house constructed by the complainant, and when complainant inquired, she was assaulted and rupees 25,000 was robbed from the pocket of the husband. Though the crime was registered on 22/7/22 at 10 a.m. itself, all along the petitioner is absconding. There are serious allegations regarding robbing of rupees 25,000, and as such, custodial inquiry is essential. It is the statement of objection, the submission of the learned public, the HCGP disclosed that ಇದೇ 30 ಕೇಸ್ ಒಳಗೆ ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದು ಇದೆಯಲ್ಲ. The petitioner herein is involved in as many as 30 cases, was convicted in 8 matters. In other 8, investigation is going on. This clearly discloses that the petitioner is a habitual offender and he is already a convicted accused. In spite of the same, he is involved in similar offense of 394 and looking to these facts and circumstances, this is not a fit case wherein the discretion can be exercised in favor of the petitioner, accused number 1. Hence, petition is devoid of any merits and accordingly it stands rejected. The learned counsel for petitioner would submit that the needful would be done during the course of the day. If so, the office to issue notice to R2 and list the matter on 28th. $8 lakhs you have received. But the condition regarding attending police station is mandatory, putting the attendance, and from Mumbai you are bound to appear before the investigating officer regularly as and when directed, including regular attendance. If he threatens you, you can move bail for cancellation. See, your interest is to see that you should get the amount. Strictly speaking, it is a purely a civil transaction. If we go by that, it is a strictly civil transaction. But since some allegations regarding cheating is there, but he has to come over from Mumbai to Bangalore regularly for having committed the offense. Now by making payment, he has indirectly admitted the everything. Reasonable attendance, police station regularly. No, sir. Once in 2 months, you are from Bombay. That doesn't mean that you should require. When you are doing involved in a business, you should maintain the business professionality of the business. I cannot impose condition for payment of amount in an anticipatory bail petition. You know it. How can I do it? Huh? Is it a recovery proceedings? Huh? You object my recovery proceeding turn ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ. But will impose certain stringent conditions. And in order to avoid it, he will get rid of your payment. Definitely. The petitioner has filed this petition under section 438 of CRPC seeking anticipatory bail in the event of his arrest in ಏನು ವಕೀಲ್ರೆ ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಬರೆಯೋ ಅಂತಾನೆ ಇಲ್ಲ ನೀವು ಇಲ್ಲ ಸರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಏನೇನ
ಸೈಬರ್ ಅಂಡ್ ಎಕನಾಮಿಕ್ ಸೈಬರ್ ಪೊಲೀಸ್
in the event of their arrest in crime number 100 of 22 of cyber and economic being the crime PS of Ramnagara registered for the offenses punishment under section 419 and 420 IPC, as well as under section 66C and 66B of the IT Act 2008. The brief factual matters leading to the case are that on 13/7/22, the complainant has lodged a complaint alleging that since last 6 months he was doing the business of lamp oil, and in respect of the same, she opened a bank account in Kumaraswamy layout of Axis branch. It is further alleged that in order to manufacture lamp oil, she was in need of liquid paraffin, and accordingly, she contacted the present petitioner who was dealing in paraffin, and by way of email transaction, she initially paid rupees 26,31,611 by way of NEFT to the account of the petitioner, who supplied the goods worth of the said amount. Subsequently, it is alleged that she was in need of, she has further ordered the said goods by making payment of rupees 26,07,800, but petitioner did not supply the oil, and hence it is even when she tried to contact him, he did not respond, and hence she lodged a complaint in this regard. On the basis of the complaint, crime was registered, and as such, the petitioner apprehending his arrest has approached the learned session judge, who has rejected anticipatory bail. Hence, he is before this court. Next. Heard both the sides and perused the records. The learned counsel for petitioner would contend that the petitioner was not in a does not have any intention of cheating the complainant, and he is getting the goods from foreign countries, and due to war between Ukraine and Russia, there is delay in supply of consignment to him, as such he could not supply the goods to the petitioner. He would contend that the moment the market eases out, he is ready to pay the amount, as he is not having any amount in this regard at this juncture, as he has paid that amount to the concerned company. He also undertakes to abide by the terms and conditions to be imposed by this court. It is also submitted that subsequently 8 lakhs has been remitted by him to the account of the complainant, which is received by her, and only now the balance is about 16 lakhs, and he would undertake to pay the same in due course. Per contra, the learned HCGP would the SPT would contend that the petitioner is a habitual offender, and this can be borne out from Google search, wherein the reviews disclose that he has cheated number of persons in this regard. Hence, he would contend that this is not a fit case wherein the discretion can be exercised and sought for dismissal of the petition. Having heard the arguments and perusing the records, the complaint was registered for the offense under section 419 and 420 IPC and under section 66 and 66D of IT Act. However, section 419 of IPC is not attracted in the instant case, since there is no issue of impersonation, and the only allegation is in spite of receipt of the amount, the goods were not supplied, which is in respect of allegations of cheating. However, the further records disclose that the petitioner has subsequently transmitted 8 lakhs to the account of complainant, which is admitted by the prosecution. The arguments on of the learned public SPP that SCGP that the Google search disclosed that the petitioner has cheated number of persons, which is evident from review, cannot be accepted as it is not having any certification. However, the records disclose that there is some transaction, and now the learned counsel for petitioner has also undertaken to pay the certain amount, the balance amount in due course, as 1/3 of the amount is already returned to the complainant. Looking to these facts and circumstances, I do not find any impediment for admitting the petitioner on bail. The other apprehensions raised by the learned SCGP can be meted out by imposing certain conditions. Hence, petition needs to be allowed, and accordingly, I proceed to pass the following order. The petition is allowed. The petitioner is directed to be enlarged on bail in so and so crime number in the event of his arrest in so and so crime number registered for the offense punishment so and so. On his executing a personal bond in a sum of rupees 2 lakhs with one surety for like sum, subject to following conditions. Regular condition. The petitioner shall surrender before the concerned jurisdictional police station, before SHO of the concerned jurisdictional police station within 15 days from the date of receipt of the certified copy of this order, and in the event of his surrender, the IO bar SHO shall release him on bail as directed. On the condition, the petitioner shall mark his attendance before SHO on 1st of each month until final report is between 9 AM to 5 PM until final report is submitted in non-condition. The petitioner shall appear before the investigating agency as and when directed during the course of investigation and shall cooperate with investigating agency.
The provisions of sections
Cannot take. I did not, I am not supposed to make any observation because investigation is in progress. That is not fair. But you, anyhow, you have been granted bail, Allah. Huh?
at this stage is not.
I cannot express anything. I have granted you bail. That is the.
Okay.
ಎರಡು ಕ್ವಶನ್ಗೆ ಆನ್ಸರ್ ಯಾವಾಗ ಬೇಲ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಅಂತ ಅದು 21/6 ಹಾಕಿದೀವಿ. ಅಲ್ಲಿ ವಾರಂಟ್ ಆಗಿದ್ದು 26. ದಿ ಆರ್ಡರ್ ಶೀಟ್ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 61 ಮೇಲೆ 7/5 ಗೆ ಸಮನ್ಸ್ ಹೋಗುತ್ತೆ. ಆನ್ ದ ವೆರಿ ಸೇಮ್ ಡೇ ದ ಟೋಟಲ್ ಕೇಸ್ ಇತ್ತು.
ಒಂದು ನಿಮಿಷ.
61 ಮೇಲೆ ಮಾರ್ನಿಂಗ್ ಇವರಿಗೆ ಸಮನ್ಸ್ ಕೊಡ್ತಾರೆ. ಮಾರ್ನಿಂಗ್ 10 o'clock ಸಮನ್ಸ್ ಕೊಡ್ತಾರೆ ಅಂತ 21 ಗೆ ಇವರು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಆಗ್ತಾರೆ. ಇವರಿಗೆ ವಾರಂಟ್ ಆಗೋದು 27/6 ಗೆ. 27/5 ಗೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಅವನು ಸರ್ವ್ ಆಗ್ತದೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ನಾನ್ ಬೇಲೇಬಲ್ ವಾರಂಟ್ ಆಗುತ್ತೆ. Then accused number 2 was granted later on granted bail by the Sessions Court. 27/6 ಗೆ
reissue NBW to accused ಅಂತ ಮಾಡ್ತಾರೆ 27 ಗೆ 21 ಗೆ this petition is filing the bail. Producing the dilation. Filing date is 21/6/2022. ಇದು 27/6 ಗೆ ವಾರಂಟ್ ಆಗಿದೆ.
Yes, ಏನ್ ಹೇಳ್ತೀರಿ? In fact, it is the mistake of the magistrate.
323 ಅಲ್ಲಿ
He should have issued warrant on 7/5 itself the moment you remained absent.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ 7/5 ಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ 10 ಗಂಟೆಗೆ ಸರ್ವ್ ಮಾಡಿದವರು ಬೆಳಿಗ್ಗೆ.
Sir, ಇನ್ನೊಂದು ಹೇಳಿ, magistrate was very liberal. A2 was ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ವಾ? A2 moved an application for under section 70 sub-clause 2 for recalling the warrant. Recalling ಬರಲ್ಲ, ಇಲ್ಲಿ ಬಂದ್ರೆ ನೀವು ಕಸ್ಟಡಿ ತಗೋಬೇಕಾಗತ್ತೆ, ಹೋಗೋದು ಸೆಷನ್ ಕೇಸ್ಗೆ ಅಂತ ಹೇಳಿ ಕಳಿಸಿದ್ದಾರೆ. 70 application ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Again he has issued warrant. It shows that when you moved an application, you should be present in the court. You means accused. You means accused ಅಂತ ನಾನು ಜನರಲ್ ಹೇಳ್ದೆ. ಜನರಲ್ accused number 2 should be present before the court. But even then magistrate doesn't take him in custody.
What happened? 323 ಮಾಡಬೇಕಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿರ್ಬೇಕು. ಹೋಗಿ is committed a mistake there.
ಗೊತ್ತಾಗಿರ್ಬೇಕಂದ್ರೆ ನೀವು ಒಂದು ಅರ್ಜಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಏನ್ ಹೇಳ್ತೀರಿ? ಅಲ್ರಿ, ನಾನು ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. One offense is registered during the course of the after complete the tribal by the magistrate, complete trial ಮಾಡಿದ್ರು. Before pronouncement of judgment, he come to a conclusion that one of the offense to a tribal by the sessions court is also attracted. Then he registers a separate case. Two cases in respect of the same crime hang barutte. First issue. 323, what he says, if he comes to a conclusion at any stage of the proceedings that the matter is required to be triable by the session judge, he should act as per the provisions of 323 of CRPC and commit the matter by obtaining a bail because he is already on bail, with a direction to appear before the session judge, wherein the session judge has to frame a charge and to come a conclusion whether the charge as claimed by the magistrate is applicable or not. Question of learned magistrate taking fresh cognizance doesn't arise. ಅವರು ಇಷ್ಟ ಕಷ್ಟಪಡೋ ಬದ್ಲಿ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕಿ ಕ್ವಾಶ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಮುಗಿದು ಹೋಗ್ತಿತ್ತು. ಅವ್ರು ನಮ್ಮ ಪಕ್ಷ ಒಪ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಇವ್ರು ಒಪ್ಪಿಸ್ಬೇಕಾಗಿತ್ತು. ಅದು This petition is filed under section 438 of CRPC, seeking anticipatory bail in the event of arrest of the petitioner in CC number 550 of 2017, arising out of crime number 211 of 2017 of Harikere Police Station, registered for the offences punishable under section 345 of Immoral Traffic Act and section 370 and 70A of the IPC. The brief factual matrix leading to the case are that the present petitioner is accused number 1 and he was He was charge sheeted for the offenses punishment section 345 of Immoral Traffic Act. The trial was held before the magistrate, and during the course of the trial, he was enlarged on bail. She was enlarged on bail. The learned magistrate has recorded the entire evidence of the witnesses and posted the matter for judgment. While before pronouncement of the judgment, he noticed that apart from the offenses under section 3, 4, and 5 of Immoral Traffic Prevention Act 1956, the provisions of section 370 and 370A of IPC regarding trafficking are also attracted against the present petitioner. Hence, he, by order dated 4/3/22, taken cognizance of the said offenses under section 190B of CRPC for the offense under section 370 and 370A and issued process against the accused petitioner herein. The summons is said to have been served on the petitioner on 7/5/22 and on 27/6/22 warrant came to be issued. Records further disclose that on 21/6/22 itself he moved an anticipatory bail petition, but the same was rejected by order dated 11th July 22. Hence, the petitioner is before this court. Heard the learned public prosecutor, the learned counsel for petitioner and learned HCGP peruse the records. It is evident from the records that the petitioner is initially prosecuted in crime number 211 of 2017 for the offenses under section 345 of Immoral Traffic Prevention Act. FIR was also issued under the said provisions and subsequently charge sheet was also submitted. Further, the learned magistrate, after appearance of the petitioner, enlarged her on bail and subsequently charge was framed, which and the petitioner has pleaded not guilty. Trial was also conducted, and before pronouncement of the judgment, the learned magistrate came to a conclusion that the offenses under section 370 and 370A of IPC are also attracted. However, after coming to such a conclusion, he directly taken fresh cognizance of the offense under section 190B of the CRPC for the offenses punishable under section 370 and 370A of IPC by registering the fresh case in CC number 550.
I should check the 17.
CC number 550 of 2017 itself. It is surprising to note here that the learned magistrate has taken 2 cognizance in the same crime. Adike observe ಮಾಡ್ಕೊಳ್ತಾರೆ. He cannot take 2 cognizance. Cognizance ಒಮ್ಮೆ ತಗೋಬೇಕು. ಹೌದಾ? And bail ಕೊಟ್ಟಿದ್ದಾರೆ. Though no doubt the magistrate was of the opinion that offences alleged under section 370 and 370A of IPC are attracted, and under such circumstances his remedy was to exercise the powers under section 323 of CRPC and commit the matter to the sessions case for further, wherein a de novo trial is required to be held. But the magistrate has taken a fresh cognizance of the offense in the same CC, which is registered earlier itself after taking cognizance, and there is no provision for taking second cognizance next term. Apart from that, the trial is already concluded by the magistrate, and when he comes to a conclusion that the other offense is triable by learned session judge are required to be framed against the present petitioner, his remedy was to exercise powers under section 323 of CRPC, which reads as under excess 323. Hence, the entire approach of the learned session judge, learned magistrate was wrong. Apart from that, the petitioner was already on bail in CC number 550 of 2017. Under these circumstances, in my considered opinion, the petitioner can be admitted on anticipatory bail as there is no issue of tampering the prosecution witnesses, since the material witnesses have been already examined or may be required to re-examine before the sessions case. Accordingly, I proceed to pass the following order. The petition is allowed. Petitioner is ordered to be enlarged on anticipatory bail in the event of his arrest in CC number so and so, pending on the file of civil judge so and so, for the offences punishable under section 345 of Immoral Traffic Prevention Act and section 370 and 370A of IPC on her executing a personal bond in a sum of rupees 50,000 with one surety for like sum to the satisfaction of the learned magistrate, on subject to following conditions. Normal conditions. The petitioner shall surrender before the learned magistrate within 15 days from the date of receipt of the certified copy, and in the event of surrender, the learned magistrate shall release her on bail as directed above. Then the learned magistrate is directed to proceed in accordance with section 323 of CRPC. There is no representation on behalf of petitioner. Least after 2 weeks. ಓಪನ್ ಮಾಡ್ರಿ. Criminal petition number 3909 of 22. 3909 of 22 criminal petition ತೆಗಿರಿ. What is the name of the petitioner? Latif, son of Imam Hussain. Huh? That is not. Whether it is dismissed on merits or dismissed for non-prosecution. Non-plus. The hearing counsel for petitioner called out absent. Please the matter after 2 weeks. There is no representation on behalf of petitioner. Please after 2 weeks. No representation for 3 weeks.
Petition law with offense under section 406, 420, 149 of IPC Malone and section 9 of KPIT Act Malone. Petitioner has arrayed as accused number 10 Malone. In all Malone, there are 12 accused Malone. FIR is dated 4/7/2022 Malone. Prior to filing of this FIR Malone, Managing Director of Karnataka State Federal Cooperative Limited Malone on dated 23/3/2021 Malone had filed FIR against complaint against the present petitioners and 13 others Malone, wherein Malone the present petitioner was granted bail by the Honorable Trial Court Malone in page number 26 Malone, crime number 19 of 21. Page number 26 is the FIR registered by the Managing Director of Karnataka State Sahara Federal Cooperative Limited Malone, wherein Malone in that case Malone the present petitioner Malone had arrayed as accused number 7. In page number 35 Malone on dated 26/4/2021 the petitioner was granted bail Malone. After 1 year 3 months Malone another FIR came to be registered Malone for the same cause of action by one of the witnesses Malone. The complainant Malone is the shareholder in the society Malone. Petitioner is the managing director Malone. After 1 year 3 months Malone on dated 23/3/2021 Malone in crime number 19 of 21 the present complainant Malone was cited as the witness. Also, my lord, since my lord, the petitioner was already granted bail, none of the conditions were violated, my lord. He was regularly appearing before the IO. He was cooperating for the investigation, my lord.
Have you returned the deposited amount?
My lord, investigation is going on. They have collected few amount.
Asking you certain questions, madam. Have you ಒಂದು ವರ್ಷ ಆಯ್ತು ದುಡ್ಡು ರಿಟರ್ನ್ ಕೊಟ್ಟಿರಾ? ಡಿಪಾಸಿಟರ್ಸ್ ಶೇರರ್ಸ್ ದುಡ್ಡು ರಿಟರ್ನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ನಿಮ್ ಸ್ವಂತಕ್ಕೆ ಬಳಸಿಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಕೇಳಿ.
If I can take my lordship to page number 30.
ಕೇಳಿದೀನಿ ಹೇಳಿ. ಅದನ್ನ ಓದೋದಿತ್ತಂದ್ರೆ ನೀವು ಏನ್ ನಿಲ್ಲಬೇಕಾಗಿಲ್ಲ. ನನ್ನಷ್ಟು ನಾನು ಓದ್ಕೊತೀನಿ. ನನಗೆ ಫ್ರೀ ಆದಾಗ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ. ಆಯ್ತು ಹೊರಟ್ಬಿಡಿ, ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ ನಾನು.
I'll answer, my lord.
ಅದನ್ನ ಕೇಳಿದ್ ಬಿಟ್ಟು ಅಲ್ಲ ಪೇಜ್ ನಂಬರ್ so and so ನಿನ್ನೆ I trust you, madam. You are officer of the court. ನೀವ್ ಏನ್ ಹೇಳ್ತೀರಿ ನಂಬ್ತೀವಿ ನಾವು unless the other side raises issue.
I was just
ನಾನು ಸಿಂಪ್ಲಿ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ದು 1 ವರ್ಷ ಮುಂಚೆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ. Some of the official has lodged a complaint. Correct? Similar complaint regarding return of the deposit amount to the shareholders. Again, ಕೊಟ್ಟಿದ್ದೀರಾ?
My lord, investigation officer has recovered amount from accused number 164.
ನಿಮ್ ಕಡೆಯಿಂದ ನೀವ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ? Still you are working there. What is your status?
Through me, there is no recovery.
What is your status?
I'm one of the directors of the society, my lord.
So you are one of the director. You have collected a huge amount, more than 2 crores from depositors.
My lord, that is not.
It is a recurring cause of action.
My lord, that allegation is that, my lord, that accused number
Allegation of the ಪ್ರಶ್ನೆ ಅಲ್ಲ. I am not talking about allegation. ನಾನು ಪ್ರಶ್ನೆ ಮಾಡಿದ್ದು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಕ್ಕಂತೂ ಏನೂ ಇಲ್ಲ. ಎಲ್ಲಿ ಹೋಯ್ತು ದುಡ್ಡು?
My lord, if I can make a submission, my lord, in this matter, the petitioner, who is a managing director, he has not collected the money nor he has misused the money, my lord. The same observation is made by the honorable trial court. Only
Madam, what is the duty of the managing director?
If I can.
Since you are arguing that the trial court has observed that managing director has not done. Now I'll go to the deeper. What is the duty of the managing director? Why he should be there? He is the responsible for the whole business of the society, credit society. And you are arguing that I have not collected. At whose instance then it is collected? It is only you. At your instance only it is collected.
The allegations are that, my lord.
And you are a managing director as well as the director of the company.
One of the managing directors of the company.
Then you are equally responsible. ದುಡ್ಡು ಏನ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲ, ಬೇಲ್ ಇದ್ರ ಅಂತೆಲ್ಲ. ಪೂರ್ ಪರ್ಸನ್ಸ್ ದುಡ್ಡು ಮಜಾ ಮಾಡೋರ್ಗೆ ಮರ್ಯಾದೆ ಕೊಡಕ್ ತಪ್ಪಾಗುತ್ತೆ.
The investigation officer, my lord, has been conducting investigation. I've been regularly appearing before the IO. They have.
ಮೇಡಮ್ ರೆಗ್ಯುಲರ್ಲಿ ಅಪಿಯರಿಂಗ್ ಬಿಫೋರ್ ಐಯೋ ಬೇಡ. ಅವ್ರ ಪಾಪ ಅವ್ರು ನೀವು ಅಪಿಯರ್ ಆದ್ರೆ ಎಷ್ಟು ಬಿಟ್ರೆ ಎಷ್ಟೇ. ಅವ್ರಿಗೆ ಬೇಕಾಗಿದ್ದು ಅವ್ರು ಕಷ್ಟಪಟ್ಟು ದುಡ್ದಿದ್ದು ದುಡ್ಡು, ಅದನ್ನೊಂದ್ ಬಿಟ್ಟು ನಾನು ಅಲ್ಲಿ ಹಾಜರಾಗ್ತಾ ಇದ್ದೀನ್ರಿ ಅಂತ ಹೇಳಿದ್ರು.
Investigation is going on, my lord.
Recurring cause of action. What do you have to say?
If I can only make a.
Recurring cause of action ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀರಾ ಅಂತ ಕೇಳಿದೀನಿ.
I am only on before my lordship in crime number 33 of 22, wherein, my lord, already an FIR was registered. Subsequent to filing of that, my lord.
ನೀವೇ ಅರ್ಥನೇ ಮಾಡ್ಕೊಳ್ತಾ ಇಲ್ಲಲ್ಲ.
Just clarifying it to my lordship.
I don't want that. You have the earlier there was a complaint. Investigation is going on. You are enlarged on bail. Fine. Subsequently, another complaint is filed. Still, you are not prepared to refund the any amount.
That is not the submission that I made, my lord. My lord, recovery of the amount is made by the co-accused. There is not.
How much made?
That is not brought to my knowledge.
No, you are a managing director, and it is not within your knowledge. Very surprising. All the transactions were without your knowledge.
Recovery.
I want how much amount was recovered.
I will rectify with that and get back.
Next.
Please.
ಅದಕ್ಕೆ ಕೇಳಿದ್ನ ರಿಕವರಿಂಗ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತ ಬಗ್ಗೆ ಕೇಳಿದ್ದು. ದಟ್ ಇಂಟೆನ್ಷನ್ ಓನ್ಲಿ ನೋಡಿ.
Also, my lord, in this, the complainant in this case.
ಮೇಡಮ್ ಬೇಡ ಅದು.
I should at least be heard, my lord.
ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ ಮತ್ತೆ ಅದಕ್ಕೆ ನಾನು ನೀವು ಅಲ್ಲಿ ಕಮ್ ಬ್ಯಾಕ್ ಅಂತ ಹೇಳಿದ ಮೇಲೆ ನೀವು ಟೈಮ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಐ ಆಮ್ ಹಿಯರಿಂಗ್ ಯು ಮೇಡಮ್, ನಿಮ್ಗೆ ಅಪಾರ್ಚುನಿಟಿ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಅದೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇ ಆಯ್ತು ಅಲ್ಲಿ ಕಮ್ ಬ್ಯಾಕ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಯಸ್ ಅಂತ ಹೇಳಿದೀನಿ. ಯು ಆರ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಆಸ್ ಇಫ್ ಐ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್. Not required at this juncture, because what is the position you come by, how much amount is recovered, ಹೇಳಿ ನೋಡೋಣ, then we will consider it. Is the matter on 27th.
Section 439 of CRPC. Petitioner is arraigned as an accused of two for alleged offences 20B, 21B of NDPS Act. Is arrested on 29/7/2022 in crime number 102 of 2022 by Blackmailing police station. As per the allegations by the respondent police, seized was 3 kgs of ganja and 17 grams of MDMA. In this case, my lord,
What is the commercial quantity described regarding MPMA?
10 grams.
10 grams. You were found in 17 grams of MPMA plus 3 kg of ganja, cannabis plant. Commercial quantity, one is commercial quantity, one is intermediate quantity.
In this case, my lord, the entire seizure margin does not disclose from whom that quantity has been seized. From the accused number 1 or accused number 2, it was not disclosed. And they have not been followed any rules of 42+2 of NDPS Act also. By the information should have been taken written from the superior officer.
Information taken in
Yes, my lord, I am not.
information ತಗೋಬೇಕಲ್ಲ. Law section 42 says that he should intimate, only intimation, not permission. Go through section 42, it doesn't say permission from the higher officer, it simply says that immediately after intimation should be delivered to the higher officers. That was done, matter ends there.
The seizure margin itself is doubtful, madam.
That is open for you during the course of the trial. Now we cannot snub the investigation itself.
It is returned to the family past 2.5 months.
You are worried about his bread earning. You are not worried about the economy of the entire state. He is being targeted because of these offences. That is to be decided during the course of the trial. Recovery is prima facie available. Section 35 of the NDPS Act is against you. How you overcome section 35 at this juncture? Presumption is in favor of the prosecution.
And it was not been anything has been disclosed to you by the investigation. Nothing has been disclosed from whom it was seized.
Madam, you have not gone through the measure in proper way. From the present petitioner, 17 grams of MDMA is seized.
complaint says does not say that.
Sir, complaint says, but seizure measure makes much importance. Not complaint. Oh, there, page number 27 and 28. The ganja is seized from accused Srinivas. Ganja is seized from accused number Srinivas, and this 17 gram of MDMA is seized from present petitioner. ಓದ್ತಾನೆ ಇಲ್ಲ ಅದನ್ನ ಓದಿದಿರಿ ಮತ್ತೆ why you are making a contradictory statement?
Contradiction is there between the complainant and the as well as remand application. Complaint never says that that they have seized from the.
Madam, complainant ಏನ್ ಹೇಳ್ತಾನೆ relevancy ಆಗೋದಿಲ್ಲ. Seizure measure becomes more important. Complaint is only setting the law in motion. Seizure measure is there. And all these arguments holds good during the course of the trial, not now. And you are found in possession of 17 grams of MDMA. What is your explanation? It is a commercial quantity. Mate, what is your explanation? You are targeting younger generation, entire society. It also affects the economy of the state. That is to be considered during the course of the trial, madam. No, you are not entitled for bail, madam. The petitioner has filed this petition under section 439 of CRPC, seeking petitioner bar accused number 2, seeking regular bail in crime number 102 of 22 of Bayappanhalli police station, registered for the offence punishable under section 20B and 21B of NDPS Act. The brief factual matrix leading to the case are that on 29/7/22 at 1 p.m. when the complainant has received a credible information that near BML compound on Suranjan Das Road, Bayappanhalli, Bangalore, 2 persons are trying to sell narcotic drugs to the customers. Immediately after receiving the information, he has informed the same to the higher officers, and then he, along with Pansas and staff, went to the spot and apprehended the present petitioner and accused number 1. On search, the accused number 1 was found in custody of 3 kg of ganja, while present petitioner was found in possession of 17 grams of MDMA. The same was seized by the investigating officer, and as such, this crime came to be registered. The petitioner was arrested after recovery and he was remanded to judicial custody. He filed a bail petition before learned session judge, and same came to be rejected. Hence, he is before this court. Next, third, the learned counsel for petitioner and learned HCGP, there is the cause. The learned counsel for petitioner would contend that the petitioner has been falsely implicated and the complaint allegations are vague and does not disclose as to from whom the narcotic drugs were recovered. She would also contend that the petitioner is in custody since long and he undertakes to abide by the terms and conditions, and as such sought for admitting the petitioner on bail. Per contra, the learned SCGP would seriously object the bail petition contending that 17 grams of MDMA is recovered from the custody of the present petitioner, which is more than commercial quantity, and there is no explanation. Hence she would contend that matter is still at the stage of investigation and as such sought for rejection of the bail petition. Having heard the arguments and perusing the reports, the merger disclosed that the present petitioner was found in possession of 17 grams of MPMA, which is more than commercial quantity. Though the learned counsel has all along argued that there is no clarity regarding recovery from individual accused, but the merger and the complaint clearly established that 17 grams of MPMA was recovered from the custody of the present petitioner, who is arraigned as accused number 2. Though the learned counsel for petitioner contended that the provisions of section 42 of the NDPS Act are not complied with, the same cannot be accepted as the prima facie records produced by the prosecution disclose that the complainant, after receiving the credible information, has intimated his higher officers, and that itself suffice to hold that there is due compliance at the juncture. Further, the petitioner was alleged to be found in possession of 17 grams of MPMA, and the presumption under section 35 is in favor of the prosecution. No material evidence is placed by the petitioner to rebut the said presumption. The offense is against the society and especially targeted against the younger generation, and it is likely to affect the economy of the state also. Under these circumstances, such offenses cannot be taken in a light way, and looking to the nature and gravity of the offense, this is not a fit case wherein the discretion can be exercised in favor of the petitioner. Hence, petition is devoid of any merit and accordingly stands dismissed. The other counsel for petitioner called out absent. List the matter finally after 2 weeks for compliance of office objections, failing which the matter shall be listed for dismissal. Adjourn again. The other counsel for petitioner called out absent, list after 2 weeks. The legal counsel for petitioner called out absent. Office has raised objections regarding non-service of the judgments to the HCGP, and he has made submission before the office that he is going to serve the citations served. The learned counsel for petitioners, learned HCGP submit that the memo of citations have been served on the HCGP. The learned counsel for petitioner absent, list after 2 weeks. Forcible miscarriage case, The learned counsel for petitioner called out absent, no representation, list after 3 weeks. Adjourned. ನಾನು ಏನ್ ಯಾರಿಗಾರ ಹೇಳ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. Saturday ಹಾಕೊಟ್ಟು Saturday. This Saturday is working day. ಆಯ್ತ್ರಿ Saturday ಅಂತ ಹೇಳಿದ್ದೀನಿ. serial number 62. 2 weeks with Saturday ಇಟ್ಕೊಟ್ಟು. The memo of citations record ಮಾಡಿದ್ದೀನಿ. For representation on behalf of petitioner, list of 30 weeks. For representation, list of 30 weeks.
Petitions under 438.
Offense is under section 327. Have you gone through the order of the learned magistrate, the session judge? What is the observation of the session judge?
The offense is.
What is the observations of the session judge?
They face that the accused have not only assaulted the accused, also snatched 1 lakh. The offense is of grievous nature.
327 apply ಆಗೋದಿಲ್ಲ, 394, 395 398 apply ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ observation ಮಾಡಿದ್ದಾರೆ.
It is a submission of the prosecutor.
ಸರಿ ಹೇಳಿ ನೋಡೋಣ. Why, what is the page number of complaint?
There should be typed copies in page number 12. The victim and should be.
Yes, ಹೇಳಿ.
Belong to same village.
Yes.
Page number 12. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು ತರಕಾರಿ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡಿದ್ದು. ನನ್ನ ಹೆಸರಿನಲ್ಲಿ K18B1892 ಮಹೀಂದ್ರ ಪಿಕಪ್ ವಾಹನವಿತ್ತು. ಪ್ರತಿದಿನ ಮೈಸೂರಿಗೆ ಹೋಗಿ ತರಕಾರಿ ಖರೀದಿ ಮಾಡಿ ಹಾಸನ, ಬೇಲೂರು, ಚಿಕ್ಕಮಗಳೂರು ತಂದು ಮಾರುತ್ತಿರುತ್ತೇನೆ. ಎಂದಿನಂತೆ ದಿನಾಂಕ 15/8/2022 9:30 ಗಂಟೆಗೆ ತರಕಾರಿ ತರಲು ವ್ಯಾನ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಮೈಸೂರಿಗೆ ಹೊರಟೆನು. ನನಗೆ ಪರಿಚಯವಿರುವ ಹೊಸಮನೆಹಳ್ಳಿ ಮೋಹನಣ್ಣನವರು ಮೈಸೂರಿಗೆ ಬರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದು, ಅವರನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಲು ಬೇಲೂರು ಸಾಚನ್ನಪುರ ಗ್ರಾಮದ ರಸ್ತೆಯಲ್ಲಿ ರಾತ್ರಿ 10 ಗಂಟೆಗೆ ಹೋಗುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿನ ಬಾರ್ ಮುಂಭಾಗ ನಮ್ಮೂರಿನ ಹರೀಶ್, ಪ್ರಭು, ದೇಗಲಾಪುರ ಕಂಸಗಾರಪ್ಪ ನಿಂತಿದ್ದು ನನ್ನ ವ್ಯಾನ್ ಅನ್ನು ಅಡ್ಡ ಹಾಕಿದರು. ನಾನು ವ್ಯಾನ್ ಅನ್ನು ನಿಲ್ಲಿಸಿದಾಗ ಅವರು ನನಗೆ ಕುಡಿಯಲು ಹಣ ಕೊಡು ಎಂದು ಕೇಳಿದರು. ನಾನು ಇಲ್ಲ ಎಂದು ಹೇಳಿದರೂ ಸಹ ಬಿಡದೆ ಗಲಾಟೆ ಮಾಡಿದರು. ನಂತರ ನಾನು ವ್ಯಾನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಕೊಡನಹಳ್ಳಿ ಹತ್ತಿರ ಹೊರಟೆನು. ಪುನಃ ಹರೀಶ್, ಪ್ರಭು, ಕಂಸಗಾರಪ್ಪನವರು ಬೈಕಿನಲ್ಲಿ ನನ್ನನ್ನು ಹಿಂಬಾಲಿಸಿ ಅಡ್ಡಗಟ್ಟಿದರು. ನಂತರ ಮೂವರು ಸೇರಿ ನನಗೆ ಕೈಗಳಿಂದ ಮುಖಕ್ಕೆ ಹೊಡೆದು ನೋವುಂಟು ಮಾಡಿದರು. ನಂತರ ಪ್ರಭು, ಕಂಸಗಾರಪ್ಪ ವ್ಯಾನ್ ನಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ನಮ್ಮನ್ನು ಹ್ಯಾಂಡ್ ಪೋಸ್ಟ್ ಹತ್ತಿರ ಬಿಡು ಎಂದು ಹೆದರಿಸಿದರು. ನಾನು ಕೋಡನಹಳ್ಳಿಯಿಂದ ವ್ಯಾನ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಹ್ಯಾಂಡ್ ಪೋಸ್ಟ್ ಗೆ ರಾತ್ರಿ 12 ಗಂಟೆಗೆ ಬಂದೆನು. ಹರೀಶ್ ಬೈಕ್ ನಲ್ಲಿ ಬಂದನು. ನಂತರ ವ್ಯಾನ್ ನಿಲ್ಲಿಸಿದ ಕಂಸಗಾರಪ್ಪ, ಪ್ರಭು ವ್ಯಾನ್ ನಿಂದ ಕೆಳಗೆ ಇಳಿದು ನನ್ನನ್ನು ಹೊರಗಡೆ ಎಳೆದು ನನಗೆ ಕುಡಿಯಲು ಹಣ ಕೊಡುವುದಿಲ್ಲ ಎಂದು ಮಗನೇ ಎಂದು ಬೈದು ಕಂಸಗಾರಪ್ಪ ವ್ಯಾನಿನಲ್ಲಿದ್ದ ಜಾಕ್ ಲಿವರ್ ತೆಗೆದುಕೊಂಡು ನನ್ನ 2 ಕೀಲು ಹತ್ತಿರ ಬಲದ ಕೆನ್ನೆಗೆ ಎಡದ ಕೆನ್ನೆಗೆ ಹೊಡೆದು ಗಾಯಗೊಳಿಸಿದನು. ನಂತರ ಕಂಸಗಾರಪ್ಪ, ಪ್ರಭು ರವರು ತರಕಾರಿ ವ್ಯಾಪಾರಕ್ಕೆಂದು
ಜೈಲಿನಲ್ಲಿಟ್ಟಿದ್ದ 1.5 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣವನ್ನು ಕಿತ್ತುಕೊಂಡರು. ಅಷ್ಟರಲ್ಲಿ ರಾಮನಹಳ್ಳಿ ವಾಸ ಪುಟ್ಟೇಗೌಡ ಕಾರ್ತಿಕ್ನವರು ಗಲಾಟೆ ಬಿಡಿಸಲು ಬಂದಾಗ ಅವರಿಗೆ ಸಹ ಮೇಲ್ಕಂಡ ಹರೀಶ್ ಶಂಕರಪ್ಪ ಪ್ರಭುನವರು, ನಾನು ಕಂಸಗಾರಪ್ಪ, ಈತನು ಜಾಸ್ತಿಯವರಿಂದ ಜಾಮೀನ ಮುಂಭಾಗದ ಗ್ಲಾಸಿಗೆ ಹೊಡೆದು ಜಖಂಗೊಳಿಸಿದ್ದನು. ಗಾಯಗೊಂಡ ನಾನು ನನ್ನ ವ್ಯಾನಿನಲ್ಲಿ ರಾತ್ರಿ 2 ಗಂಟೆಗೆ ಬಂದು ಚಿಕಿತ್ಸೆಗೆ MG ಆಸ್ಪತ್ರೆ ದಾಖಲಾಗಿದ್ದೇನೆ. That is the allegation.
327 ಬರುತ್ತಾ, ಇದು 394 onwards ಬರುತ್ತಾ? Allegations I am talking. 327 ಬರುತ್ತಾ, 394 and onwards ಬರುತ್ತಾ? You are the best person now. ನೀವೇ ಹೇಳಿ.
392.
ನೋಡಿ 392 ನೋಡಿ ingredients.
Robbery. The complaint is, Your Lordship, exaggerated version of the true incident. Your Lordship, the victim and the accused belong to same village. And Your Lordship, the incident took place from the, Your Lordship, 37 kilometers from the village in which they are residing.
ನಾನು ಕೇಳಿದ್ದು ಯಾವ ಪ್ರೊವಿಷನ್ ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಕೇಳಿದ್ದೀನಿ. ಫಸ್ಟ್ ಮೊದಲು ನನಗದನ್ನ ಹೇಳಿ. How many accused are involved? 3 involved. It is the case of robbery. ಯಾವ ಅಪ್ಲಿಕೇಶನ್ 394 ಅಪ್ಲೈ ಆಗುತ್ತೆ? IO 327 ಕೆಳಗೆ ಹಾಕ್ಯಾರ, 427 ಕೆಳಗೆ ಹಾಕ್ಯಾರ, ಕ್ಲೋಸ್ ಆಗುತ್ತಾ? ಸರಿ ಹೇಳಿ. It is imprisonment for life.
10 years.
ಸರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ 394.
But 327 is 10 years.
327 ಬರುತ್ತಾನ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. When there is a robbery and during the course of robbery, if an injury is being caused, 394 is applicable. 394 is punishable with imprisonment for life, or which may extend to 10 years.
Your Lordship, according to them, it is extortion. Your Lordship, they have extorted money.
What is the difference between extortion and robbery?
Extortion, Your Lordship, they have Your Lordship sought for money.
No, I am asking you, what is the difference between extortion and robbery?
Robbery, Your Lordship, were theft. Your Lordship, with the apprehension of causing danger to the life. Where extortion, Your Lordship, the threat has committed, Your Lordship, committing, seeking for money.
What is the definition of robbery?
Yes, sir. 319, Your Lordship. In all robbery, there is either theft or extortion.
So extortion is part of robbery.
CH-27 also applicable.
327 ಹೇಗೆ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಸರ್? What is the relevancy of 327?
It is matter of trial, but Your Lordship, police in Your Lordship, prima facie has the Your Lordship for.
Sir, ಯಾವ argument ಮಾಡಿದ್ದಾರೆ?
It is a case of prosecution, Your Lordship. They have to argue before the trial court. Your Lordship, during the trial, because it is Your Lordship, or change the charge, or during the charge. As of now, Your Lordship, 327. Where Your Lordship?
Sir, when the extortion amounts to robbery, definition is also given in section 390. Go through it.
Extortion is robbery if the offender at the time of committing the extortion is in presence of person put in fear and commits the extortion by putting that person in fear of instant death, of instant hurt, or instant wrongful restraint to that person or to some other person. By putting in fear, induces the person to put in fear that then and there to deliver up the thing extorted. Lordship, it is said in complaint that he has taken the money. It is not, Lordship, it is demanded.
So snatching the money is not the demand.
According to his Lordship,
So
he has
only if by threatening demand is made, then it becomes robbery. If you snatches, it is not a robbery, according to you.
this extortion, Lord. The complaint is what says, they have demanded money by stopping the van. And in Lordship,
He
incident,
did not give the amount. You snatched it away.
they have sought for, initially they have sought for, beating.
Sir, like, what is the definition is when theft is a robbery.
Yes, ma'am. But insofar as this complaint is concerned, Lord,
Whether the offense is attracted on the basis of the ingredients of the complaint, the recitals of the complaint, which ingredients are attracted, or a complaint on the section hakid kudle ade accept
that state
madbeka.
has to answer, Lordship. Why
State
they have
answer.
attracted-
Then why the court should be there? It is the duty of the court.
It's the duty of court, Lordship, during the hearing of charge. But Lordship, during this.
So at this juncture, according to you, while considering the bail petition, the court cannot go into the merits of the complaint regarding which offense is attracted. Whatever is quoted by the concerned IO or SHO, that is to be blindly accepted without application of mind by the court. That was your argument there.
Under submission is Lordship. Without Lordship, Lordship, only allegation has to be seen. Whether prima facie allegation is made out of.
I'm talking about allegation only.
Allegation, only complaint has to be looked into.
But the complaint no ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವನು ಹೆದರಿಸಿ ಹೊಡೆದು ದುಡ್ಡು ಕಸ್ಕೊಂಡ್ರೆ ಏನಾಗುತ್ತೆ?
That is allegation. That is allegation. That is what.
Sir, at this juncture, everything is an allegation. At this juncture, everything is an allegation.
My version is not.
Your version is required to be tested only during the course of the trial. You are not yet called. You are not yet called to disclose your defense. If you are willing to disclose your defense at this juncture, nobody will prevent you. Consequences, you should think.
My humble submission is, Lordship, only complaint element has to be looked into. And my Lordship, my humble submission is the exaggerated version of complaint. And Lordship, incident took place, Lordship, beyond 37 kilometers from the village. And Lordship, the initial para of the complaint, it says that Lordship, they have demanded money for purpose of drinking. And there is no, Lordship, initially there is no, Lordship, intention to commit robbery or dacoity. Yes. Initially there is no intention to commit robbery or dacoity.
Initially, intention was not there.
Complainant himself, they are known persons.
Do you mean to say that only unknown person should commit an offense of robbery or dacoity?
But yes, it's the exaggerated version of complaint.
Sorry.
The allegation, they are the known persons.
Yes, next.
My apprehension is Lordship, I will be harassed and I will be Lordship falsely implicated in the case.
No, sir. You are not entitled for anticipatory bail.
Lordship,
Looking to the nature and gravity of the offense, you are not entitled for anticipatory bail.
the gravity of offense, Lordship.
The session judge has also observed the same thing, which now.
But Lordship, there is no.
Then I'll dictate.
There is no Lordship of evidence, Lordship, or proof to regarding the.
There is no always complaint or immediately proof. Crime is registered. Proof and other things will come later on. What is the vengeance between complainant and yourself to lodge a false complaint against you?
That is Lordship, that belongs to the same image.
What is the vengeance? What is the grudge? To falsely implicate you, you should be knowing. What is your defense then?
There is the complaint itself is called self-contradictory. Kindly we have raised complaint, Your Lordship.
ಓದಿದ್ದೀರಿ ಅದನ್ನ?
I will not raise complaint, Your Lordship. Sir.
2:30 ಓದಿ. 2:30 ಓದಿ. 2:30. ನಾನು 2:30 first case.
Serial number 75, representing the NCB, the lot of kindly grant 1 week time. Learning me to file the statement of objection. 75.
75. Who is the other side? Aurilla.
Representing the NCB.
Correct. Sir, correct, sir. Our presence or date ಕೊಡ್ತೀನಿ ನಾನು ಡೇಟ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. But when case reaches, if he is not there, I'll accommodate you. Even if he is present, I'll consider your prayer to accommodate. That I'll promise. But our absence ಕೊಡೋದು ತಪ್ಪಾಗುತ್ತೆ ಅಷ್ಟೇ. ಅದೇ ಪ್ರಿಲಿಮಿನರಿ ಬೋರ್ಡ್ ಇಬ್ರು ಜೊತೆಯಲ್ಲಿ ಇದ್ರೆ ಡೇಟ್ ತಗೊಂಡು ಹೋಗಿ ನಂದು ಏನು ತಕರಾರಿಲ್ಲ. Because he may be under impression that serial number so and so running, my serial will come, my number will come at later hours. So he may not be interested to represent at this junction. We'll consider it. In prayer, consider Martin. No, I'm not rejecting your prayer, but as and when the case reaches, we can submit.
ಸರ್ ಜಾಧವ್ ಸರ್, ಶ್ಯಾಮ್ ಮಾತಾಡ್ತೀನಿ.
ಹಾ ಹೇಳಿ.
ನೀವು ಮಧ್ಯಾಹ್ನ ವಿಸಿನಲ್ಲೇ ಬರ್ತಿರೋ ಫಿಸಿಕಲ್ ಬರ್ತಿರೋ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಬರ್ತಾನೆ.
ಅಲ್ಲಿ ಅಲ್ಲ, ಸೀನಿಯರ್ ಬಟ್ ವಿಸಿನಲ್ಲಿ ಇರ್ತಾರಲ್ಲ ಸರ್.
ಅವ್ರ ಸೀನಿಯರು ಅಲ್ಲಿ ಇರ್ಲಿ, ನಾವು ಅಲ್ಲಿ ಇರ್ತೇನೆ.
ಅಲ್ಲಲ್ಲ, ಸೀನಿಯರು ವಿಸಿನಲ್ಲಿ ಇದ್ರೆ ನಾವು ವಿಸಿನಲ್ಲೇ ಇರೋಣ.
ನೋಡೋಣ.
ಎಲ್ಲ ಏನ್ ಮಾಡೋಣ ಸರ್? ನೀವು ಬರ್ತೀರಾ ಫಿಸಿಕಲಿ?
ಹೌದು, ನಾ ಬರ್ಬೇಕಂತ ಮಾಡೇನಿ.
ಹೌದಾ ಸರ್? ಹಾಗಾದ್ರೆ ನಾನು ಜಾಧವ್ ಸರ್ ಇದ್ರಲ್ಲಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇರ್ತೀವಿ ಸರ್, ತಾವು ವಿಸಿನಲ್ಲಿ ಬರ್ತೀರಲ್ಲ ಸರ್?
ಹೌದು, ಸೀನಿಯರ್ ವಿಷಯಲ್ಲೇ ಇರ್ತಾರೆ.
ಆಯ್ತು ಆಯ್ತು.
ಸೀರಿಯಲ್ ನಂಬರ್ 76 ಅವ್ರು ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ ಬಂದಿಲ್ಲ ಅಂತ ಸರ್, ಅದಕ್ಕೆ ಸಾಟರ್ಡೆ ಕೈಂಡ್ಲಿ ಔಟ್ ಸಾಟರ್ಡೆ. ಆಫೀಸರ್ ಕೇಳ್ಬೋದು
ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ
ಅವರು ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಅವ್ರು ಬಂದ್ರೆ ನಾನು ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ನಂದೇನ್ ತಕರಾರಿಲ್ಲ.
ಅವ್ರು ಇನ್ಫಾರ್ಮ್ ಮಾಡೋ ಕೇಳ್ಕೊಂಡು
ಅಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದಲ್ಲ, ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀನಿ, ಅಬ್ಸೆನ್ಸ್ ಬೇಡ. ನಾನು ನಿಮ್ಗೆ ಅಕಾಮಿಡೇಟ್ ಮಾಡ್ತೀನಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಅಲ್ಲ ಅವ್ರು ಬಂದ್ಮೇಲೆ ಹೇಳ್ಬೇಕು.
But I was asking you one question. What is the any possibility in this party? They are the reason of presence.
Asking you grudge.
Yes, that is what. But there is a property dispute between the.
Very good. What is the evidence?
If I through the phone.
What is the evidence?
ಯಾವ ಕೇಸು? It is not 79.
Relatives property dispute. It is simple, no? That cannot be ground. Yes, ಹೇಳಿ Naresh ಹೇಳಿ.
They participate in the investigation, but there is no set of playing not. But they participate in investigation. Reasonable conditions they will comply with.
Yes, then next.
Whether it version of complaint.
Yes, what you want to say? Going to dismiss it, sir. Going to dismiss it. Such matters we cannot exercise the discretion blindly.
Not as per the prosecution, new certificate has not been issued.
You have argued. If you want to further argue, you can argue. I'll not come in with you. I'm going to dismiss and ಹೇಳಿದೀನಿ. Petitioner, this petition under section 438 of CH-27 seeking anticipatory bail in the event of his arrest in crime number 278 of 22 on the file of Chikmagalur Rural Police Station, registered for the offences punishable in section 327 of IPC. The brief factual matrix leading to the case are that on 15/8/22 at 9:30 p.m. the complainant was proceeding to Mysore in his Mahindra pickup van bearing registration KA 18B 1892 in order to bring the vegetables. That one Osamane Halli Muhammad was accompanying him, and at 10 a.m. when they were going near Channapur village in Belur Taluka, in front of the bar, accused persons stopped the vehicle and asked the complainant to give money for consuming the alcohol. When the complainant refused, the accused quarreled with him. Then the complainant was proceeding in his vehicle, and near Kodanhalli, the accused persons followed him in their bike and restrained the complainant by stopping the vehicle and again demanded the amount for consuming the liquor. When the complainant again refused, the petitioners assaulted the complainant with hands on his face, and later on they asked him to drop them near hand post. At about 12 in the midnight, when they reached the hand post, accused number one came there on the accused number one, petitioner number one came there on motorbike, and the petitioners 2 and 3 dragged the complainant from the van and again demanded the amount and abused him in Hindi language. The petitioner number 3 took a jack lever and assaulted the complainant on both ears, chest, left hand, and they have also snatched 1,50,000 from the complainant. When Puttegowda and Karthik came there, the accused persons abused them in Hindi language, and they have also damaged the vehicle of the complainant. In this regard, the complaint came to be lodged. The petitioners, apprehending their arrest, now approached this court, approached the sessions court, and the learned session judge has rejected the bail petition. Hence, the petitioners are before this court. Third, the arguments advanced by the learned counsel for petitioner and learned HCGP. The learned counsel for petitioner contend that the offence alleged is under section 327 of IPC, and the petitioners are known to the complainant, and there is no question of robbery or extortion. He would further contend that in order with a grudge, a false complaint has been filed. He undertakes to abide by the terms and conditions to be imposed by this court, and hence he sought for admitting the petitioners on bail. Per contra, the learned HCGP would seriously object the bail petition, contending that to the offence under section 327 of IPC is mentioned, considering the allegations made in the complaint, the offences under section 394, 397, and 398 are attracted, which are heinous in nature, and hence they would contend that recovery is yet to be made, as there is robbery of 1,50,000, and as such, they would seek for rejection of the bail petition. Having heard the arguments and perusing the reports, the allegations of the prosecution disclosed that accused intercepted the complainant, then assaulted him by jack lever and robbed the sum of 1,50,000. The FIR, the offence under section 327 is quoted, which is voluntarily causing hurt to extract property or constrain to an illegal act. But the allegations made in the complaint clearly disclose that it is not only an attempt to extract, but the complainant was assaulted and extortion was made, and it falls directly under section 494 and 497 of IPC, as in the course of committing the offence, the complainant was assaulted. Hence, the contention of the learned counsel for petitioners that only offence under section 327 is quoted or attracted holds no water, as the definition of 390, section 390 makes it clear what is the offence under section robbery and defaulting with reference to extortion and theft. The allegations of the prosecution disclose that rupees 1,50,000 were already robbed from complainant, and as per the case of the prosecution, recovery is essential. Under these circumstances, looking to the nature and gravity of the offence, this is not a big case wherein the discretion can be exercised in favor of the petitioner, and the remedy for them is to surrender before the learned magistrate to the concerned police and cooperate with the investigation. Hence, the petition is devoid of any merits and needs to be rejected. Accordingly, petition stands dismissed. ಅದೇನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಆಡಿಸ್ಕಿಲ್ಲ, ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ವೇಟ್ ಮಾಡ್ತಾರೆ.
Page number 13.
Is filed in section 302 of CRPC by defective complainant to assist the prosecution. Have you got any objections?
I do not have any objection as
In
such.
fact, I need not ask you, but because it is the between the court and the complainant.
Complaint. But
However, he cannot argue, he can only assist the
yes,
prosecution.
yes.
Considering the grounds as I1 of 22 is.
I would like to.
Allah, merits me here, I'll hear you. No problem. First, I'll dispose of this IO. Considering the grounds, I1 of 22 is allowed and effective complainant is permitted to assist the prosecution. He has also filed statement of objections which were taken on report. Yes. Sir, you have no right to submit directly to the court. You are only permitted to assist the prosecution. You are not right to have submission is not there. You cannot address the court in any way.
Document number 2, page 13, typed copy of the first information.
Page number of
13.
Yes.
Piriyapatna Police Inspector ಅವರ ಸಂವಿಧಾನಕ್ಕೆ, that is dated 27/8/2022.
Yes.
So, ವಾಸವಾಗಿನ ಮಂಜುನಾಥ್ ರವರ ಮಗಳು ಪದ್ಮಿನಿಯಾದ ನಾನು ಬರೆದುಕೊಂಡ ಪಿರಿಯಾಡ್. This Manjunath is a legal practitioner which has come on record. ನಾನು ಈ ದಿನ ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 9 ಗಂಟೆ ತಾರೀಕು 27/8/2022 ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡ ಸುಪ್ರೀತ್ A1 ರಾವ್ ಅವರು ಇಲ್ಲ, ಇಲ್ಲಿ ಶ್ರೀಮತಿ ಕೀರ್ತಿ ಅವರು ಇಲ್ಲ, ಪ್ರವೀಣ ಅವರು ಇಲ್ಲ, ನನ್ನ ಚಿಕ್ಕಪ್ಪನ ಹೆಂಡತಿ ರೂಪ ವೈಫ್ ಆಫ್ ಲೇಟ್ ಪ್ರಸನ್ನ ಕೇಶವ ಹಾಗೂ ಅವರು ರೂಪ ಇಸ್ ದಿ ಪಿಟಿಷನರ್. ನನ್ನ ಚಿಕ್ಕಪ್ಪನ ಮಗ ನಾಗಭೂಷಣರವರುಗಳು ನನ್ನ ಗಂಡನ ಕಾರಿನಲ್ಲಿ ಅಂದರೆ ಸ್ವಯಂ ಕಾರಿನಲ್ಲಿ ನಮ್ಮ ಮನೆ ಬಳಿ ಬಂದು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ತಂದೆಯನ್ನು ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ನಿಂದಿಸುತ್ತಾ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನಮ್ಮ ಮನೆ ಒಳಗಡೆ ನುಗ್ಗಿದ್ದಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನ ಗಂಡ ಇಸ್ ನಾಟ್ ದಿ ಪಿಟಿಷನರ್, ನನ್ನ ಚಿಕ್ಕಮ್ಮ ರೂಪ ಶಿ ಇಸ್ ದಿ ಪಿಟಿಷನರ್, ನಾಗಭೂಷಣ ಕೀರ್ತಿ ಪ್ರವೀಣ ಅವರು ಪಿಟಿಷನರ್ಸ್ ಅಲ್ಲ. ಇವರುಗಳು ನನ್ನನ್ನು ತಬ್ಬಿ ಹಿಡಿದುಕೊಂಡು ನನ್ನ ಮುಖಕ್ಕೆಲ್ಲ ಹೊಡೆದಿರುತ್ತಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನ ಚಿಕ್ಕಮ್ಮ ರೂಪ ಪಿಟಿಷನರ್ ಮತ್ತು ಇವರ ಮಗ ನಾಗಭೂಷಣ ಮತ್ತು ಕೀರ್ತಿ ಮತ್ತು ಪ್ರವೀಣ ಅವರಿಲ್ಲ. ನನ್ನನ್ನು ತಬ್ಬಿ ಹಿಡಿದುಕೊಂಡಾಗ ನನ್ನ ಗಂಡ ನನ್ನ ಕುತ್ತಿಗೆಯನ್ನು ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡು ಉಸಿರು ಕಟ್ಟಿಸಿ ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡುವುದಾಗಿ ಹೇಳುತ್ತಾ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿರುತ್ತಾನೆ. ನಾನು ಉಸಿರು ಕಟ್ಟಿ ನಮ್ಮ ಮನೆಯ ಹಾಲ್ನಲ್ಲಿ ಕೆಳಗೆ ಬಿದ್ದಾಗ ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು ನನ್ನ ಎದೆ, ಕುತ್ತಿಗೆ, ಬೆನ್ನು, ಹೊಟ್ಟೆ ಭಾಗಗಳಿಂದ ಕಾಲಿನಿಂದ ಒದ್ದು ನೋವುಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಗಲಾಟೆ ಶಬ್ದ ಕೇಳಿ ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದ ನಮ್ಮ ಟೌನ್ನ ಕೌನ್ಸಿಲರ್ ಆದ ಟಿ.ಜಿ. ಕೃಷ್ಣ, ಬಿನ್ ಚಂದ್ರಶೇಖರಯ್ಯ, ಮಂಜು ಬಿನ್ ಅಣ್ಣೇಗೌಡ, ವಾಗೀಶ್ ಬಿನ್ ಬಸವರಾಜಪ್ಪರವರು ಅವರುಗಳನ್ನು ತಡೆದು ಅವರ ಹಿಡಿತದಿಂದ ನನ್ನನ್ನು ಬಿಡಿಸಿ ನನ್ನ ಜೀವ ರಕ್ಷಣೆ ಮಾಡಿರುತ್ತಾರೆ. ನಮ್ಮ ತಂದೆ ಮತ್ತು ನಮ್ಮ ತಾಯಿಯವರು ಸಹ ನನ್ನನ್ನು ಬಿಡಿಸುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ತಂದೆಯನ್ನು ಕೊಲೆ ಮಾಡುತ್ತೇವೆ ಎಂದು ಹೇಳುತ್ತಾ ನನ್ನ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಮತ್ತು ಇವರ ಸಹಚರರು ನನ್ನ ಗಂಡನ ಪ್ರೇರಣೆಯಿಂದ ನನ್ನ ತಂದೆಯನ್ನು ತಾರೀಕು 30/3/2022 ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಪಟ್ಟು ನನ್ನ ತಂದೆಯನ್ನು ಸಾಯಿಸಲು ಮಾಡಿದ ಅಪರಾಧದ ಬಗ್ಗೆ ಕೇಸ್ ಆಗಿರುತ್ತದೆ. ನನ್ನ ಚಿಕ್ಕಪ್ಪನ ಮಗ ಸಿಪಿ ನಿರಂಜನ ಸಂಚು ಸಾಯುವುದಕ್ಕೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡಲು ಬಂದು ನನ್ನನ್ನು ಸಾಯಿಸಲು ಪ್ರಯತ್ನಪಟ್ಟು ನನ್ನ ದೇಹದ ಭಾಗದಲ್ಲಿ ನೋವು ಮಾಡಿರುವ ಹೇಳಿಕೊಂಡ ಅಪರಾಧಿಗಳ ವಿರುದ್ಧ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಿ ನಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ರಕ್ಷಣೆ ನೀಡಬೇಕಾಗಿ ಪ್ರಾರ್ಥಿಸುತ್ತೇವೆ. ರಿಜಿಸ್ಟರ್ಡ್ ಅಂಡರ್ so and so, crime number 236, 143, 504, 448, 341, 307, 307 is the serious offense. 323. The other side has filed de facto complaint, has filed some documents in which the perpetrated wound certificate is also there. I have not produced it because I could not secure it. So far as the other case referred to 33/2022 is concerned, this honorable court has granted them anticipatory bail. Of course, I am not anticipatory bail. That the other side has produced along with their so-called objections, which your lordship gets at page 92. Sabhi Swami Suchita so. Last paragraph, which says, allowed, consequently, Krishna shall be released on bail in the event of the arrest in so and so. So what remains now is whether this particular lady, whom the original informant calls as Chikkamma, in what way she is responsible for causing any injury. What she says is that injury, the injury certificate is produced by the other side. That is that there also whether there is any grievous injury. Many photos also produced. That your lordship gets at page 60. Objection to the beef of the formality. 60. 16.
Yes.
Wound or injuries found on person of a female, Padmini, she is the injured, age 28 years also, sent with and accompanied by Manjunatha. Manjunatha is the father, still practitioners, for report as social injuries caused assault on 27/8/2022. But shoulder down on 29, shoulder fracture, taken to hospital. Now, this has to be read along with her state of first information. The question of fracture does not arise.
It is not shoulder fracture, it is a clavicle fracture.
Clavicle fracture. Even then, it does not say that. Assuming that it is so, then several persons are in the act. This lady who had suffered thrombosis in the year 2016, I produced the certificate. What is the motive? What is the intention? For 307. And the lady, so far as the lady is concerned, not. Though this is an application under 439. 437 also may be looked at. This year. Only for this purpose. When they may be taken in case of non-bailable offense. Agreed. Provided that the court may direct that a person referred to in class 1 or class 2 be released on bail if such a person is under the age of 16 years or is a woman or is sick or infirm. I come within this class. So I have produced the certificate. At page 4, 2016. Incident happened on 27/8/2022. She was admitted on 23/10/2016. Discharged on 29/10/2016.
Which document you are reading?
Page 37, document number 4. Discharge summary, Department of Neurology, so far as this lady is concerned, Rupa. ಹೌದು ನನ್ನ ಫಿಕ್ಷನ್ ಹಾಕಿದ್ದೆ.
Page number
37. Diagnosis: cerebral venous thrombosis type 2DM. Sudden onset headaches in 3 days. This is on 23/10/2016. Discharged on 29/10. History of resulting illness: sudden onset of headaches in 3 days. Left answer from this and so. Then about the investigations are done. Last page 41. In case of urgency, please call so and so or visit emergency. The de facto,
how it is relevant
for in the year 2016. She was not well.
She was suffering some disease in 2016, mental disease or something else.
Yes.
And she was admitted for 1 week in the hospital, discharged around 29/10/2016. Yes. How it is relevant to the present case?
27/8/2022. If we read the whole record as such, whether it was possible for a person to create an incident where injuries have to this complaint.
No, I'm not able to follow your arguments because this document of admission is pertaining to petitioner of 2016.
Yes. Yes.
And the injuries were alleged to have been caused to the complainant. 2022.
20.
So there is gap of almost 6 years.
Yes.
How it is relevant?
So far as that is concerned, Lord, I have secured from JSS Hospital, Mysore, the latest ಹೊರರೋಗಿಗಳ ದಾಖಲೆ outpatient record, which discloses that even this certificate is valid up to 30/11/2022. ರೋಗಿ ಕುಟುಂಬದ ಸದಸ್ಯ patients should retain the OPD record with them and must bring it during the next visit to OPD, emergency, so on and so forth. Therefore, in the circumstances where she said, doesn't say in the first information.
I'm not able to follow you. How these records are relevant in respect of the injuries being caused to the complainant?
Yes.
How you are correlating? I'm not able to follow you.
The only purpose would be, my Lord,
Because that document number 4, which you are relying on, is pertaining to your admission in 2016. The allegations of the prosecution is of 2022.
22.
Near gap of nearly 6 months.
So I got this also. Original also is with me. I will not produce it. If you are not to permit me, I can produce it.
Sir, the copy to the other side first.
I should have said it. Right now, Lord, if you read the complaint dated 27/8/2022, what it says is, ಉಳಿದವರು ನನ್ನನ್ನು ಕಬ್ಬು ಹಿಡಿದುಕೊಂಡಾಗ ನನ್ನ ಗಂಡ ನನ್ನ ಕುತ್ತಿಗೆಯನ್ನು ಗುರಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡು ಉಸಿರು ಕಟ್ಟಿಸಿ ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡುವುದಾಗಿ ಹೇಳಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿರುತ್ತಾನೆ. is not there. ನಾನು ಉಸಿರು ಕಟ್ಟಿ ನಮ್ಮ ಮನೆಯ ಹಾಲಿನಲ್ಲಿ ಕೆಳಗೆ ಬಿದ್ದಾಗ ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು ನನ್ನ ಎದೆ ಕುತ್ತಿಗೆ ಬೆನ್ನು ಹೊಟ್ಟೆ ಭಾಗಗಳಿಗೆ ಹಾಲಿನಿಂದ ಒದ್ದು ನೋವುಂಟು ಮಾಡಿಬಿಡ್ತಾರೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ದಿಸ್ ಈಸ್ ದಿ ಓನ್ಲಿ ಎಲಿಗೇಷನ್. ಹಾಲಿನಿಂದ ಒದ್ದು ನೋವುಂಟು ಮಾಡಿರುತ್ತಾರೆ. ನೋ ಫ್ಯಾಕ್ಟ್, ನೋ ಸರ್ವಿಟಸ್.
She claims that she was kicked and she suffered pain. She may not be knowing what is termed. What is the internal damage to her body? That will only be on after medical examination.
ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು ನನ್ನ ಎದೆ ಹಾಲಿನಿಂದ ಒದ್ದು ನೋವುಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು what part, specific part, my party has taken in this particular case is not discussed.
Yes.
Therefore,
so you call, according to individual vote act is not referred in the complaint.
Yes. And so far as 307 is concerned, she is infirm. 2016. Woman, 437. It's not as though the lordship does not know about it. What may direct enables. If such person is a woman or is sick or infirm, that's all I think. Yes, this is the loss. Not beyond that. She has been in the incarceration from that day. And the very day she is arrested. Woman.
Whether 437 is made applicable here?
437, that proviso in a limited sense can be made applicable.
Why?
Otherwise, not 437.
Because the same proviso is not available in 439.
No, 439 is not available. But what is this? The High Court or so and so, any person acquitted of so and so, in custody, be released on bail. And if the offence is of the nature specified in subsection 3 of section 437, may impose it. So it is a matter for condition to be imposed. On the ground that she is likely to flee from justice. She is likely to tamper the witnesses. The trial court, the district court has rejected it.
Yes.
Special powers. If the offence is of the nature specified in section 3 of section 434, may impose any condition. Woman.
But that is 437 subclause 3 is pertaining to restricted offense covered under particular chapters.
Yes.
Whether the offense alleged, does it fall under the specific chapter?
That doesn't fall with you.
Then how the 437 subclause 3 can be made applicable?
Woman is concerned. She is a woman. She has been in jail from that day itself.
Yes.
Therefore, my suggestion would be, this honorable court may release her on bail. Conditions will be there.
Yes.
That's all I can submit. Beyond that, I cannot records for that. Conditions, impose strict conditions. Taking into consideration that she is a woman and she has only chikkama of the ordinary complaint.
Yes.
What is the role she has played? With this on her part.
She mentioned presence of all the accused. She mentions the specific overt act of her husband.
The lady falls down. There are issues.
Whether the CCTV footage is disclosed, the attempt on life. Whether CCTV footage is disclosed, attempt on life.
Yes.
So I'm asking you, cheating is different, assault is different. I'm not talking about assault. The major offense is 307. Regarding 307, either CCTV footage, does they disclose anything? So inside house, there is no CCTV. Admittedly, the incident has taken inside the house. So no CCTV footage is pertaining to the alleged offense of 307. Yes. Do you admit that the person visible in some of the photos is that accused number 4?
No.
She appears to be ferocious, therefore, little bit ferocious.
ಹೌದು. ಇಲ್ಲಿ 21 ಪೇಜ್ ನಂಬರ್ 20
23 page number second photograph.
Note.
23 ಒಳಗೆ ಎರಡು photographs ಇವೆ.
One is clear. A4 ಅವರು ಪಿರಿಯಾಡಿ ಮಾಡಿದ್ದು
ಅಲ್ಲ ಅವ್ರು ಮಾರ್ಕ್ ಮಾಡಿದ್ದು ನಾನು ನಿಮ್ಗೆ ಕೇಳಿದ್ದೇನೆ because you are the best person to identify.
I have not been able to identify.
But you are not disputing the identity.
I cannot dispute the, I can say I cannot dispute the identity in the absence of seeing the lady.
Page number 21 ಒಳಗೆ ನೋಡಿ. She appears to be too ferocious.
A4 ಮತ್ತು A2. They are deceptive.
We cannot form any opinion on the basis of photograph. I do
There matters for
it is subject to trial only.
for matters for the police to obtain those matters and find the final report. And for me to I can defend myself, depending upon the charge.
Yes.
I cannot assume that 307 is being charged.
Yes.
We are only at that stage now. That's all I can submit.
One question. All along you are asserting that there was an attempt of strangulation, throttling of the neck. The injuries shown are only scratch injuries on the neck. Which is available from your photographs. See, that is the slapping. It is not the throttling. Throttling thumb will be there. Attempt that thumb ಬರುತ್ತೆ. Slap ಆದಾಗ ಈ ರೀತಿ injury ಕಂಡು ಬರುತ್ತೆ.
And abrasions or cheek, just complaints of chest.
Third, put inside. Yes.
Yes. One submission I would like to make.
Yes.
Was not with regard to the merits of the case. Mr. Sunil Kumar, he has filed the objection statement. In the objection statement, your lordship has said, the affidavit, so-called affidavit. What this honorable court has held is, so if it is to be construed as an affidavit, either before the notary or before the oath commissioner, the transaction number must be submitted. I go to the notary. He has got the register. My number will be 111. If that 111 is not incorporated in the affidavit, then it is no affidavit. It cannot be looked at.
Who has sworn it? Before whom it is sworn? Before whom it is sworn?
Some notary. But unfortunately, it's a matter of this aspect.
Oh, it has no relevancy regarding the merits of the case, but you have raised some issue.
Yes.
Because if it is not done, notary will land in trouble.
What the learned judge says is, in the case reported in 1998, 1 Karnataka Resolution 529, it will be a defective affidavit and it cannot be looked into. Not only that, the learned judge has said, the courts will not act on defective affidavits which are not attested in the manner required by law. Let a copy of
But here one thing is certain. This affidavit is not in the way of creating any right. It is only seeking a leave. First thing. Second thing, it is the mistake of the notary. Why the party should be made as a scapegoat.
That also question has been answered by this.
But correct, it is not creating any right.
No, it
It is simply seeking the leave of the court.
Statement of certain facts. That is why I submitted. This will not go into the merits. This is only for the purpose of following what should be done or should not.
No, he has brought it, and if strictly I record it, I'll have to issue notice to the concerned notary. It is shown by the before notary, and he has raised that proper issue because both commissioner regularly put serial number. Both commissioner do put serial number, but notaries never put serial number. That is a serious thing. Because it should be correspondingly, it should be entered in the register. And they should obtain signature. Sometimes it becomes very serious issue.
Not mine.
Huh? ಅಲ್ರಿ 17 ದಿನ ಆಯ್ತು ರೆಕಾರ್ಡ್ಸ್ ಇನ್ನ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ you have taken notice on 26/9. Prior to that they have also served the copy and they are in custody. Should be diligent. Day after tomorrow, Saturday it is notice. Saturday it is working day. Saturday, day after tomorrow. Huh? Notification declare ಆಗಿ 2 ದಿನ ಆಯ್ತು ರೀ. ಹಾಲಿಡೇ ಆಗತ್ತಂತ. ಮಂಡೇ ಇಡಿ ಆಗಿ. ಮಂಡೇ ಹೋಗಿಲ್ರಿ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಮಂಡೇ ಹೇಗಾರ Saturday there is some otherwise engagements likely. ನೋಡೋಣ ನಾನು. Copies are received. Learned counsel. The learned counsel for petitioner submit that he has received the copy of I-1 of 22. Hence, office objections are overruled. One ಮೊದಲು ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಅಲ್ಲ. I-1 of 22 is filed. The section 301 of CRPC, seeking the leave of the court to assist the prosecution in opposing the bail petition. The learned counsel for petitioner submits that he has no objection for I-1 of 22. Since I-1 of 22 is allowed, the learned counsel for objector is permitted to assist the prosecution. Yes.
It's 17 not is the right copy of the complaint. But the allegations are not under section not 498A and 306. Regard to 498A, not there are no allegations in the complaint. Only not provision that remains is section 306. May I read not the complaint here?
Yes.
Complaint number 2.
When it is posted, what is the number?
940. 9240 number. But this will be considered independent of that.
Independently, but what is the main allegations? Note ಬೇಕಾಗುತ್ತೆ 9240 of 2022.
These two are the sister.
Day after tomorrow. Tomorrow doubtful. Monday. Along with that, along with this matter.
The other petition is likely to be listed tomorrow. Likely. It is directed to be listed immediately after the petition.
Hello, but tomorrow it will not be listed because I am having different benches in the second half. Second half, other matters, bench matters have. Monday editini. Not giving a longer date. Monday only. As per request of HCGP, this the matter on Monday along with criminal petition 9240 of 22. Office objections have been raised on memo of appearance. Memo of appearance was sent, one minute. Memo of appearance was sent through mail. It does not have a welfare stamp affixed.
Respondents. Respondent.
Huh?
Respondent. Respondent.
Pakabatti judge.
Oh, sorry. I was understanding.
But that could be overruled.
ಅವ್ರ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರೆ 4 ದಿನ. When you are served?
23rd September.
23rd September. No, 26/9. 26/9. 15 ದಿನ ಆಯ್ತಲ್ರಿ. So even 39 counts ಮಾಡಿದ್ರು almost 14 days ಆಯ್ತು.
Tuesday.
Wednesday.
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 Wednesday 1 week.
1 week ಆಗತ್ತೆ Wednesday. ಇವತ್ತು Thursday. 1 week ಅಂದ್ರೆ next Wednesday. As per request of CGC, this is the matter on Wednesday. ಅವರು ಟೈಮ್ ಕೇಳಿದ್ರು Saturday ಇಟ್ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿ ಇರಲಿಲ್ಲ. I did not use the matter as per request of the 11th council for petitioner on Saturday. ಇಡೀ some other day post ಆಗುತ್ತೆ.
The matter was listed on 28th of September. That time notice was ordered. Now HCGP was directed to take it. Respondent.
Yadav?
Respondent is represented by the
HCGP ನಿಮಗೆ ಬರಲ್ಲ ಲೋಕಾಯುಕ್ತ.
I have already served a copy on the Lokaयुಕ್ta office itself. On 26/9 only, I served the copy on Lokaयुಕ್ta office.
ಲೋಕಾಯುಕ್ತ ಪೆನಲ್ ಸಪರೇಟ್ ಇದೆ.
Yes, sir. DB Patil was special counsel appeared for Lokaयुಕ್ta.
There are some councils which are on the role of Lokaयुಕ್ta.
Yes, Prasad or DB Patil.
ಅಲ್ಲ ಅದು ಮಾಡ್ತೀನಿ. ಯಾರು ಇದಾರ ಲೋಕಾಯುಕ್ತವ್ರು ಇಲ್ಲಿ? So that I can direct.
Council was DB Patil appears.
DB Patil. You intimate him then?
Yes, sir. Intimate what my last call this matter on Saturday, my lord.
Saturday is a doubtful issue of the ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Now it is declared as a working day. Now in view of the subsequent developments.
439 application, my lord.
Correct. ನಾನು ಇಡ್ತೀನಿ, ನಂದೇನು ಹೋಗಲ್ಲ. Saturday ಹಾಲಿಡೇ ಡಿಕ್ಲೇರ್ ಆಯ್ತಂದ್ರೆ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Otherwise, not trying to have it tomorrow.
Tomorrow, second half, I am having a bench. ನಂದೇನು ತಕರಾರು ಇಲ್ಲ, ಇಡ್ತೀನಿ. ಬಟ್ ಸ್ಯಾಟರ್ಡೆ ಹೋಯ್ತಂದ್ರೆ ಮತ್ತೆ ಹೋಗುತ್ತೆ. ಆಯ್ತು, ನಿಮ್ ಪ್ರಕಾರ ಬಿ ಪಾಟೀಲ್ ಅಡ್ವೊಕೇಟ್ is directed to take notice for the respondent Lokayukta, Karnataka Lokayukta. The office is directed to delete the name of HCGP from the cause list. Or intimate Madi.
My lord, if it is transferred from ACB, then it will be Lokayukta, Patil. If it is direct Lokayukta, Arabatti will appear. There are some internal arrangements. If the cases were transferred from ACB, Patil will appear. Direct Lokayukta iravadre Arabatti appear ಆಗ್ತಾರೆ.
ನೋಡೋಣ ಬನ್ನಿ. ಅದೇ ಅದರೊಳಗ ಬಿಬಿ ಪಾಟೀಲ್ ಬರಲ್ಲ, ACB ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದ ಅಷ್ಟೇ ಬಿಬಿ ಪಾಟೀಲ್.
Arabatti will appear for direct Lokayukta case.
ACB ಇಂದ ಲೋಕಾಯುಕ್ತಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದು ಬಿಬಿ ಪಾಟೀಲ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಡೈರೆಕ್ಟ್ ಲೋಕಾಯುಕ್ತ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಇದ್ದಿದ್ವಲ್ಲ ಅರ್ಬಟ್ಟಿ ಅವರು ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ. ಅರ್ಬಟ್ಟಿ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅರ್ಬಟ್ಟಿ ಅವ್ರಿಗೆ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಷನ್ ಮಾಡಿಬಿಡಿ. You are for? So you are defective complainant. You filed an application under section 301 seeking permission.
My lord, I am appearing for the petitioner in 79, my lord. The two are connected, 78 and 79.
Incomparable. Actually, for the state. There's not tank amount of gain. Victim
According to the allegations are that in spite of the injunction by the apex court regarding transfer. That is apex court apex court regarding transfer of the property. The accused have transferred it.
Taking that we shall not register in document related or the court. By that, we take in particular, you should I think getting letter. And now,
Yearly, no.
application of
Yes.
Here is termination of the proceedings in the review. We may have to clarify that 15 combined slash equality are two distinct conditions. It's not always necessary that the combined slash equality. But you are a stranger, Robert, can you know this? But you are a stranger to the act of crime and be informed. Similarly, the victim need not be apparent or informed. But the judgment of the honorable Justice Clark, let us continue not to do that judgment. This is in relation to the anticipatory. About this judgment. Then put that was a state. And because you lost the final judgment. First, I would like to take your order to carry out 12. Thereafter, you take your order.
Yes.
Yeah, he's there, but he's not properly. I'm not able to hear him, sir. Because had a voice, sir.
The apex observer, the normative provision is set for permission written argument should be filed by a state person before the session score. And court is doing not the argument. The apex observer.
Lord, I'll be highly obliged if my friend uses the mic, my lord. We are not able to hear anything.
Yes, you're right. He's asking you to use the mic because he's not able to hear you. He's justified in submission.
It's only a request, my lord.
Yes, you're right. Yes. Yes. His counsel is also there.
My lord, according to me, my lord, for 3.1, it only permits the counsel to assist the public prosecutor. My lord, really no permission is required. Even if it is required, it could be granted. But that, as your lordship has already observed in the earlier case, doesn't authorize the advocate to address the court. He could only assist the prosecution. For that,
now that he wants to not only assist the court prosecution, he wants to come on record. So let us dispose of his application. He claims that as of right, he has got a right to address the court by coming on record. That is a different from assisting the prosecution.
No. That means it will be an impleading application.
Yes.
It is an impleading application. No,
He
that is,
indirectly wants get himself impleaded as respondent number 2.
no, that can't be done in law.
No, no, he wants to argue on that point, on that issue itself. We'll consider it, we'll dispose of this IA also.
What is the application?
If he says no objection, I can consider it. But if the
No, I have no objection for 301. I have no objection if the application is to assist the
issue is
prosecutor.
different. If it is assisting, it is only between the court and the person seeking. It is only between court. Court need not ask the other side. But if you are seeking impleadment, once you come implement, you get all the rights. So that issue is to be considered. Yes. We'll dispose of that application. We'll consider it without going to the merits of the case. Yes.
I get a right of audience in the event of without granting this.
Yes, definitely. If your application is allowed, you'll get right of audience.
Otherwise, no.
Your right will be to assist the prosecution. Yes.
Paragraph 15. When an application for anticipatory bail is considered. When an application for anticipatory bail is considered, police may not place all necessary as an investigation in both of such cases. Therefore, some court can be played by the complainant.
Mic is not used, my lord. You are now. I am not hearing anything.
Yeah, mic.
This major problem. In fact, I don't know how you are
Sir, now ಏನು ಮಾಡೋದು ಹೇಳಿ. Even we request now virtual ತಗದ್ಬಿಡಿ ಅಂತ ಹೇಳಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿಗೆ ಬಂದೀವಿ ನಾವು. Because of these climatic variations affects. Sorry, ಹೇಳಿ.
When an application for anticipatory bail is considered, the police may not place all details before the court as a investigation. In these circumstances, it's not possible to hold. But cannot be first application when the complainant court of hearing of an application the court found paying. The said right cannot be allowed to be exercised. The man delayed the disposal of the application for anticipatory bail. The delay in disposal of such application may adversely affect the investigation. Therefore, the right which can be spelled out in favor of the complainant or the complainant is of making all submissions for finding out the actual aspect of in the course of hearing of an application for anticipatory bail. The said right is to be exercised by the complainant either by himself or his counsel. This is not to say that the sessions for the application for anticipatory bail and that is obligation to issue notice to the complainant or the complainant. There is no such requirement of issuing notice to the complainant or the complainant at the hearing of the application for anticipatory bail. Or if the complainant or the complainant, denied making oral submission, either in person or his counsel. Must be noted here. Subject to now the direct session justified in not accepting the submission state as behalf of the subject to what is observed about no place.
It doesn't say regarding impediment. It simply asserts right of submission can be given.
How does your lordship give me the right of submission?
But even that is also observed. There is no need to issuance of notice.
Notice.
Because if you are made as a party, notice becomes mandatory.
Notice can be issued in the absence. But when the first government of the complaint, what is bound to give it, candidate it is, there is not in paragraph 15. Why this page for 5 or 6 pages and all. This is not to say that the sessions court hearing the application for anticipatory by is not allowed. There is an obligation to issue notice to the government of compliance. There is no such requirement of issuing notice to the government of compliance. At the hearing of an application for anticipatory, now mainly known as cost of sentence. However, if the complainant of the particular or time before the government, it cannot be denied the right of giving moral submissions either in person or saying, noted here, the legal position is the application regular way. And the regular way, we are but now, almost all the questions so kindly go to paragraph 30. The larger legislative Supreme Court is to clear the issue. Kindly go to paragraph 30. Considering the submissions made to the respective parties.
1-3, na? 3-0.
You're reading out from the judgment. Sir.
Huh?
Judgment.
ನಮಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲ
3-0 ಇಲ್ಲ ಇಲ್ಲ
My lord, we would have been in a better position to assist your lordship had the at least notice of the citations would have been given. We would have been ready for it because application is filed under 301. I thought if it is 301, I will have no objection.
He is asking that the citations which you are now relying, if they are furnished to the other side, they would be better equipped. So
Citation is enough. Ruling need not be done.
I am addressing arguments by basic reliance. It is an unreported statement. The law is fairly clear.
Question of furnishing means at least which citation you have quoted. What is?
No, I don't want the copies of the judgment, my lord. Citation may be given. I will search for and get it. But I must know that it is being cited.
But to ask as a matter of fact, I would say that this is to take this. You want to find one. I'm not here to give it. But in support of my submissions and arguments during hearing, I am demanding your lordship's attention to this statement. But it's an unreported statement. I want to do it. If it is a reported statement, no.
One memo could be simple, at least you submit a memo which citations. See, if one thing is justified, if you submit a memo in duplicate or triplicate, giving it to the court, which citations with which paragraphs you are relying will be made known available. Simple thing. Huh?
before I make my submissions.
Then you argue, then you submit it, then I'll hear him other side.
What I submitted, Your Lordship. In principle, I have no objection. Now that Your Lordship has desired that I should furnish it.
Memo, I'm not asking you to furnish citations. Copy. Memo ಕೊಟ್ಬಿಡಿ. Yes, he'll furnish you a memo of the
Please,
citations.
ma'am. Please, ma'am.
Yes. Yes.
I think I did not trouble Your Lordship. I have already judgment. Concerning the sufficient state by the respective parties, the nation will make the court's decision. That the absence of those documents requiring the involvement or impact of all victims or an against party is an opportunity of the application for anticipatory way. But keeping in view the criminal justice delivery system and public policy in the head as follows. The robbery only to invite Your Lordship. Small movement, which are telling Your Lordship for taking Your Lordship.
Yes.
The environment stand against party. So what appears in court, an application for anticipatory way, either to support or oppose such application and place before the court to give an opportunity to accept something, it means the necessity of getting such person in the interest of justice and justice system. But ultimately, we are bound by Your Lordship's discussion in the jurisdiction.
Yes.
Any number of judgments in this point. They can't say that I should be asked to go out of the court and I am but now, my request to Your Lordship is that so for the reason, but the investigator at this point of time, hardly does not take any of the international market. What the land is over the coast, Your Lordship. Bail applications on the for custody for last 7 years can be conducted. We should take all of the indicators. And all those examples suddenly going to buy Your Lordship's attention. Provided a lot of the amendment. That's all. I know where I stand.
Yes. Yes, what you have to say? Regarding his prayer or impediment rather than assistance.
First of all, I want to place lines.
In fact, if there is earlier 3-bench edition, then this 2022 bench edition is per inquiry.
Even if there is all I think is very big. Right. So the only secret form of judges is to refer the matter to the Honorable Chief Justice. Unless and until.
But that is the law now prescribed by the full bench, declared by the full bench of the apex court. Because if there are co-equal benches, the earlier bench edition shall prevail. The remedy for the subsequent bench is to refer it to higher bench. Until then, earlier bench edition shall prevail. But what happens normally, this is the latest edition. That is regular arguments. Prasad, ninne bandide swami. See, that is covered. Ratiram Kisha addition clear madbiti. That earlier bench, it is hit by per inquiry. But this is the full bench edition, constitutional bench edition, 1980. Yes. 2005 benches. Constitutional bench edition ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು 1980. ಅಲ್ಲ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಏನಿದೆ. 1980 ಅಷ್ಟು ರಿಲೈ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು. ಅಲ್ಲಲ್ಲ ಇವ್ರಿಗೆ I'm not hearing on merits now. I'm considering only regarding his application. No, it is 1980.
Here, no, 1980 is a good thing. Very much handicapped.
Tika Moraka, 2020.
Jadoo site, which is that? How is that? Third party impeding. I want to know which is this. I cited, so we can reply.
The section 301. I know that came to be rejected by the trial judge. Thereafter, the High Court dismissed, and then but there are 6
judgment.
We citing this hour.
Hours.
What is it?
Point 1. The use of the term assistant, the project 24D is crucial and implies that the victim counsel is only intended to have secondary role for the public process. This is supported by the fact that the original CRPC had used the word coordinate with the prosecution. However, a change was later proposed, and in the final drafted version, the words coordinate with get substituted by victims counsel. It should also be in concurrence with the role emphasized for the leaders instruct private persons under Justice 312. In our considered opinion, a mandate that allows the victims counsel to make oral arguments and cross-examining the witnesses goes beyond the mere assistive role and constitutes a parallel prosecution procedure by itself. Given the primary accord to the public prosecutor in conducting the trial, as evident from section 325, 301, 2, permitting such a free hand would go against the scheme inside of the court of procedure.
But how it is applicable? This is pertaining to trial.
Yes, for trial.
He is now relying only regarding assisting the prosecution in case of anticipatory bail and relies on a full bench edition of the apex court. That is a 3-bench edition wherein there is specific observe they have got right of submission of oral arguments.
I will look into that and what I will make my submission.
Yes.
But if it is not this substitutable, that is para 11.4. 11.4. 4 or 5th line from the top. As stated in section 301(2), the private party's pleader is subject to the directions of the public prosecutor. In our considered opinion, the same principle should apply to the victims counsel under the Title 2, section 24(8), as it adequately ensures that the interests of the victim are represented. If the victims counsel feels that certain aspect has gone unaddressed in the examination of the witnesses or arguments warned by the public prosecutor, he may root any questions or points through the public prosecutor himself. This would not only preserve the paramount position of the public prosecutor under section scheme of statute, also ensures that there is no inconsistent disadvantage by the public prosecutor and the victim counsel. However, Even if there is a situation where the public prosecutor fails to highlight some issues of importance, despite it having been suggested by the victim counsel, the victim's counsel will not to be given the unprivileged of making oral arguments of determining witnesses. This is because in such cases, it still has a recourse by channeling the questions or arguments to the judge first. So ultimately, not in this decision, the scope of section 3.1 law is discussion. And that is the rule expect.
But I do endorse your view, but this observation is only regarding the trial, examination in chief, cross-examination, certain things were not elicited by the prosecution that can be done by the assisting counsel. Here, the counsel cannot take a role of a prosecutor. Ultimately, this is the parallel proceeding. He cannot step into the shoes of the prosecutor. He can assist. But here, he wants oral submissions.
How was the my letter not have appeared not really similar request. But in the order sheet, I both have indicated a copy of it, but I read that relevant portion of the order sheet. The civilian counsel on behalf of the country for the complainant has appeared before the court in 1245 and sought permission of the court to make submission. Since the learned counsel for appeal are not able to perform, the learned senior counsel is permitted to make submission. The present central learned for appeal. See so and so counsel for appeal number 2 submitted that the senior counsel will submit arguments of issue application. Later, so and so for A2 submitted that he will submit arguments of group so and so. Accordingly, he is permitted to submit arguments. First, the arguments of so and so for others of 3C. The learned senior counsel is present and sought permission of the court to make submission. Since this court has already reserved the case of this order, it is not proper to hear the argument. So on the accordingly, the request made by so and so. So he has already made such prayer for the trial court and that it is rejected.
No, that is rejected on the ground that it is reserved for orders. Here you are at the stage of hearing the matter. We'll consider it. Now the citation again Monday. Tomorrow, second half, I am not because I have got a bench. We have parted heavy matter is there. It is also going from since long time.
Yes. Shall be made a party. Yeah. The proceedings all in relation to sitting for the passion of the people. I asked. I argued with it. I should just judgment. Just about 10 days back. I asked.
Monday. Because Saturday is doubtful. Monday. Sir, memo they will furnish a memo, sir. ನೀವು ಬಗೆಹರಿಸ್ಕೊಳ್ಳಿ ಸರ್.
Hello, may I make one submission, my lord?
Yes,
I may be permitted to file my objections to this. Written objections, I'll file by tomorrow. I'll file by tomorrow, yes. Or after, yes. I'm all rowdy, I should not be allowed. And it is not bona fide. Okay. Right.
Petition number 439. Yes, there is an obvious objection. With regard to service of notice to the second respondent, it is a de facto complainant. And in fact, my understanding was the notice of prosecutor here. The case is that, my lord.
Hello, one minute. Office objection. Notice of the
That was, my lord, the court was heavily burdened with about 400 cases, 500 cases.
400 is not a heavy matter. 400 enta heavy. Hello, 400 heavy matters. 400 is not a heavy. But we are bound to issue notice to R2 without issuing notice.
Because of the obvious objection, I had to throw in at a.
Hello, correct.
Because the logic that they were not the party. They were not the party.
What is the offense?
The case is that the petitioner was the managing director of a multi-state cooperative society. It was a financial institution. Moreover, certain number of cases have been filed in different parts of the country, both under invoking section 420 of Indian Penal Code and also the relevant provisions of the state concerning the public money protection, interest of the public money. Here also, at the beginning, the FIR, the case was registered.
Hello, correct. Everything I accept, but you have implemented R2. But without when he is implemented, without hearing him. Yeah, he should be heard.
If the complainants are able to
manage these things,
participate in the court by a substantial sum of money, the government need not spend public money. With all respect to the police prosecutor, I can submit.
But that doesn't mean that the complainant comes and argues. He is not exonerated. He is bound.
Bail role is for the state. Once it is the case of a bail is concerned.
But anyhow, we are bound to issue notice.
Notice one submission I think will be posted on Monday. In between, my lord has a permit to take out the hand summons.
Criminal case hand summons provision illa. Because section 62 or 63 of CRPC only mandates through police only.
Through police, I have no difficulty if it is still got served and come back.
They will get it served through. Yeah, I can understand.
Granted bail by virtue of direction to the other state. The moment the bail was granted, Tribunal police brought in. After the Tribunal police remand was there, Dharwad police. Dharwad he got an anticipatory because they surrendered back. The learned session to Dharwad granted an anticipatory bail. Like that, now the next one is Kenya and Udupi. The entire country is moved from. I also filed a petition for transfer.
That is the best way. You can get all the matters transferred to a common court.
Before this one, I also filed it.
Because if all the matters are heard by.
That case, the honorable court question also why he shifted from one prison to another prison. Morning he is in one prison, night.
It is not a question of prison. It is a question of the jurisdiction of the concerned police station. He is in custody in a particular crime. If he is released here, he is taken on another case on body warrant.
The honorable Supreme Court.
But one thing I am not able to understand your submission, how the Harvard court has granted anticipatory bail. Once body warrant is taken, he is deemed to be in custody. Though he is sent back, though he is sent back to original case, the body or lien of body warrant remains. The moment he is released in that case, he should be taken custody, because what is the intention of the body warrant is to make known that he is also involved in this case.
Yesterday the order has been pronounced.
I was surprised because 439 grant material things are different. Anticipatory bail put a doubt.
In that case of transfer of petition, I have referred to the honorable Supreme Court which directed to CBI to do the investigation. CBI did it and completed and filed a charge sheet in the particular court of the other state. Once the CBI completed the investigation, whether it is necessary for the individual.
So that it is better for you to challenge it. You can challenge it under 482.
That also.
We will issue notice.
Notice returnable by
You can give, you can get it served. ಇಲ್ಲೇ ಚಿಕ್ಕಬಳ್ಳಾಪುರದಲ್ಲ ಡೈಲಿ ಬಂದೇ ಬರ್ತಾರೆ. ಚಿಕ್ಕಬಳ್ಳಾಪುರದವರು, ಕೋಲಾರದವರು, ರಾಮನಗರದವರು ಬೆಳಿಗ್ಗೆ ಎದ್ರೂ ಇಲ್ಲೇ ಇರ್ತಾರ ಅವರು.
Bangalore district.
Twentieth, issue notice. It is noticed that notice to R2 is not yet issued. Hence, ನೀವು ಇಶ್ಯೂ ಆಗಿದೆ, ನೀವು PF ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
My understanding was that notice to the first respondent alone.
ಈ ಕೊಡಿ ಆರ್ಡರ್ ಆಗಿದ್ದದೆ ಆಫೀಸಲ್ಲಿ ಕೊಟ್ಬಿಡಿ. The learned counsel for petitioner undertakes to attend the office objections during the course of the day. Issue, if so, issue notice to R2 returnable by 20th. 20th, Guruvara. Next Thursday, 20th. Huh? Notice to R2 because through it shall be served through SCGP. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಬಂದೇ ಬರ್ತಾನ ಅವನು. But you will have to pay PF. PF copy ಕೊಡ್ಲೇಬೇಕು. 4:30 ತನಕ ಇರುತ್ತೆ ಆಫೀಸ್. 4 ಗಂಟೆ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. One day, tomorrow itself ಅಂತ during the course of day ಅಂತ. Yes.
I appear for the appellant in this case.
Yes.
Partner matter.
Huh. What is the
last hearing date it was suggested.
Sir,
ನಿಮ್ದಲ್ಲ ಸರ್, ಒಂದ್ ನಿಮಿಷ. ನಿಮ್ ನೆಕ್ಸ್ಟ್ ಇದೆ ಬರುತ್ತೇನೆ, ಒಂದ್ 5 ನಿಮಿಷ. ಹಾ ಹೇಳಿ ವಕೀಲ್ರ.
On 3 grounds, my lord, I have preferred this appeal. One is, my lord, the liability of the insurance company is restricted to, my lord, Employees Compensation Act. And the second aspect,
that is one is there is he was traveling in cabin, not in the cabin.
Yes, madam.
And liability is under Workman Compensation Act.
Yes, madam.
It is a pickup van.
Correct.
And 100 rupees is paid.
Paid towards.
So he was paid. He was traveling. He's a gratuitous passengers and traveling in a carriage, not in the cabin. And he was supposed to travel in a cabin in case he is a workman. That was your contention.
Yes. Yes.
Sir, carriage ಅಂತಂದ್ರೆ ಅವ್ರು ಹೇಳಿದ್ದು ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. Carriage is different, but body is different. Open body nu irutte, closed body nu irutte, whatever it may be. Cabin is entirely different. Driver, cleaner are meant for traveling in cabin, and he's harping on that point. He's harping on that point.
Kind permission, my lord, I have furnished 2 citations, my lord. That is, one is, my lord, Challabharatama case, and another one is judgment by this honorable court, my lord, by Justice Narayan Swamy. 2 citations, my lord, are laid with regard to, my lord, traveling on the cabin and
ನೋಡಿದಿರಿ ಅವನ ಅಲ್ಲ ನೋಡಿದಿರಾ ಅಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಡ್ರಿ ನೋಡ್ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕಾಪಿ ನೀವು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತಲ್ರಿ.
I have furnished 2 sets, my lord, to the court. However, my lord, I will furnish another set, my lord, if I have no issues.
ಅಲ್ಲ 2 sets ಕೊಟ್ಟಿದ್ದಾರೆ ಕೋರ್ಟಿಗೆ. ಕೋರ್ಟಿಗೆ 2 ಸೆಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಒಂದೇ ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು ಕೋರ್ಟಿಗೆ.
ಕಳಿಸಿದ್ದೆ ಸ್ವಾಮಿ, 2 ಸೆಟ್ ಕಳಿಸಿದ್ದೆ.
ಕೋರ್ಟಿ 2 ಸೆಟ್ ಇಲ್ಲ ಅಂತ ರಿಟರ್ನ್ ಕೊಟ್ರ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನೀವು.
ಫರ್ನಿಶ್ ಮಾಡ್ತೀನಿ.
ಇದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಡ್ರಿ. ಟ್ಯೂಸ್ಡೇ ಇಟ್ಟಿರ್ತೀನಿ, ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆನ್ಸ್ಡೇ,
ಎನಿ ಡೇಟ್ ಮಾಡಿ ಕನ್ವೀನಿಯಂಟ್.
ವೆನ್ಸ್ಡೇ.
In this case, I have filed a memo.
Yes, Mahesh Vakil, he has filed a memo that he has no objection for giving voice samples.
We'll do that. We'll do that.
But his only one condition is that he cannot bear the cost. Since you are raising the dispute, you bear the cost. I'll give voice sample before the tribunal.
Let it go to the tribunal, my lord. Our this thing will go and take the voice sample and do the rest of the thing.
Okay. Yes. On that ground, remand ಮಾಡಬಹುದಾ?
ಮಾಡಬಹುದು. That will be the clinching evidence, my lord.
That is the entire case depends on that evidence itself.
Correct.
The petition is filed under section 173(1) of MU Act. These petitions are filed and these appeals are filed under section 173(1) of MU Act, challenging the judgment and award passed in emission number 1121 of 2014 on the file of Senior Civil Judge and MACT Sira, dated 6th October 2017. MFA 2130 is filed by the claimant.
2130.
2130.
Yes.
Seeking enhancement of the compensation, while MFA 34 of 2018 is filed by the insurance company challenging the liability itself. Next. As per the case of the prosecution, as per the parties herein are referred to the original plan certified by them before this. According to the case of the according to claimants on 28/5/2000, according to claimant on 28/5/2014 at 9:30 am, when he and other laborers were loading the sand in the tractor and trailer bearing registration PA022 T171617 at Madhu's land at Nagzapayana village in Kannambala Hobli, Sira Taluka. The driver of the vehicle, without giving any signal, moved the vehicle in a rash and negligent manner in a reverse direction and dashed it to the petitioner, who was standing on the backside of the vehicle, resulting in the accident, and petitioner suffered grievous injuries. Hence, he filed a claim petition on section 166 of MU Act. The tribunal, after assessing the insurance company has disputed the accident on the ground that the vehicle was not, the claimant has not suffered any injuries as alleged by involving the vehicle, and disputed the liability. Next. The tribunal, after assessing the oral as well as documentary evidence, has awarded total compensation of rupees 3,35,900 with interest at the rate of 9% per annum by fastening the liability on respondents 1 and 2 jointly and severally. Being aggrieved by the judgment and award, these appeals are filed. During the course of the hearing, the learned counsel heard the arguments. There is the reports. The reports. During the course of the hearing, the learned counsel for respondent insurance company has invited the attention of the court to exhibit R7, which is a alleged recording said to have been done by the investigator by interviewing the claimant petitioner, wherein the claimant has disputed the extent and other aspects. The exhibit P8 R8 is also relied, which simply states that the exhibit R7 is a genuine document. It is not tampered with. Exhibit R7 is not tampered with. However, the issue is regarding whether it is the voice of the claimant petitioner or not. Subsequently, after hearing the matter for some time, both the counsels submit that matter may be remanded with a direction to the trial court to take voice sample of the claimant and examine the same along with exhibit R7. The learned counsel for claimant appellant has also filed a memo stating that the claimant is prepared to give voice sample subject to the condition that cost shall be borne by the insurance company. The learned counsel for insurance company would submit that in case matter is remanded, necessary steps will be taken in this regard. Looking to these submissions made by the rival, both the parties, it is evident that the entire matter now rests on the genuineness of exhibit R7 itself. Hence, the matter requires to be remanded in order to enable the parties to give voice sample of claimant before the tribunal, which can be taken by a competent person and that can be compared with exhibit R7, R6, that can be compared with R7. Under these circumstances, the appeal, both the appeal needs to be allowed by setting aside the impugned judgment and award, and matter requires to be remitted back to the tribunal. Accordingly, I proceed to pass the following. The appeals are allowed. The judgment here, judgment and on so and so stands set aside. The matter is remitted back to the tribunal with a specific direction that the tribunal shall secure the voice sample of the claimant petitioner at the cost of the respondent to insurance company, and then get it analyzed by comparing the same with exhibit R7, and then pass a appropriate judgment basing on other evidence, including the report regarding voice sample. Next, considering the old nature of the matter, ನಿಮ್ದು ಇದಿದೆ ಹೇಳಿ ಏನಾಯ್ತು ವಕೀಲ ಸಿದ್ದರಾಮಯ್ಯ ಅವರೇ?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್.
Considering the old nature of the matter, the parties are directed to appear before the tribunal.
Any date?
ಅಲ್ಲ ಅದೇ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ, ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ಹೋಗ್ಬೇಕಲ್ವಾ?
ರೆಕಾರ್ಡ್ಸ್ ಹೋಗ್ಬೇಕು.
On 4/11/22 at 11 AM and without waiting for any notice or summons from the court, the tribunal shall then fix a date for taking voice sample and then proceed further. The office is also directed to transmit the records to the tribunal immediately. Statutory amount ಇದೆ ಅಲ್ವಾ?
ಇದೆ statutory amount ಇದೆ.
ಟ್ರಿಬ್ಯುನಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಬಿಡ್ತೀವಿ.
It may be transferred to the tribunal. Yes.
The amount in deposit shall also be transmitted to the tribunal. Mute ಆಗಿದೆ ವಕೀಲರು ನಿಮ್ದು?
ಇಲ್ಲ ಈಗ ಆಗಿದೆ. ಅವಾಗ
ಅಲ್ಲ ಅವ್ರದ್ದು ಮಹೇಶ್ ಅವ್ರದ್ದು.
To be invested, my lord, interest earned will be benefit of either of the parties.
ಆಯ್ತು. Further, the tribunal is directed to invest the amount in any FD scheme of nationalized bank, and the successful party is entitled to get the deposited amount with accrued interest thereon.
I appear for the appellant in the connected appeal.
Oh, yes, Sakilre.
In case the last time lordship directed me to withdraw this appeal, my lord, since it was a case of third party property damage and that was considered.
Lordship claim around in MFA 6533 of 2019 filed by Mr. Sidramaya. I have not been served with a copy.
Sir, my lord, right now I'll send it.
ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ನಾನು ನಾರ್ಮಲಿ ಕಾಪಿ ಯಾರಿಗೂ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲ.
ಅವರು ನೀವು ಕಾಪಿ ಸರ್ ಮಾಡಿಲ್ಲ, ನೀವು ಕೊಡೋಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳಿರೋ ಅಲಿಗೇಷನ್ ಅಲ್ಲ.
ಯೂಶಲಿ ಮೇಲ್ ಕಳಿಸ್ತಾರೆ, ಬಟ್ ಈ ಕೇಸಲ್ಲಿ ಮಿಸ್ ಆಗಿರ್ಬೋದು.
ಅಲ್ಲಿ ಕಳಿಸ್ತಾರೆ, ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಕಳಿಸ್ತಾರೆ, ಈ ಸಲ ಕಳಿಸಿಲ್ಲ ಅಷ್ಟೇ.
I will send it right now.
Shall I release it from part head?
ಇದರಲ್ಲಿ ಇಲ್ಲ if Omesh sir ಏನೋ ಇದಿಲ್ಲ ಅಂತಂದ್ರೆ there is no this thing by the other company. This dispute between only my lord, the owner of my vehicle, and the insurance company. That's it. Last time my lord, your lordship said ಅವರು ತಮ್ಮಲ್ಲಿ ಓಡಿ ಕ್ಲೇಮ್ ಮಾಡಿದ್ರೆ you are liable to pay the entire compensation. ಹಂಗಾಗಿ ನೀವು 40% ಏನಕ್ಕೆ ಇದನ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ lordship question on me.
Cannot recollect any. ಅವ್ರೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಹೋಗ್ಲಿ ಸಿದ್ದರಾಮಯ್ಯ ಅವರೇ.
ಇಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಕಳಿಸಿದೀನಿ, ಇಮೇಲ್ ಕಳಿಸಿದೀನಿ.
ಕಳಿಸಿದಾರ ನೋಡಿ.
ಇಮೇಲ್ ಆಗೋದಿಲ್ಲ ನನಗೆ.
ಕಳಿಸಿದೀನಿ
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರಿಗೆ ಹಾರ್ಡ್ ಕಾಪಿ ಕಳಿಸಿದ್ರೆ ನನ್ನ ಫೀಸ್ ಬರುತ್ತೆ.
ಇಲ್ಲ ಹಾರ್ಡ್ ಕಾಪಿ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಮಾಡಿದೀನಿ.
ಅಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಮಾಡಿದಾರಂತ ನೋಡಿ.
ಇಮೇಲ್, ವಾಟ್ಸ್ಆಪ್ ಯಾವ್ದು ಪಾಸಿಬಲ್ ಮೆಥಡ್ ಕಳಿಸಿ ತಿರ್ಗಿ ಕಳಿಸ್ತೇನೆ.
ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಡ್ರಿ ವಕೀಲ್ರೆ.
ಇಲ್ಲ, ಇನ್ನೊಂದು ಕಳಿಸ್ತೀನಿ.
may make one submission, my lord.
Yes,
my lord, ಅವ್ರದ್ದು ಕೌಂಟರ್ ಅಪೀಲ್ ಇದೆ. In fact, I discussed with the company officers, my lord. ಅವ್ರದ್ದೇನು ಅನೌನ್ಸ್ಮೆಂಟ್ ಏನೋ ರೈಸ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ both appeals may be dismissed. I have no issues. ವಿಡ್ರಾ ಮಾಡೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ as a technical issue.
Both the appeal may be dismissed.
Both appeals may be dismissed.
I will pay my lord the liability of my 40%. I have no issues. Other companies have already satisfied, my lord. This is only dispute between us. So Omai sir or company ಏನು issues ಇಲ್ಲ. Directly apply the copy of the certified copy of that and get the fees, my lord. No issues.
So ಎರಡು ಕಾಪಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು, ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದು. ನಿಮ್ದು ಅನೌನ್ಸ್ಮೆಂಟ್ ಗೆ ಏನು ಪ್ರೆಸ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ, ಪ್ರೆಸ್ ಮಾಡಲ್ಲ. ಪ್ರೆಸ್ ಅಂದ್ರೆ
ಅಫಿಷಿಯಲಿ ಇದು ಮಾಡಿದ್ರು, ಅನ್ಅಫಿಷಿಯಲಿ you will not press it.
You will not press.
I'll dictate subsequently.
Yes, the amount in deposit may be transferred to my lord MSCT for my appeal.
Sir, dismissed. Judge, order to follow.
Shall we take it as disposal?
Disposal. ಯಾಕಂದ್ರೆ ಅವ್ರು ನಿಮ್ಮ್ಯಾಗ ಏನ್ ಸಂಬಂಧ ಇಲ್ಲ, ನಮ್ಮ ಅವ್ರ ನಡುವೆ ಅದ. ನಮ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರಿ, ಅವ್ರದ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಸೊ anyhow you have paid your part.
Okay, they have already satisfied.
Nim liability is already satisfied.
Yes.
ನಾನು ಕಂಪನಿ ಕಾಪಿ ಕಳಿಸ್ತಿದ್ರೆ ನಮ್ ಫೀಸ್ ಬರಲ್ಲ.
ಬರುತ್ತೆ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿ ನಾಳೆ.
ಈ ಕಾಪಿ ಬರುತ್ತೆ ತಗೊಳ್ಳಿ ನಿಮಗೆ.
ಈಗಲೇ ಕಳಿಸ್ತೇನೆ. In fact, it is signed by Mr. Mahesh himself to the
ಅಲ್ಲ, I'll check up.
He might have forgotten.
ನೋಡಿ.
Corrected.
I'll give one more copy. Nothing wrong.
Yes,
ಬಂದಿರುತ್ತೆ ನಮ್ಮ
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು
ಹುಡುಗರೆಲ್ಲ
ಹೇಳಿದ್ರಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ, ಬಟ್ ಬಿಕಾಸ್ ಆಫ್ ಟೆಕ್ನಿಕಲ್ ಇಶ್ಯೂಸ್ ಐ ವಾಸ್ ನಾಟ್ ಏಬಲ್ ಟು get it withdrawn.
I appreciate your stand that it may be dismissed on merits only,
Please,
but
please.
no problem.
And also one more submission, my lord.
Yes.
My lord, on 6/12/2020, I reported to this honorable court to show that I have sold the copies to Mr. Omesh. ಮೆಮೊನು ಕೂಡ ಹಾಕಿದ್ದೀನಿ.
ಫೀ ಬರುತ್ತೆ
ಹಂಗಲ್ಲ,
ಹಂಗ ಅವ್ರಿಗೆ ಫೀ ಬರ್ಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದು ಒಂಥರ ಒಳ್ಳೆ ಲಕ್ಷಣ.
ಸಿದ್ದರಾಮಯ್ಯನವರೇ, ಏನು ಕಾಪಿ ಕಳ್ಸಿರ್ತೀರಲ್ಲ, ನಾವು ಕೊಟ್ಟಿರ್ತೀವಿ, ನಮ್ಮ ಹುಡುಗ ಅದ್ರ ಫೈಲ್ಗೆ ಹಾಕಿರೋದಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿದಷ್ಟೇ.
ನಮ್ಮಿಂದ ತಪ್ಪಾಗಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ, ನಾಟ್ ಮೋರ್ ದನ್
ಚೆಕ್ ಅಪ್. ನೋ ಹಾರ್ಡ್ ಫೀಲಿಂಗ್ಸ್.
Yes.
Much.
Petition for anticipatory bail, 3 petitioners. In respect of first petition, will not be sought for interim bail. This wedding is tomorrow.
We are not concerned about wedding, sir. The nature of the offense is to be considered.
457, 120B, 147, 148, 149, 307, and 26, 25, 27 of Arms Act. Lord, the present petitioners are accused in crime number 112 of 2022, dated 22/7, which your lordship gets it at page 9. This is the FIR. This Lord is registered at 20:06, that is 8:06 PM on 22/7, which your lordship gets it at column number 3B. This FIR 112 was registered as a counter blast to the FIR registered by the present petitioner number 1, which is at page 43, against the complainant's husband and the other accused. This page 43 is FIR 111 of 2022, dated 22/7/2022, Lord, registered at 18:30.
Sir, timing of registration is not a material aspect.
Material aspect, sequence of events there.
Correct. Both were registered on the same day.
Same day, but ours is prior.
The timing of registration is not ಒಬ್ರು ಯಾರೇ ಹೋಗ್ತಾರೆ ಅವ್ರು ಮೊದಲು ಹೋದ್ರು ಅಂತ ಹೇಳಿ ಮಾಡಕ್ ಬರಲ್ಲ. But in both the case, there is allegations of Arms Act.
Yes, in fact, our licensed revolver has been pulled out. I have been attacked. Petitioner 1 is an inpatient for Lord 5 days in Manipal Hospital initially, for 4 days, then in YTE Hospital.
Detailed arguments. So, without giving them opportunity, I cannot do it. This is Arms Act.
Prima facie, then I will satisfy your lordship only to the extent of interim bail for petition number 1. ಇದು ಮೊನ್ನೆ ಇತ್ತು your lordship.
ನಾನು ಏನ್ ಮಾಡ್ಲಿ, ಒಮ್ಮೆ ಕಂಪ್ಲೈನ್ಸ್ ಹೋಗಿರ್ತದೆ, ನಿಮ್ಗೆ
ಮೊನ್ನೆ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದ ದಿವಸ ನೀವು ಬೇಲ್ ಬೇಕು, ಅವ್ರಿಗೆ ಅಪರ್ಚುನಿಟಿನೂ ಸಿಗಬಾರ್ದು, ಬಂದ ತಕ್ಷಣ ನಿಮ್ಗೆ ಬೇಲ್ ಬೇಕು.
ಆ ತರ ನಾವು ಒಂದು ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಿದ್ರಲ್ಲ.
ಅಲ್ಲ, ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ರಿ. See, the fact is, the bail petition, anticipatory bail petition, was rejected on then 30th August. You obtained the certified copy. In fact, copy ready on 5/9. You received it on 29. There was no urgency for you. You are required to appear on 6/9.
ಅಲ್ಲ, ಕಾಪಿ ಡೆಲಿವರ್ಡ್ ಆನ್ ಬರ್ದೇ ಇಲ್ಲ ಇದು.
Sir, ಇದೆ ನೋಡ್ರಿ, ಕಾಪಿ applicant told to appear when you are delivered.
ಬರ್ದೇ ಇಲ್ಲ ಆಫೀಸ್ ಅವರು. ಸರ್ 6/9 ತಗೊಂಡು ನಾವು ಫೈಲ್ ಮಾಡಿದ್ವಿ, 21 ಬಿಫೋರ್ ವೆಕೇಶನ್ ಅಂತ ತೆಗೆದಿದ್ದಾರೆ. ಏನಾಗಿತ್ತು ಸರ್, ಲಾಸ್ಟ್ 1 week ಬರೀ 439 ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ತಗೊಂಡಿದ್ವಿ. Of prior to Dasra vacation, I am only.
Sir, 21ಕ್ಕೆ ಫೈಲ್ ಮಾಡಿದಿರಿ ನೀವು ಕಾಪಿ ಇಮಿಡಿಯೇಟ್ಲಿ ಇಕ್ಕಿದ 5ನೇ ತಾರೀಕು ಅಥವಾ 6ನೇ ತಾರೀಕು ತಗೊಂಡಿದ್ರು ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಇಟ್ ಆನ್ 21/9 ಅಲ್ಲಿ 15 ದಿನ ಡಿಲೇ ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಕೋರ್ಟಿಗೆ ಬಂದ ತಕ್ಷಣ ಇನ್ಸ್ಟಂಟ್ಲಿ ಬೇಲ್ ಬೇಕು
ಅದೇನಾಗಿದೆ ಸರ್ ಅವ್ರ ಆಫೆನ್ಸ್ ಅಲ್ಲಿ this honorable
we are not concerned about other I am concerned about your urgency only
because it has a bearing. I am only submitting my
our offense ನಿಮ್ ಬೇಲ್ ಪಿಟಿಷನ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು ನೀವೇನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ವೆರಿ ನೆಕ್ಸ್ಟ್ 2 ದಿನ ಆಯ್ತು ವಕೀಲ್ ನಂಗೆ ಏನ್ ಲೋಕಲ್ ಎಂಗೇಜ್ ಮಾಡಿ ಡ್ರಾಫ್ಟ್ ಮಾಡಕ್ಕೆ 1 ದಿನ ಬೇಕು ಐ ಡು ಕನ್ಸಿಡರ್ ಇಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ರೆಡಿ ಆಗಿದೆ ಅದಕ್ಕಿಂತ ಮುಂಚಿನ ಡ್ರಾಫ್ಟ್ ನಿಮ್ದು ರೆಡಿ ಆಗಿರ್ತದೆ 1 ವೀಕ್ ನಿಮ್ಗೆ ಟೈಮ್ ಸಿಕ್ಕಿದೆ ಯು ಹ್ಯಾವ್ ಡಿಸೈಡೆಡ್ ಟು ಕಮ್ ಟು ದಿ ಹೈಕೋರ್ಟ್ so you'll not keep my mom you definitely prepare the petition and only remedy only thing is the moment you receive certificate you attach it file it ಆದ್ರೆ ಅದನ್ನ ಮಾಡಕ್ಕೆ 15 ದಿನ ಬೇಕಾದ ನಿಮಗೆ
hectic ಅಲ್ಲ ಅಂದ್ರೆ license because arms act is involved your lordship may kindly give me 1.5 minutes ನಾನೇನು
ಇದನ್ನ ಅರ್ಧ 15 ನಿಮಿಷ ಇದನ್ನ ಹೇಳಾದ್ರಿ 1.5 ನಿಮಿಷ ನಿಮ್ಗೆ ಇನ್ನ ಬಂದೇ ಇಲ್ಲ
ಅಲ್ಲ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ page 53 these are licensed revolver. They have in fact my lord fired on me and I have suffered injuries. Both 53 is in respect of pistol license which E1 possesses, petitioner 1 possesses, and 56 is revolver license which petition number 2 my lord possesses. And the hospital records are at page 59. The lordship will kindly come to page 59. I was inpatient, my lord, from 22/7/2022 to 25/7/2022. History of alleged assault. Thereafter, my lord, I was shifted to Vaidehi Hospital from 27th July to 30th July. That is as far as petition number 1. For reading of my lord entire complaint, which is at page 15, filed by the wife of accused number 1 in that case. No injury sustained by anyone. In fact, they admit on page 17 page 17, my lord, they admit that is part of the complaint. Original complaint is at page 13 and type copy is from page 15. Page 17, they admit the injury that has been caused to the present petitioner. ನನ್ನ ಗಂಡ ಹಾಗೂ ಭಾವನವರ ಮೇಲೆ ಮೇಲ್ಕಂಡ ವ್ಯಕ್ತಿಗಳು ಹಾಗೂ ಇತರರು ಸೇರಿ ಹಲ್ಲೆ ನಡೆಸುವಾಗ ಆ ಸಮಯದಲ್ಲಿ ನವೀನ್ ದಟ್ ಇಸ್ E3 ಕಬ್ಬಿಣದ ರಾಡ್ನಿಂದ ಬೀಸಿದ ರಭಸಕ್ಕೆ ಜನಾರ್ದನ್ ದಟ್ ಇಸ್ petition number 1 before the lordship ಜನಾರ್ದನ್ ಎಲಿಯಸ್ ಜಾನಿಗೆ ಏಟಿಯು ಬಿದ್ದಿರುತ್ತದೆ. ಹಲ್ಲೆ ನಡೆದ ಸಮಯದಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿಯೇ ಇದ್ದ ಗಣೇಶ್ ಬಿನ್ ಸೋ ಅಂಡ್ ಸೋ, ಗೋಪಾಲ್ ಬಿನ್ ಸೋ ಅಂಡ್ ಸೋ ಹಾಗೂ ಇತರರು ಜಗಳ ಬಿಡಿಸಿ ನಂತರ ಗಂಡ ಹಾಗೂ ಭಾವನ ಚಿಕಿತ್ಸೆಗಾಗಿ ಕಳಿಸಿರುತ್ತಾರೆ.
Correct, sir. Why the gun license is given to you?
For protection.
To fire?
Oh my lord. It was not. That is now kindly, but now that your lordship has asked a pertinent question, kindly come to page 50. This is the complaint filed by me against the other side. Page 50. Robbery sub-inspector so and so in the Janardhan P. That is the petition number 1 before your lordship. ವಿಷಯ ನನ್ನ ಮೇಲೆ ಮಾರಕಾಸ್ತ್ರಗಳಿಂದ ಹಲ್ಲೆ ಮಾಡುವ ಬಗ್ಗೆ. ಸರ್, ಈ ಮೇಲೆ ವಿಳಾಸ ವಾಸವಾಗಿದ್ದು ದಿನಾಂಕ 22/7/2023 ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಗ್ರಾಮ ಆಫೀಸ್ ಹತ್ತಿರ ಇರುವ ನಮ್ಮ ಜಮೀನಿನ ಕೆಲಸ ಮಾಡುತ್ತಿರುವಾಗ 8 ಜನ 4 ಬೈಕ್ ನಲ್ಲಿ ಬಂದರು. ರಾಜೇಶ್ ಕೆ ಸೋ ಅಂಡ್ ಸೋ ಸುನೀಲ್, that is the accused number 2. ನಮ್ಮ ಜಮೀನ್ ನಾನು ಕೆಲಸ ನಿಲ್ಲಿಸುವುದಿಲ್ಲ ಎಂದಾಗ ಅವರುಗಳು ಮಾರಕಾಸ್ತ್ರಗಳಿಂದ ಏಕಾಏಕಿ ನನ್ನ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿರ್ತಾರೆ. ರಾಜೇಶ್ ಕೆ ಬಂದು ಮಾರಕಾಸ್ತ್ರಗಳಿಗೆ ತಲೆಗೆ ಹೊಡೆದರು. ನಾನ್ ಆಗ ಜುಮ್ಮೆಂದು ಸ್ಥಳದಲ್ಲಿ ಕುಸಿದು ಬಿದ್ದೆನು. ಆಗ ನನ್ನನ್ನು ರಕ್ಷಿಸಲು ಬಂದ ಚೇತನ್ ಅನ್ನು ಸುನೀಲ್ ತಂದಿದ್ದ 1 ಅಡಿಯ ಡ್ರ್ಯಾಗರ್ ಅನ್ನು ಚೇತನ್ಗೆ ತೋರಿಸಿ ಹೆದರಿಸಿ ಓಡಿಸಿರುತ್ತಾರೆ. ಆಗ ಡ್ರ್ಯಾಗರ್ ನಿಂದ ನನ್ನ ಕುತ್ತಿಗೆಗೆ ಇಟ್ಟು ಹಲ್ಲೆ ಮಾಡಲು ಯತ್ನಿಸಿದನು. ಆಗ ನನ್ನ ಡ್ರೈವರ್ ಆದ ನವೀನ್ ಮೇಲೆಯೂ ನಾರಾಯಣ್ ಗೌಡ ತಂದಿದ್ದ ಡ್ರ್ಯಾಗರ್ ನಿಂದ ಹಲ್ಲೆಗೆ ಮುಂದಾದಾಗ ಅವನ ಬಳಿ ಇದ್ದ ಲೈಸೆನ್ಸ್ ನ ಬಂದೂಕಿನಿಂದ ಆತ್ಮರಕ್ಷಣೆಗೆ ಗಾಡಿಯಲ್ಲಿ 2 ಬಾರಿ ಗುಂಡು ಹಾರಿಸಿದ. ಅದನ್ನು ಸಹ
this is the issue. If you are fired in the air, how did it hit the other side?
No injuries at all. As far as my lord, the complainant's husband or the other accused, there is absolutely no injury. I have suffered injury. In fact, this complaint is given.
Yes, ಏನು ಹೇಳ್ತೀರಾ? ಅವ್ರು ಯಾರು ಇಂಜುರಿನ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಂಜುರಿನ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಮುಂದೆ ಬರೆದಿದ್ದೀವಿ.
ನೀವು ಬೇಕಾದ ಬರ್ಕೋತೀರಿ ಸ್ವಾಮಿ, ಅವ್ನು ಕೇಳ್ತೀರ. ನೀವೇ ಹೇಳೋದಿದ್ರೆ ಮತ್ತೆ ಅವ್ರ ಎದಕ್ಕೆ ಇರ್ಬೇಕು?
ಕ್ಲಾರಿಫೈ ಮಾಡಿ.
ನೀವು ಕ್ಲಾರಿಫೈ ಅಲ್ಲ, ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕು ಅದನ್ನ. The complaint was there is allegation that her husband is injured in gunfiring, and you are arguing that there is no injury. ಗುಂಡು ನನ್ನ ಗಂಡನ ಕಾಲಿಗೆ ತಾಗಿ ಅಂತ ಹೇಳಿದ allegation.
ಇಲ್ಲ, ಹಂಗಿದೆ. But that is the reason, my lord, it is an afterthought. That is the reason I took your lordship to the FIR.
Sir, one thing ತಿಳ್ಕೊಳ್ಳಿ, ಒಂದು ಕಂಪ್ಲೇಂಟ್ earlier ಬಂತು, ಒಂದು ಕಂಪ್ಲೇಂಟ್ later ಬಂತು. That cannot be presumed that one to counterblast. A person who attacks may go to police station first. That itself is not a ground to decide that second complaint is a concocted. No, that is required to be decided during the course of the trial as to who is the aggressor. If it is case and counter case.
My instructions are there. In fact,
they are in writing. They are putting it. Put your copy, then we will hear it in due course. If you are involved in other offences earlier also, then you will not question of interim bail doesn't arise.
I'm not disputing or subject to verification. My only request is, my lord, the offence has taken.
If you are involved in other crimes earlier, question of interim bail is ruled out. Take it granted. Interim bail is ruled out. We cannot.
In fact, Lord, the Honorable Supreme Court has held, and even this Honorable Court has held, that merely because he is an habitual offender, that will not disentitle him.
I am not disentitling you. I am hearing you on merits in due course. You are for interim bail. Yeah, therefore, you looking to your background, interim bail is to be considered. The entire bail petition is to be required to be considered, not interim bail. Only on the ground of marriage.
Is only in respect of petitioner.
That is not a marriage, is not a so much important. You can postpone the marriage. Marriage can be performed on any other day. Marriage can be performed on other day. That is not a crowd, sir. No. Looking to the fact that. Heard. ಸರ್ ನೀವೇನ್ ವಿಚಾರ ಮಾಡ್ತೀರಿ ಅವ್ರಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಕ್ ಅವಕಾಶ ಕೊಡ್ತಾ ಇಲ್ಲ ಅರ್ಜೆಂಟ್ ಅಂತೀರಿ ಅವ್ರು ಹೇಳಿದ ತಕ್ಷಣ ನಮ್ ಕಾಪಿ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಒಂದು ಎರಡೂ ನೀವೇ ಮಾತಾಡಿದ್ರಿ ಹೇಗೆ
or the present senior counsel has been made that routine bail for routine bail they will not be heard.
I will not hear you. I'll ask him to produce the records. Because they need not be heard me, that is not a mandatory thing. If I'm sorry. Oh, sorry. The learned counsel on I number 1 for interim bail. The learned counsel for appellant petitioner submits that the interim bail is restricted to petitioner number 1 alone and the provisions of ಕೊಡ್ತೀನಿ ಅಕ್ಕಿಲ್ಲ ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ ತಿರುಮಲ ಶೆಟ್ಟಿ ಪೊಲೀಸ್ ಠಾಣೆ ಮುಕದ್ದಮೆ 9913 187 17 75 18 29 of 19 30 of 20.
Yes, that is the outline is namdu anta
sir ನೋಡ್ಕೊಳ್ಳಿ they are putting it in writing. A1 is involved ಅಂತ ಹೇಳಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Submits that interim bail is restricted to petition number 1 alone and the provisions of
Arms Act are not applicable since Arms Act are not applicable since they had licensed gun and pistol. However, the learned counsel for the learned HCGP submit that the accused number 1 himself is involved in 6 to 7 matters from 2013 to 2020, including the offense under section 384 IPC. Looking to the allegation, the learned counsel for petitioner disputes this aspect, but however, the learned HCGP submit that it is the specific written instructions issued to him by the investigating officer. Looking to these facts and circumstances, only on the ground of considering the gravity of the offense, only on the ground of marriage of the petitioner is being said, petitioner number 1 is scheduled on tomorrow. The interim bail cannot be considered, and accordingly, I1 stands dismissed. Oh, ಯಾವಾಗ ಹೇಳ್ತೀರಾ Wednesday. Wednesday. Business to follow 5 purposes. Both appeals dismissed. Both appeals dismissed.
ಬಂದಿದ್ರು ಬರೀ ಬೆಂಕಿ
ಇಲ್ಲ